of agency that we can.
It's it's a disclosure of agency relationships. So CIS form, it's first document you give to anyone you intend to do business with. Its purpose is it's a disclosure of agency relationships. You give it to people before you talk about their finances.
Yes.
You give it to people at open houses.
Yes.
You give it to people before you write a contract for them.
Yes.
It's the first thing.
Well, it's all of them, isn't it?
Yeah. Yep.
Now, but the thing is, you get exam questions where what I'm getting at here is you get exam question where answer options could be, all of them could be correct, just like I'm dictating to you right now. But the key to it is you need to figure out which one of them happens first. Because the question I asked you was, you know, it's the first thing that you give to anyone you do business with, right? That's how I keep teaching it to you anyway. First thing. That should be in your head. I'm trying to groom you to remember it's the first thing. So now if you get an answer options, multiple choice, and they give you all these answer options and they're all correct, but you could only choose one of them, which would be the right answer. You got to ask yourself, well, which one happens first? You talk to them, right? So that's why that one would be correct, because you talk to people first, okay? That's just trying to give you guys like little examples without even telling you that they're examples. What do we call the agent who's owed a commission because they did the most work leading up to the sale?
Procuring cause.
They have procured the sale, so they are the procuring cause of it. And when the parties are in agreement on all the terms of the contract,
Meeting in the mind.
we've come to a meeting of the minds. And what do we call giving anything of value to somebody who does not have a license?
Kickback.
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 When do licensees really earn their commission?
After the title
5
has-
days.
When do we earn our commission?
When the sale closes, and when do we earn it or when are we given it?
I said, when do we earn it? I mean,
When we make a sale.
when we produced a ready, willing, and able buyer.
Yes.
Okay. As an independent contractor, what are you responsible for?
Oh, our own insurance. We need to.
E&O.
Paying your own
Yeah.
taxes, insurance, tools, maintaining your own license, etc. What's the difference between a client and a customer?
A client is signed to us and a customer, you know, like assigned through an agency agreement or no? No.
The client, we had fiduciary responsibilities to,
Okay.
and the customer,
We owe honesty and
And
good intentions.
so we got to treat them fairly and honestly. So
Yeah.
a
Okay.
customer we need to only treat fairly and honestly, and a client, somebody we owe fiduciary duties to. These are the legal responsibilities that we owe to.
Got it.
All right. And what's the
There you
difference
go.
between a general agent and a special agent?
General agent has power of attorney, like a property manager, and a special agent is pretty much everybody else.
That's the way that I explained it when I started teaching it, but that's not the main difference I want you to focus on learning. The main difference I want you to focus on learning is that a general agent can legally bind, they can
Yeah, power
legally
of attorney.
bind their client to a contract, whereas a special agent cannot.
Yeah, like they have power of attorney, isn't that
Yes.
like the ability to legally bind?
Yeah, but I don't want you just to remember power of attorney. I want you to know what, you know, what it does and what the main reason is behind it. What the difference is with that power of attorney versus one who doesn't. One
Gotcha.
can legally bind them to a contract and one cannot. Because on exams, they're not going to mention power of attorney. You know, they're going to be talking about special agent can work in one capacity only, and a general agent can legally bind their clients to the contract within the scope of their authority. That's the kind of retarded wording that they use, okay? So I'm
Yeah,
trying to groom you guys to that kind of a wording instead of, power of attorney and, linking it to documents and stuff, because you're never going to hear those words. And then you're going to be a little bit lost when you don't hear them,
got it. Thanks.
Who works as a general agent?
Usually property manager.
Property managers. And if you're guilty of 3 or more violations, what could the real estate commission do to your license?
Revoke it.
Revoke it for life. What's the minimum and maximum fines they could give you per offense for a violation of licensing law, the real estate commission?
Oh, sorry, can you repeat the question?
What's the minimum and maximum fines that the real estate commission can issue for a violation of licensing law?
10,000 to a million.
250. 250 to a million?
to $50,000.
$250 to a maximum of $50,000 per offense.
Mm.
So who charges, is that for a lawsuit? What's the thing that's $1 million, if we,
Well, this is for anything for violation of real estate licensing law, what the real estate commission can do as far as issuing you fines, monetary fines. As far as $1 million fine and 10 years in prison, that would be the Sherman Antitrust Act.
All right.
so that's
sorry.
the law.
Yeah, Sherman Antitrust Act violation. And then what's the violation for, well, how about this? I'll get to the violation in a second. Let me first tell you about the law. What is the law that requires full disclosure and truth in advertising when talking about financing in an ad? When certain triggering
Reg
terms are used.
Z, Regulation Z.
Regulation Z. And what are the penalties
There you
for violating an administrative order of a Regulation Z?
Fined or
Yeah, what is that fine?
is it the name of the fine?
No,
or
what's the amount? What's the amount?
the 250 to 250,000? No.
For a violation of Regulation Z, if you don't, if you talk about financing in an advertisement, this isn't just about real estate. This is for any industry. If you talk about financing in an ad and you don't fully disclose all the terms, the fines are $10,000 per day that the ad is in the public domain.
Okay.
Okay. So, and that's when certain triggering terms are used. What would be the 4 triggering terms that you would see in an ad that would trigger the full disclosure requirement?
APR.
No, that would be one of the things that you'd have to fully disclose.
The interest rate,
The interest rate, which is different than the APR.
the
One.
down payment,
Interest rate, if you mention in an ad, the interest rate,
the down payment,
a down payment amount,
The term, the term of the, and,
Is it
um,
commission? No.
or monthly payment, the payment amount.
right. Mhm.
If you mention any of those 4 items, that would trigger the full disclosure requirement. So now what would you have to fully disclose? Somebody already said APR, so let's lay that one on the table. That's one of the 3. APR,
Well,
if any of those
Sorry.
triggering terms, those 4 triggering terms that we just used are used in an ad,
APR,
full disclosure is required. So you have to disclose the APR and what else? Two more things. And a statement
APR. The statement is for qualified people, right?
to those who qualify or to
To
a
those who
qualified
qualify.
buyer, the APR, the down payment, and the term.
And the term.
Mhm. All right. In property ads, in the individual real estate ads for 123 Main Street, it's up for sale. What do I have to have in that advertisement just for that property in each individual property ad?
The municipal location.
The municipal location of the property where it's located, correct. Can I ever use the term in the vicinity of in an advertisement?
Yes, if it's.
Yes, I
Yes, but
can.
you have to,
Yes, I can. Just not in place of the
municipality.
municipal location. How do we help people value their properties? Do we offer them appraisals?
No, but we
No,
can do
we
a
tell them.
CMA.
We offer them a free CMA perhaps, but not an appraisal. Or we could offer them something else, another type of property valuation. What do we call that? Another one that we do. Got a little more math involved, but we usually do it for banks. BPO, BPO, broker's price opinion.
Hmm,
CMA or a BPO, broker's price opinion. It's similar to a CMA, except it's got more math in it, you know. Can we ever put a sold sign rider on a property?
hmm.
Yes.
Yes, yes, we can. As long as it's actually been sold and title's been transferred. What is title?
Ownership.
Ownership.
A document that I'm sorry, not document, a word that means ownership. Is there any document in real estate called title?
No,
So how do we transfer title?
Deed.
By some sort of
Deed.
deed of conveyance. Is a deed proof of title?
I think so. No,
Mhm.
that title insurance is proof of title, right?
Title insurance policy is one of the 4 evidences of title. Title insurance policy. Keep coming.
I should know this. Oh my God.
So what are the 4 evidences of title or the 4 proofs of ownership? We have a title insurance policy.
The title insurance policy, the deed, the tax, is it the taxes that you pay on the land? Or
What do we call it when we search the public records? Or we have somebody search the public records and then an attorney looks at that.
Oh, the starts with an A. It's about the chain of title, right? It's followed by attorney. It's
Abstract.
Abstract title
There you
with
go.
the attorney's
Yeah.
opinion. Abstract of title, attorney's opinion. What did you say?
Certificate of title.
A certificate of title, title insurance policy, and one more that's not used in New Jersey, but it's still a proof of ownership.
it's torrent.
The Torrens certificate.
There you go.
Correct. So those are all evidences of title, the 4 evidences of title. And what do we call it when you could search the public record and link one owner to the next?
Chain of title?
Search.
Chain of title. It's a chain of title. And what do we call it when you cannot link one owner to the next because the documents had not been recorded in the public record?
Cloud on the title? something like that?
Well, it
Or
does
no?
create a cloud in the title, but what do we actually call when you can't link one owner to the next by researching the public records?
What's first letter? That's a hint.
Well, it could be worded 2 ways. You could call it a break in the chain or a gap in the chain of title. And how do we cure that? How do we fix that problem? It's all right. I mentioned it one time. I mean, that's like in the last chapter, but we went over it. A quit claim deed or a suit to quiet title.
Mhm.
All right, don't worry about that. We skipped way ahead for that stuff. I mean, it's amazing that you guys know as much as you do already with that, not to toot my own horn or nothing, but. All right. Can an unlicensed person put a real estate sign on a property?
No.
Yes. Yes.
they can.
Oh, okay, first up by own.
Remember, keep that picture in your mind of the commercial property.
Construction
They
workers.
got the construction crews building those larger signs on the properties, right? Don't just have the picture, the image of the lady in the dress, her business suit, pulling the real estate sign out of her Mercedes Benz and putting it on the front lawn. Okay. That's the imagery that a lot of people get. So they, or at least the image that I picture that people are thinking, well, why they think that only somebody with a real estate license can put it on the front lawn when anybody can. You could have your assistant go and put a sign on the property for you if you like. They could also make copies of company keys for company listings, right?
Mhm.
Yep, they can. Can they deliver documents without a license?
Yes,
Sure can. They just can't explain them though, right?
correct.
All right. If you offer a real rebate in an advertisement, what else you need to put in that ad?
Consult a tax professional.
You must consult with a tax professional with regards of receiving that rebate, right? And if you want to advertise that you offer low commission rates, you say, we take listings for 4%. What do you need to put in the ad?
In New Jersey, all taxes or commissions are negotiable.
Correct. And if your name is in an ad, you have to use your real first name and your real last name, but tell me something else about it.
You have to put the broker, the
Yeah,
brokerage, the broker.
The broker,
bigger and bolder.
not the
bigger and
broker,
bolder.
Yeah,
the
the brokerage.
brokerage's name has to be there. Now, is there
More
something else I
prominently
need to
than
know
our
Their
about that?
phone number, their phone number.
Well, about the name, tell me something about the name. Yes, the phone number has
It
to
needs to be
there.
more prominent.
It has to be
it
in
needs to be
larger
more prominent
type
than
and more
ours.
prominently displayed than the agent's name. Correct. This was another issue that we were going over in the instructor seminar the other day. Teams. Oh my God. You want to talk about every instructor starting to yell about that because agents come to these classes and they got a million questions and they're so misinformed by the people at these real estate offices. When they talk about teams, some of these teams, they come up with their own names for the team as if it's a different entity than the brokerage. You know, the general public has to be aware who is the brokerage in this scenario. And it starts to get confusing when a team even comes up with their own logo, you know. So the brokerage's name has to always be more prominently displayed and in larger type than a team or an individual's name, because the public has to know who the brokerage is, who exactly are they dealing with. And when it comes to a team, let's say that you join a real estate team within a brokerage. It's like an office within an office. However, ultimately, who can you get paid by? Who's the only person that can pay you?
Broker.
The broker, not the team leader, who may not even have a broker's license or a broker salesperson's license for that matter.
Right.
You could only get paid by your broker. Okay, so things are starting to get a little confusing with all these teams. I understand teams they could be a good thing if done properly, you know, but they're doing a lot of things wrong. Like one thing wrong is, say that you're on a real estate team and you're the listing agent on it. You're the one that's been in communication with this with the owner. The team leader never met them, but the team leader wants all the listings put in their name, so that they could get the credit for all the listings and they can advertise themselves as the superstar. Okay, that they're the one that got a million listings when it's all bullshit, right? They try to do that for their advertising and stuff, but they're not allowed to do that. They're not the one that's working with that client. You are. Your name needs to be on that listing. Okay. Just trying to make a point here for you guys. That's not going to be on exam, but it's becoming a big issue, and investigators are going to be cracking down quite a bit on that stuff, because every single instructor in the state was screaming about it. All right. What needs to be the cover page of any contract prepared by licensees?
The CIF.
Now, CIS is the first document you give to anybody way before you.
26.
What?
26.
Opinion
26.
26
Opinion
notice.
26.
Opinion 26 notice. What's that?
right to hire a lawyer.
Your right to hire a lawyer and
There you
have a
go.
lawyer review that contract, make any changes to it if you want to, or cancel the contract, right? So that needs to be the cover page of any contract. Does it need to be the cover page of lease contracts that we prepared?
Yeah.
Yes. And let me just reiterate, how did I ask it before? What needs to be the cover page of any contract prepared by licensees? Okay?
Right.
So what kind of properties can licensees prepare contracts for?
Real estate, residential leases and all that.
Only
No.
residential leases?
No, I said residential,
Just residential.
for
Okay, I
rent,
gotcha. So
for rent.
residential leases and purchase contracts only. For commercial real estate, they need to be prepared by attorneys. So there's already an attorney involved. This is why we need to use the opinion 26 needs to be the cover page of the residential contracts that we prepare, because we don't prepare the contracts for commercial property. Attorneys are already involved. So we don't need an opinion 26 notice sitting on top of it saying you have the right to hire an attorney, because an attorney is the one that prepared that contract. We didn't, right? The reason behind this is because, look, years ago in New Jersey, well, let's first talk about how real estate works. The way real estate works in New Jersey versus how it works in many other states. In New Jersey, we ask people at the beginning of the transaction, do you have a real estate attorney? Who are you going to be using as your attorney on the transaction? You know, most states, they don't use attorneys in real estate transactions unless there's a problem. Now, the southern part of New Jersey works that way too, because let's face it, it's not really New Jersey anyway. It's like an annex of Pennsylvania, right? The southern part, they even follow the Pennsylvania sports teams, right? it's a different it's a different state altogether, the southern Jersey, right? So they actually do business like they do in other states. They don't do it. They don't use attorneys unless there's a problem in the real estate transaction.
Is that true?
Yeah. The real estate agent actually takes a more active role in the real estate business. So what happens is, see, the thing is, the reason why that happens is because the north central part of Jersey, we actually do things, for lack of a better term, ass backwards. Okay. What do I mean by that? I mean, when we are presenting an offer to a seller, when we're putting together the offer, we're not putting together an offer. We're putting together the actual contract. And once that contract is signed, we can't make modifications to it. Otherwise, we're practicing law without a license. So then we need an attorney to go in there and make modifications after. All right. Whereas the southern part of New Jersey and a lot of other states, they make offers like we do in commercial real estate. What they do is they prepare a non-binding intent to purchase or lease, or they could call it a term sheet that they put together. It lays out all the terms of the offer, and the parties both go back and forth on this non-legally binding term sheet. And when they agree on all the terms that are to be added into the contract, the one time that we put together, it's going to have all the agreed on terms, so nothing needs to be modified later. So ergo, we don't need an attorney in the transaction. Okay, but don't ever tell anybody you don't need an attorney.
Right.
Because what happened years ago was an agent in the southern part of New Jersey said, we're doing a lot of stuff that the other agents throughout the rest of the state aren't. So we're taking a more active role. Boom, light bulb pops up. I got an idea. In my advertisements, I'm going to start advertising that to people. When you hire me as your real estate agent, I take a more active role in the real estate transaction. I could save you the cost incurred by hiring a lawyer. Uh-oh. What do you think is going to happen when that advertisement lands in a lawyer's mailbox? You don't need to hire a lawyer because I could save you the cost of hiring a lawyer because I take a more active role as a real estate agent. You don't need a lawyer. Yep. Well, eventually happened. And an attorney ended up writing up a law, going to one of his political friends or contacts, giving them the law that they wrote up already, because let's face it, attorneys usually write the laws, right? They write even when a politician proposes it, an attorney actually writes it up. So this attorney actually wrote up the law, how they proposed it, because they said real estate agents are doing some potential bad stuff. They're not informing people of what their rights are. People have the right to hire an attorney, and agents are not informing people of their rights. Instead, they're telling them you don't need to hire an attorney. So they're subverting them of their rights, right? It's kind of like a twisted word game that they're playing, isn't it? So what happened was they proposed a law. And then, of course, politicians are more than happy to pass a law and say, hey, I'm the hero. I'm protecting people's rights. Yeah, it sounds good on paper, right? But in reality, what are they really doing now? You know, well, they're adding more paperwork for us, okay? Sure, people know that they could use an attorney. However, now we have an additional document, an additional disclosure where we have to disclose to people that on the cover page of any contract that we prepare, instead of us telling people you don't need to hire an attorney, we have to tell them you have the right to hire an attorney. And how do we do that? Through the Opinion 26 notice, making it sitting on the cover of the contract that's prepared by us. So before they ever see the contract, they see a piece of paper that says, stop right here. You have the right to hire an attorney. Let me open one of those up.
I think, can I say something?
Yes, you can.
My mom is licensed in Southern New Jersey, and so are a few of my friends. They all use attorney review, and they use the 3-day. They do. So I'm not certain.
Yeah, well,
Why you're saying nobody? Like, I know you didn't say nobody, but like,
Yeah.
I think they do here. They definitely do.
well, where in Southern Jersey are you
I'm
too?
in
You know,
Ocean
look,
City, New
it-
Jersey.
it used to be kind of more common. Now, when they're dealing with agents from the north central part of Jersey, they could be guaranteed that the other side of the transaction has an
Has
attorney.
one.
So
Right.
now they're kind of like, you know what,
Exactly.
let's not try to beat the system here, because if you don't have an attorney and they do, then you're going to be disadvantaged, you know?
Yeah.
But in the past, it was more common where they would never have an attorney on that side of the transaction. They tell people you don't need an attorney, you know, because
So when you give them the Opinion 26, do you give them 3 names, or do they always bring their own? You never recommend.
well, I never recommend anybody, but I have a list of vendors that our clients have used in the past.
Right.
I put on that list. This list is for convenience purposes only. We never recommend anybody. Past performance is not an indicator of future performance. You know, you're free to hire and use anybody you like. But then I tell people, I have a coaching conversation with you as a buyer or seller. I say, listen, do you have a lawyer that you're going to use already, or do you want us? I got a list of lawyers that our clients have used in the past. They've been happy with them. They don't charge them outrageous amounts of money. And if you you use one of our lawyers and you have any problems with it, let me know. I'll remove them from the list. You know, I'm looking for only good people. So when I come across somebody who's done good in the past, I just add them to the list. But you know, I don't personally recommend anybody.
Right.
Just list for your convenience. You can hire anybody you want. I just
Got it.
advise you that if you do hire a lawyer, make sure they specialize in real estate. You know,
Yeah.
otherwise it's like going to a heart surgeon to do brain surgery. Okay.
Right.
Even though they learned about the anatomy in school, you know, that they don't specialize in the other part. Okay. So real estate's the same way. Every attorney took a real estate 101 class. But if you don't want to hire a litigation attorney to do a real estate transaction, because it's a different animal altogether. Litigation is a fancy word for argument. They like to argue and they need to always win, right? You don't need that attitude from an attorney when going in a real estate transaction, because their objective is to make sure that their client gets that property, but you want to get just the most favorable mutual terms to both parties in the wording in the contract. Okay. And that's that attorney's job, is to get the most favorable terms for your client, but not at the detriment of them losing the deal. you know, so there's some compromise that's involved in that. And litigation attorneys don't like compromise, you know, they want to win all the time, you know? And I've had people hire litigation attorneys and they ended up killing the transaction because they didn't get everything exactly their way. And when I found out about it, because I'm a more proactive agent, I like to communicate and make sure that everybody's still communicating in that transaction. And I didn't see any attorney review letters going back anymore. I'm like, are we out of attorney review? I haven't seen any letters. What's the status here? You know, the attorney said, oh, well, they didn't want the wording or whatever I want. I killed the deal. I'm like, you did what? I said, is your client aware of that? Because they were just calling me, asking me what's going on. You know, I was like, I suggested you get back on the phone. You better piece this deal back together. And I immediately hung up. I contacted the buyer and I was like, remember when I told you that when you hire an attorney, make sure they specialize in real estate, but you insisted on going in with this other guy? Well, guess what? He killed the deal. Did you still want the house? Well, then I suggested you get on the phone with him and tell him to piece that deal back together. Needless to say, that attorney was pissed at me for the rest of the transaction, but I don't give a crap because I'm not working for him. You know, I'm working for that buyer, you know. But this is what happens. Sometimes you get attorneys. Listen, there's a lot of incompetent attorneys out there too. You know, you got to keep an eye on them, make sure that they're doing their job and doing it right too. You just don't get involved in there. You just make sure they keep communicating between the parties and they get in, they get out of attorney review. You're
So
not
are you copied? Are you allowed to be copied on their?
I always ask them. I always ask them. As a matter of fact, I got a cover page that I put together that I wrote up. I put a cover page together that says there's 2 cover pages that I use anytime I get a contract that's signed by everybody. It's fully executed. When we want to start attorney review, when I send over the contracts to both sides attorneys, I have a cover page that has the contact information of all the parties. So like the left side is the seller side, the right side's the buyer side, and in the center of the page is the mortgage company that's going to be used by the buyer, okay? So I have all the mortgage company's information. On the left side, I got all the seller's attorney, the seller's information, and the seller's agent's information. On the right side, I have the buyer's attorney, the buyer's information, and the buyer's agent's information. So it's like a cover sheet with all the contacts, so they don't have to go searching who's who. So they got it all on one sheet. And then sitting on top of that is a page that I have. It's a fax cover sheet. Basically, it says, this is a new contract for your review to start attorney review. And I got a little bit of a write-up in there, but I say, please CC, please carbon copy both sides real estate agents on all about all correspondence between attorneys so that we're apprised of what's going on in the transaction. You know, and you know, that's basically it in a nutshell of what I say. And even with that, sometimes attorneys won't do it. And then I have to contact my client and I have to have them ask their attorney to do it because their attorney has to listen to them. They don't have to listen to me, even if I'm asking nicely. And it would help the transaction move smoothly. They should be doing it, but they don't because they're like, oh, I don't work for you. Okay, well, you're just a jackass attorney then, you know? I'm trying to help your client. We need to know what's going on. If you guys are making changes to the contract, if the agents aren't aware of it, how the hell are we going to do what it's
Exactly.
required? You know,
Right.
and how do we know when it's out of attorney review if you're not letting us know? You know, so our job is the manager of the transaction. Basically, we need to make sure those attorneys keep communicating. So when I don't just fax or email over a contract and wait to be contacted. I send it over to them and then I call their office to
Yeah.
confirm that they've received it. I sent over a new contract for you because if you don't, they'll be like, oh, the fax machine ran out of paper. Oh, we never got it. Oh, the email must have gotten caught in spam or we never got it. Or there'll be some kind of an excuse and it won't be started. Okay.
When does the 3-day review start? After it's fully executed, the next day or the day of?
You have 3 days to start attorney review. If you did not get it started within 3 business days
Okay.
from the time of the fully executed contract, and you give both the buyer and the seller or the tenant and the landlord their duplicate original, then you start counting time. of business days. 1, 2, 3. If you do not start attorney review within the 3 business days, then the contract becomes legally binding as it is. And neither party can make changes to it unless they both agree to those changes. Okay. Here, I'm opening up an opinion 26 notice right here, just to show you guys real quick on screen. This is the opinion 26 notice. I like to refer to it as a big fear-mongering document by attorneys, you know. Look, it says, by the way, I wrote this opinion 26 notice. It used to say this on as a standard. It doesn't anymore. Now it just says notice on it. This is why even in the book, they don't use the term opinion 26. They just refer to the word as notice. I have you guys write opinion 26 in the book. All right. But this is the actual form. Try Googling the word notice and see what comes back, you know, versus you Google opinion 26 notice, a very specific New Jersey form comes back, this one. All right. Now, it says the law requires real estate brokers to give you the following information before you sign this contract. It requires us to tell you that you must read it all before you sign. The purpose is to help you in the purchase or sale or lease, okay? It says, what's number 1 here? What is this number 1? What is all this in number 1? This is what a disclosure of agency relationships looks like. Where do we first disclose the agency relationships to people? How do we first disclose that to people?
When first time we talked to them.
On how?
Oh, the CIS.
On the CIS form, correct. So do you know that every contract and every disclosure and every form except for the lead paint addendum, we also disclose our agency relationships? It looks like this. It's a checkbox. As a real estate broker, I represent, and then you got to check off one of them. The seller, not the buyer not the seller, both the seller and the buyer, or neither. If you're not representing neither, how are you working?
Yeah, you're not.
Well, how are you working? In what capacity if you're not representing either party in the transaction?
A referral agent?
Transaction broker.
Okay.
Referral agents can't work with people. They can only send referrals. So
Right.
the title company does not represent either the seller nor the buyer. Let's continue reading this. It says, you will not get any legal advice unless you have your own lawyer. Ooh. Neither I nor anyone from the title company can give you legal advice to either the buyer or the seller. If you do not hire a lawyer, no one will represent you in legal matters now or at closing. Neither I nor the title company will represent you in those matters. The contract is the most important part of the transaction. It determines your rights, risks, and obligations. And signing is a very big step. A lawyer would better help your feeble minds understand it. You can see I'm ad-libbing here a little bit, but you're getting the gist of what this form is actually doing. It's kind of like a fear-mongering document saying you need a lawyer. I wonder who made it up. A lawyer, right? So, and then it goes on, it basically just goes on, keeps on telling you why you need a lawyer, all right? Only a lawyer could advise a buyer about what to do if a problem arises. Really? All right. Actually, where's the other one? There's another point here. A lawyer would review the contract, help you understand it, and negotiate its terms. The contract becomes final and binding unless your lawyer cancels it within the following 3 business days. If you do not have a lawyer, you cannot change or cancel the contract. What's that very next word? What's the very next word there? Unless. Oh, so then you can change or cancel the contract, right? Words matter. Unless the other party agrees. So it is still possible for it to happen when you don't have a lawyer. You see what I mean? It's a big fear-mongering contract that was put together by lawyers. The funny part is the lawyer who created this law and put this thing together, he is now the lawyer, the official lawyer for the New Jersey Association of Realtors. I guess keep your enemies closer kind of situation there, right? Anyway, you get the gist of that idea. I just wanted to show you that document. All right. You know what? Let's get started in We're doing too much review here right now. Let's get started. Let's go back to, we'll have a whole chapter on this stuff. That's contracts, chapter 11, that we'll hit that stuff up again. Let's do chapter 4. We already had an hour of review. That was good enough. All right, so chapter 4, page 63 for most. And let's go full screen of this. Ta-da. All right. So, fair housing. Remember, I told you that they're going to be changing, not this license renewal period, but the following one, the CE requirements that you're going to need. You're going to need to have 1 hour in fair housing, okay, as in classes for the CE to renew your licenses. Not for this licensing term, but the following one. So you guys don't have to worry about that right now. But you need to know this for exams anyway, to get your license to begin with. So at the end of this chapter, well, we're going to be learning about the state and federal fair housing laws and anti-discriminatory laws. We're going to learn about different types of discrimination, advertising rules, what can be deemed discriminatory terminology and stuff like that. All right. So we're going to go over that. We're going to be learning about different kinds of discrimination, because it's important to know about discrimination, because if you don't know if something's discriminatory, how could you avoid discriminating? All right. And as I told you guys the other day, it's easy to find yourself guilty of discrimination. It doesn't have to be your intent to discriminate against anybody. All somebody needs to prove is that a discriminatory act had occurred, and bam, you're guilty of discrimination. So let's try to avoid that altogether. So, equal opportunity in housing. Failure to comply with housing practice is not only grounds for loss of license, but also an unlawful act, and you could also get all kinds of fines and stuff. Now, why do we have all these equal housing opportunity laws in place to begin with? Not going to find the answers in the book. Why do you suppose we have the fair housing laws? Well, here, I put a slide together for it. To ensure everyone has equal rights to have a place to live, to own or rent, or to be able to own personal property. Everybody should have those rights. There's some basic rights. And violating them is a criminal act. So, let's start off with the Civil Rights Act of 1866. Let me ask you something. What happened back in the 1800s? Pertaining to equal rights and of all persons. From your own knowledge from junior high school and high school, what happened in the 1800s?
Some of us been out of junior high and high school for a very long time.
Well, in 1866, back then, who was president back then? Well, now we're asking, okay, now we're getting too far into it, right? Back then, how about Lincoln abolished
Abraham
slavery?
Lincoln?
Huh?
Sorry. No, I said Abraham Lincoln.
Yep, Abraham Lincoln abolished slavery back then, right? And then we had the passage of the 14th Amendment to the United States Constitution. Now, so I want you to remember that. Start thinking when you see the law, the old one that happened in the 1800s. What happened in the 1800s with civil rights? Okay, they passed the 14th Amendment of the Constitution. So let's read up on this a little bit. It says,
Monty, sit down.
It says the efforts of the federal government to guarantee equal housing opportunities to all U.S. citizens began with the passage of the Civil Rights Act of 1866. Just highlight the term Civil Rights Act of 1866. Just highlight that. And then keep your highlighters out. I'm going to read and I'm going to tell you to highlight this, highlight that. So okay, just highlight that title, Civil Rights Act of 1866. This law was an outgrowth of the 14th Amendment of the United States Constitution that prohibits any type of discrimination based on race and or color. Highlight race and color. It says all citizens of the United States shall have the same right in every state and territory as is enjoyed by white citizens thereof to inherit, purchase, lease, sell, hold, and convey, highlight, real and personal property. Now, because of this reference to white citizens, this law has been widely interpreted to prohibit discrimination based on race and or color. So this is why the exam questions are going to focus on that too. However, in 1987, see, they're still updating these laws. The Civil Rights Act of 1866 had an update to it. The Supreme Court broadened the definition of race, implying that it could also apply to ethnic or even in some cases religious groups. So highlight ethnic and religious groups. So what are the protected classes by the Civil Rights Act of 1866? Race, color, ethnicity, and religion. And what kind of property does this law deal with? You got to unmute yourself there, Kate. I see you talking. I don't know if you're talking to your dog or if you're talking to me.
No, I'm talking to you.
Real-
Personal and real.
Real and personal?
So there's only two kinds of property in this world, real property and personal. So it's all kinds of property, right? It applies to all property. The clothes on your back as well as a home to live in, right? Highlight, no exceptions are allowed to this federal law. It's the only law that has no exceptions to it. Now, even though we highlighted 4 protected classes of this one, I want you to underline the word race, because that's the one they're really going to be using on exams. Okay? So as we start learning about these different civil rights laws, anti-discriminatory laws, we're going to need to know what they cover, because we have multiple laws that kind of like overlap each other and they cover the same things, but for different reasons. So we need to know what the protected classes are and what they cover. So the Civil Rights Act of 1866 deals with all kinds of property. The protected class is race. At least that's the one we need to focus on for exams. Even though we know there's 4 protected classes, the exam is going to focus on race. All right, next, which by the way, I put together some handy dandy slides here for you to study too. I put all those things in one neat little place. All right. Types of property covered, real, residential, and commercial, including unimproved land and personal property like the clothes on your back and personal belongings. Protected classes, race, color, ethnicity, and religious groups, which are added in 87. And who enforces these laws? The federal laws, all the federal laws. HUD, that's the Department of Housing and Urban Development. And how long do you have to file a complaint? Even though we didn't get to that here in the book, I got it all here in this slide. You have 1 year to file a complaint. And HUD has administrative judges within that agency that specialize on only listening to discrimination cases. Now, so how long do you have to file a complaint? 1 year.
1 year.
Unless you want to make a federal case out of it. You ever hear somebody say that? Well, if you want to make a federal case out of it, well, check this out. If you want to make a federal case out of it, 2 years. So if you want to have it heard in federal court, you have 2 years to file it. Otherwise, it's 1 year. How long you got to file a complaint? 1 year, unless you want to make a federal case out of it. Yeah, that's the way I talk in my head when I'm saying these things. I say, you got 1 year, unless you want to make a federal case out of it, then it's 2, okay? So now we're going to go over the Federal Fair Housing Act of 1968, which is part of the Civil Rights Act of 1968. The Civil Rights Act of 1968 had a section in it pertaining to housing. That section, called Title 8 of the Civil Rights Act of 1968, pertains to fair housing laws. Okay, so now we have an understanding, because you're going to see Civil Rights Act of 1968, Federal Fair Housing Act of 1968. What the hell's the difference of it? And Title 8. What the hell's the difference? Well, I'm telling you the difference. Civil Rights Act of 1968 is the law. There's a portion of that law, Title 8 of the Civil Rights Act, the Section 8 of the Civil Rights Act of 1968 pertains to housing. We call that the Federal Fair Housing Act of 1968. Now, the types of property that are covered in this law, without us reading all over it yet, is residential property for sale or lease, including vacant land used for residential use. This one does not, it's not for all It's not for personal property. It doesn't cover commercial property. It only covers residential property. So the purpose of the Federal Fair Housing Act has a key word in it, housing. It covers residential. Housing is residential, right? So the protected classes are, it has a lot more protected classes. Race, color, religion, national origin, sex, people with disabilities, including AIDS, and familial status, that's having children under the age of 18, which also includes pregnant women. Alcoholics and persons in treatment are also considered a protected class. This is an issue that we were kind of talking about the other day when we had somebody from the New Jersey Civil Rights group in our meeting. It seems like they don't even know some of their own laws here, because the guy was bouncing around. People were asking him questions. Are alcoholics and persons in drug treatment programs considered protected classes? They're like, no, but yeah, but no, but yes, they are. So alcoholics and persons who are in drug treatment programs are considered a protected class. But if current drug abusers are not a protected class, only if they're in treatment programs, okay? So current drug abusers and people who pose a threat to the health and safety of others are not a protected class. Now, there's some exceptions to this Federal Fair Housing Act of 1968. Because there's exceptions to the law does not mean that does not give you the green light to discriminate, okay? There are reasons why they put exceptions in the law. It's not a green light to discriminate. And one thing you got to remember, when two laws cover the same topic, the more restrictive rule will always prevail. Let me repeat that. When two laws cover the same topic, the more restrictive rule you have to follow. So we got to always remember when it comes to race, you can never discriminate and there's never exceptions to it, because we fall back on the Civil Rights Act of 1866. Which, let me go back in the slideshow here. You go back to the Civil Rights Act of 1866, there are no exceptions to this federal law. When it comes to race, there are no exceptions to the law. Okay, so even though the Federal Fair Housing Act has exceptions to it, it does not mean you could discriminate on somebody because of their race, okay? So let's go over what this federal law does cover, though. Well, pretty much got it all buttoned up in this one slide, but let's go over it in the book now. So under the Federal Fair Housing Act of 1968, what to highlight, okay? On the second line, we're gonna highlight the Federal Fair Housing Act of 1968 is contained in Title 8 of the Civil Rights Act of 1968. So highlight that. Now, the law provides that it's unlawful to discriminate on the basis of, now let's highlight some of the protected classes: race, color, religion, or national origin when selling or leasing residential property. So what kind of property does this law pertain to? Only residential property,
Hello,
not commercial.
Victor?
Yes.
Hi, I missed the last one, said to highlight. Where was it?
Under the Federal Fair Housing Act of 1968, on the second line, we're highlighting the Federal Fair Housing Act of 1968 is contained in Title 8 of the Civil Rights Act of 1968. And then on the next line, we're going to highlight race, color, religion, and national origin. And then at the end of the line, we're going to highlight residential property because it deals with residential property. That's the type of property, and here's some of the protected classes. These are not all the protected classes, though, because as you can see on the slideshow, we got a couple more coming up, which would include people with disabilities, including AIDS, or including AIDS and coronavirus too. Okay, that's it. Those are all considered disabilities or illnesses or sicknesses, right? That they're all covered. And familial status. Alcoholics and persons in treatment are considered protected classes, but current drug abusers are not. That's coming up. Those classes are coming up on the next page though. All right. So let's just go over now this list. The Federal Fair Housing Act covers dwellings and apartments as well as vacant land acquired for the construction of residential property. So vacant land is covered under this too, if it's for the construction of residential property. And it makes all of these acts discriminatory. Refusing to sell, rent, or negotiate with any person or otherwise make a dwelling unavailable to any person as a means of discrimination. Changing terms, conditions, or services for different individuals as a means of discrimination. You know, I'm renting out my unit for $1,500 a month, but for you, $2,000. You know, practicing discrimination through any statement or advertisement that restricts the sale or rental of residential property. Representing to any person as a means of discrimination that a dwelling is not available for sale or rent when it is. Making a profit by inducing owners of housing to sell or rent because of the prospective entry into the neighborhood of persons of a particular, I'm going to use the word protected class to cover all the protected classes. Because it's not just race. Anytime we think of discrimination, often most people just think of race. It's a lot more than just race. There's a lot of kinds of discrimination that's out there. You got race, color, religion, national origin, sex, people with disabilities, people with families or children, alcoholics, people in drug treatment programs. Now, these are the federal laws. If you want to start getting now into the state laws, when we get into the state laws, New Jersey has just about one of the strictest laws when it comes to protecting people's rights, because we've got laws that cover people's gender identity or expression, their sexual orientation, their if you served in the military, which is kind of weird that we have to make people in our military that fight for our country a protected class. What the hell is going on with our country when people are discriminating against those just because they served in the military? You know, we're getting kind of twisted. Anyway, the New Jersey has a lot of protected classes, a lot more protected classes. They even got statements in there that you're not supposed to make statements directly or indirectly or even utter or joke around about discrimination. Check this out. In New Jersey, according to New Jersey law, if you think somebody's a protected class and they're not a protected class, if you think they are, they just became a protected class. That's how wide covering New Jersey is. All right, so making a profit by inducing owners of housing to sell or rent because of the prospective entry into the neighborhood of persons of a particular race, color, religion, or national origin, disability, or familial status. I want you to write at the end of that line the word blockbusting. You see, I got it up on the slide. I just changed the slide. That's how you spell blockbusting. It's one word. So that bullet point describes blockbusting, but I like this slide. This slide I created goes over 3 things that you need to know for exams. Good slide to study from, hint, hint. The next bullet point, altering terms or conditions for a home loan to any person who wishes to purchase or repair a dwelling or otherwise deny such a loans as a means of discrimination. Okay, now this one is redlining. So right next to that bullet point, redlining. But redlining is not just discriminating against people by not offering them loans. It's not offering them, it deals with all kinds of financing, not offering them home loans to purchase real estate, or not giving them homeowners insurance, even though they could afford it, as a means of discrimination. All right, so in the past, redlining was a practice done by banks that or lenders in general. any investor does not want to make risky investments, right? But in the past, discrimination played a big role in whether the lenders were going to lend to people. They said that lending to minorities, which was not just people of color, it was Black people, Hispanic people, Asian people, but it also covered people from different countries, like Irish people were discriminated against. They were thrown into that mix as being a lower class of people and a riskier people to lend to. So for loan, when you applied to get a loan, they used to have these maps that were drawn out for the area that said, what's the major composition of the people that are living in these areas? And they were like, what percentage of it is Black, Hispanic, white, and the nationality of the people, you know? And then they determined the risk. They would color code the map. So they would draw red lines around it, dissecting the areas within a town, for example. And they would decide whether they were going to grant loans or not to people in certain areas. And so that is the way that they discriminated, by tiering the risk factor of lending to people in areas that they deemed to be risky. All right. Let's see. I think I got a little video pertaining to that too. I could show you. And I downloaded videos. I just didn't integrate them yet. So real estate videos. Okay. No, I did not download that video yet. I got a link to it somewhere though. All right. It's just explaining what I just explained to you. It just showed you how they drew out the map and how on the applications they put down. They actually had that on their documentation based on census data. They drew out the maps to dissect the town by cutting it up with red lines on the maps, and lenders would actually use this to determine whether they're going to qualify people for loans or not. All right. So let's just continue on. So denying people membership or limiting their participation in any multiple listing service, real estate brokerage organization, or other facility relating to the sale or rental of dwellings as a means of discrimination. Remember, I told you the other day, we have the African American Association of Realtors, the Asian, the Hispanic, the Women's Council, and I could join any of them. Because if they denied me membership, it'd be a violation of this federal law, the Federal Fair Housing Act of 1968, part of the Civil Rights Act of 1968, that pertains to the housing. So they wouldn't be able to, nobody would be able to deny me membership, because that would be a means of discrimination as of this bullet point. Okay, now this is actually a title. I would draw a line separating this. This is not one giant run-on list. This is now, there's a separate title here. Let's draw a line separating at for the last bullet point from the rest of them here. Draw a line across the page there, and then highlight the title. This is actually a title. Exemptions to the Federal Fair Housing Act now. So what are the exemptions to the Federal Fair Housing Act? Okay, so the sale or rental of a single family home is exempt while a home is owned by any individual who does not own more than 3 such homes at one time, meaning that they're not in the, real estate business as a practice. And A, the broker or salesperson agent is not used because under no circumstances are we ever allowed to discriminate. And B, discriminatory advertising is not used. If the owner is not living in the dwelling at the time of the transaction or was not the most recent occupant, only one such sale by an individual is exempt from the law within any 24-month period. The rental of rooms or units is exempt in an owner-occupied 1 to 4 family dwelling. Dwelling units owned by religious organizations may be restricted to people of the same religion if membership in the organization is not restricted on the basis of their protected class. A private club that's not open to the public may restrict the rental of its occupancy and lodgings that it owns to its members, as long as the lodgings are not operated commercially. See, it's not telling people that they could discriminate. It's just carving out exceptions to the law. I mean, some of these are kind of apparent. You could see why. Other ones, it's not so clear why, but there's reasons for all of them here. So in 1974, we're going to highlight, in 1974, an amendment added sex as a protected class. In 1988, 2 other classes were added, those with mental or physical disabilities, including AIDS and familiar status. Those are children under the age of, having children under the age of 18. And although alcoholics and persons in treatment are considered a protected class, okay, so let's just stop it right there. So now we have all the additional protected classes highlighted. Now let me continue reading. Drug abusers are not. Current drug abusers are not, nor are those who pose a threat to the health or safety of others. Highlight, housing intended for older persons is exempt from the familial status requirement if it's solely occupied by persons 62 or older. And I want you to write in the margin next to that, senior housing, next to that line. Senior housing. And then I want you to put a bracket around the remainder of that paragraph. And write in the margin next to it, 55 plus community. Because the rest of this paragraph is going to be describing what a 55 plus community is. And that last line that you highlighted is describing what senior housing is. There's a difference between them. So we need to know the difference. What is senior housing? Housing intended for older persons that's solely occupied by people 62 and older. Now, so what's a 55 plus community? Well, let's read it. If 80% of the units are occupied by at least one person 55 or older, by at least one person 55 and older, and the housing facility or community publishes and adheres to policies and procedures demonstrating its intent to be housing for older persons, and also complies with the occupancy rules of HUD, this is Department of Housing and Urban Development, that it intends to be housing as a 55 plus community. Now, if you're a licensee marketing such housing for older persons should make sure that the facility states in writing that it is HUD compliant. All right, if you guys try to get a listing for a property that's in a 55 plus community or senior housing, you need to get this statement. You see this slideshow? I put this form up here. It's not in the book. This is from the Garden State MLS, this one, but this is the required disclosure. If you get a listing for 55 plus or senior housing, 62 and over, this is the HUD, Housing for Older Persons Certification of FHA Compliance Form. It needs to be filled out for the property. If we get a listing in a 55 plus or senior housing community and we do not have this form filled out, the listing will be taken out of the MLS and we're going to be fined for discriminatory advertising. Because if we don't get a certification that it is a 55 plus or senior housing, then we're discriminating against those who have children, those with family members under the age of 18. All right. So I just want to give you the visuals here. So I add these actual forms that we use here into the slideshow. This is not in the book though. All right. So, I mean, these slides are pretty good to study for this chapter. Familial status, what does that mean? It applies mainly to those with children under the age of 18, including pregnant women. All right. Senior housing, these are the exceptions. These are the only allowable exceptions to familial status, and it's not considered discrimination if it's a senior housing or 55 plus community. But in that case, you need to have this form once again filled out. Okay. Now, can you buy a home in a let me see. Can you buy a home in a 55 plus community and not be 55 and older?
I think a family member needs to live in somebody in the family needs to be 55 or older.
Okay,
And then,
so correct. You cannot buy in a 55 plus community if you're not 55 or older, because it requires that it's meant to be 55 for people 55 and older. Can you own in a 55 plus community without being 55 and older?
yeah,
Yes, because what if that family member had died and they left it to you? Right? So yes, you can. Because everybody there, unlike the senior housing where everybody has to be 62 or older, in a 55 plus community, only 80% of the units have to be occupied by at least one person 55 and older. Now, you can't buy in a 55 plus community if you're not 55 or older. However, you can own because a relative could have died and left it to you, right? But the community has to keep tabs on the numbers of people that are living there that don't have at least one person 55 or older. Otherwise, they can lose their status with HUD as a 55 plus community. Okay, so I just basically want to make that point to you, okay? So these are the points, the main points I'm trying to have you highlight here within the book all over the place. But this slide is a nice little, neatly tidied up, buttoned up, good for your notes, studying, hint, hint type thing, all right? Okay, so fair housing, Jones versus Mayer. All right, so,
Victor,
yes.
I have a quick question. Devil's advocate, right?
Sure.
You said that they have to keep record of how many people are in the vicinity, in that area of 55 and plus.
It's in the
Say that-
facility. It's not an area, it's a community or facility.
Yes, the community.
Yeah.
Right. So let me use the correct word. I'm sorry. In the community, say this coronavirus is happening,
Mhm.
right? And you have maybe 2 people.
A lot of people dying. Is that what
Right.
you're getting at?
Yes.
Yeah, that's going to be a mess. I don't know.
Uh,
I don't know. I mean,
Right.
we've had some governors that made some awful decisions here in New Jersey and New York.
mhm.
These are the 2 states with the most deaths. And, I'm going to play devil's advocate and say that these 2 guys are directly responsible for them because they sent people knowingly that were infected with coronavirus to be amongst the people that were the most vulnerable. I know people that lost family members, both their parents, directly because of this, and it is a serious issue, and we have had a lot of deaths. And now, if this is a 55 plus community, your question is going to be pretty much what if they fall below those requirements now because
Right.
so many people died? I don't know. I'm not going to act like I have all the answers for everything. Okay, so unfortunately, under normal circumstances, we're learning the laws under normal circumstances. Okay, are there ever situations that are not normal? Yeah, and that's what the courts are for, right? I'm sure there's going to be arguments in the future about this. I'm sure there's going to be all kinds of issues with regulatory, especially since we live in a nanny state and they want to regulate everything. But then we have situations like this that are beyond control. I don't know. And for exam, they're just going to be teaching you the norm anyway. But I don't know. Sorry, I don't have a better answer for you.
No, that's fine.
Okay. Okay, so we're going to learn now about Jones versus Mayer. Basically, this case is going to tell us what I've been explaining to you all the time. I explained to you that when you have two laws that cover the same topic, the more restrictive rule will prevail. That means we have to follow the more restrictive rule, the more restrictive law. And this is an example with an actual case of Jones versus Mayer. So in 1968, the Supreme Court decision in the case of Jones versus Alfred H. Mayer Company. Jones was an African-American who sued Mayer, alleging that he had refused to sell him a home in St. Louis County, Missouri, solely on the basis of race. In its court ruling, it upheld the Civil Rights Act of 1866. Highlight: Civil Rights Act of 1866 prohibits all racial discrimination in private or public in the sale and rental of property. So it's falling back on that more restrictive rule. So the importance in this decision rests in the fact that while the 1968 federal law exempts individual homeowners and certain groups, the 1866 law prohibits all racial discrimination without exception. So despite having an exception in 1968 law, an aggrieved person may seek a remedy for racial discrimination under the Civil Rights Act of 1866, a law against any homeowner, regardless of whether or not the owner employed a real estate broker or advertised the property in a discriminatory fashion. Where race is involved, there's no exceptions ever to the law. Okay? So I know some people a lot of times get heated up. I was able to get through the class, at least talk about the Federal Fair Housing Act without getting bombarded with questions. A lot of times when I start talking about the Federal Fair Housing Act of 1968 and start going through the exceptions, I start getting a million questions. Well, why, you know? Okay, so over here, we were able to at least get through it. And now we could see that there was, even though there are exceptions, it does not give you the green light to go ahead and discriminate, because we have the Civil Rights Act of 1866 that says under race, you can never discriminate anyway, even though there are exceptions to it, right? All right, now, we have an equal housing opportunity poster that was created by HUD, the Department of Housing and Urban Development. Anybody that offers housing or housing services has to display this poster. Failure to display the poster is actually evidence of discrimination. This is the equal housing poster. You see it has the house with the equal sign in it. This is the HUD's equal housing opportunity poster. So at the bottom of page 65, we're going to highlight, when HUD investigates a broker for discriminatory practices, it considers failure to display the poster as evidence of discrimination. So once again, the threshold is pretty low to be found guilty of discrimination. If somebody files a complaint against you that you discriminated against them, HUD has their own investigators. They have their own judges within their department that all they do is discriminatory stuff, right? So HUD will send out their investigators and to talk to you, to investigate, to see the case, you know, to ask questions. However, the first thing they do when they get to your office is they're going to look around to see if this poster is displayed anywhere. If it's not displayed, they stop their investigation. Bam, you're guilty. Because if you don't advertise that you offer equal housing for all, then you must be engaging in discriminatory practices, right? It's a pretty low bar, right? All right, so enforcement of the anti-discriminatory laws. Okay, so here's a breakdown of the federal laws I have here at the beginning on this slide. Let's pay attention to this slide for now. We have the federal laws against discrimination. We have the Civil Rights Act of 1866 and the Federal Housing Act of 1968. Who enforces the federal laws? HUD. HUD enforces the federal anti-discriminatory laws. And how long do you have to file a complaint for violations of the federal anti-discriminatory laws? 1 year. unless you want to make a federal case out of it, and then it's 2, right? Okay, so this term, an injunction, for some reason, they give this to you on exam, on state exam. So you need to know what this term means. That's why I added it to this slide. An injunction is when a judge orders somebody to do something or to refrain from doing something. Okay, so it's when a judge orders somebody to take action or refrain from taking action. You need to study this for state exam. That's going to be on a state exam. And to see where it's at in the book, on page 67, under enforcement, after redlining, there's a section there on enforcement. Well, let's highlight, first of all, a person who believes illegal discrimination has occurred has up to 1 year after the alleged act to file a charge with HUD, or 2 years if they want to make a federal, bring it to federal suit. HUD will investigate. Okay, so who investigates the federal anti-discriminatory laws and enforces them?
HUD,
HUD. How long do you have to file a complaint?
1 year.
Unless,
You want to bring it to federal court.
and then you got
2 years.
2
2.
years. Okay. Now in the next paragraph, we're going to highlight an injunction. This would order an offender to take action. Now it goes on to say, for example, a judge can force a landlord to rent to somebody that they previously denied, you know, or take some other kind of an action. It's when a court orders somebody to do something or refrain from doing something, okay? As far as these fines go for violations of the federal law, don't highlight them. You don't need to highlight them. I don't know how the hell you would study and remember them. They're very obscure numbers that seems like they picked them randomly out of thin air. So, for violations of the federal anti-discriminatory laws, as of April 15th, 2019, these fines ranged from $21,039 for a first violation, $52,596 for a second violation within 5 years, and $105,194 for where the hell do they get these numbers from? Yeah, they're so obscure. Anyway, so you obviously don't need to study them. I don't know how the hell you'd remember them. Okay, let's back it up a little bit. So back on that page, block busting and steering, just put an asterisk next to it. We pretty much already went over that one, and let me back up to the slide with it. Okay, I have this this slide that I have, I'm telling you, is a good slide to study. I got the breakdown of these 3 things that you will get tested on both exams. Block busting is also known as panic peddling. It's using discrimination as the tool to play on a homeowner's fears of a protected class. These people are moving into the area. They're going to drive your property values down. You got to get out now. So they're trying to scare you into busting up the block. That's where they come up with the block busting from. They're trying to scare you into selling your property by playing on your fears. That's why they call it panic peddling. They're trying to panic you. These people are moving in. They're gonna drive down your property values. You gotta sell now. But I'm gonna be the hero that I'll buy it from you. But of course, at a lower price. I mean, property values are going down. And then they turn around, they sell it to the very protected class they were playing on their fears using at a marked up price. Okay. So block busting is basically done by a bunch of scam artists that are trying to make money by playing on people's fears, but they're using race as the, or not, it's not just race. It was commonly used with race, but it's not just race. These days, you could still see it going on, but you're not seeing it as so much with race anymore. What you're seeing it now is, hey, look, have you heard what they're putting in next door? They're going to have one of those rehabs or a battered woman's shelter, or they're going to be putting in a a home for the mentally disabled. You're going to have all these crazies running around your neighborhood. What's that going to do for your values of your home? See, these are the things that we're probably seeing a little more commonly. I mean, because look, we're in New Jersey. It's pretty integrated, you know. So it's not as common to see that with race anymore, but we are still seeing it with other protected classes more often now. But it's still not a common thing these days. This was big in the 60s and before, where discrimination was a major issue back with us before they passed some of these civil rights acts, right? So it's not as common anymore, but we still need to know the laws because it still could happen. So what is blockbusting? Who is blockbusting discriminating against? Who is blockbusting discriminating against?
A seller?
Yep, the owner of the property. They're trying to use discrimination as the tool against them. They're trying to scare them against these people, whoever these people are, you know, and using discrimination as the tool to try against them. All right. Now, steering is a little more subtle, or could be a little more subtle. It could be obvious, it could be subtle. This is why steering is harder to detect, you know. And I'm going to tell you guys straight out, you could be found guilty of discrimination for steering, and you're not trying to discriminate. Let's just say you're trying to help people, because you're trying to put them in a better area with safer area or better schools. Well, hold on one second. When you're the one who's making the decision where somebody should live, guess what? You're guilty of steering. You should never do that. People are going to ask you all the time, well, is this a good area? Is that a good area? What's the better area? Well, better. What is better? That's a subjective term, isn't it? I'm going to give you examples. There's plenty of examples where I probably could have been found guilty of discrimination if somebody wanted to really push it. I mean, you guys are probably going to come across this too. And look, I tell you, you do not need to have meant to discriminate against anybody. Somebody just needs to prove that a discriminatory act occurred for you to be found guilty of discrimination. I could have been found guilty of discrimination by white people, by black people, by whatever, you know, and it wasn't, discrimination is the furthest thing from my mind, trying to help people. But some of these people saw that I was trying to help them, so it was never going to be an issue with me anyway. But you never know what kind of chip somebody's got on their shoulder. Some people, their first go-to when they want to argue is they want to go to the race card, right? But the people I was helping knew that that wasn't in my heart, so they never made an issue out of it. But you never know. Sometimes people, money is on their mind, and they know they get a lawsuit out of it. So you guys got to be careful. And it doesn't matter if you're the same color of them or not. You know, somebody wants to accuse racism. You know, they could accuse you of racist. You could have a black person accuse another black person of racism. You know, the law doesn't care about that, right? Look. I'm going to give you a couple of examples of steering. I had one instance one time when I opened up my office in Edison. I had this one black girl came into my office. At the time, I used to do a lot of work in Newark, and she actually worked in Edison. She lived in Newark, but she needed to find a new rental. So I put her down at the computer next to me. She sat down at the computer right next to me as we put in the search criteria and search for homes in the area she wanted to look, right? And we're going through all these listings, and a lot of these properties were run down. Some of them were decent. Some of them were too small. Some of them were okay. So we're just going through the list of possible properties that would be good for her, right? So she's there side by side next to me, making the decisions, you know. And, you know, I'm kind of like skipping through some of them because I'm like, oh, that thing looks small. Because being in real estate, I could see that those rooms are small. She's not going to like them. So I'm like, no. And then she goes, well, go back on that one. Go back. I was like, okay. Well, I went back. And I was like, oh, yeah, that's actually not too bad. Price seems decent. Wow, the room sizes are pretty large. Wow, yeah, that looks pretty good. All right, let me pull up the map, see where it is. And I was like, ooh, that's pretty rough area, you know, because at the time Newark is a strange animal. It could have one street, and even on the same street, you know, like the lower numbers could be good and the higher numbers are bad. You know, it's really weird. You have to really know the area. It's like real small areas. You could have one place where you got crackheads moving around, another place it's an excellent neighborhood. You know, it's
That is a true statement.
yeah, you got to be familiar. You got to be really familiar with the area. So anyway, at the time, I used to do a lot of work with landlords and banks and stuff back then. So I was pretty familiar with the streets back then. You know, now I couldn't tell you anything. You know, you got to stay up on that stuff. You know, so she, I was like, oh, that's a pretty rough area because I was there like, you know, a couple days before, and she was. Listen. Some of the words that come out of people's mouths will shock you, but after a while, you may start getting numb to it. You know, I was like, oh, I don't know about that. That's pretty rough area. Now, right there, I should have never made that statement because that could have been construed as steering, even though, you know, I'm trying to help the girl, you know, but it's subjective. People have the right to choose where they want to live. And when it's you that's trying to, even if you're trying to help them out, I was trying to like steer her because I was saying, oh, that's a pretty rough area. It could have been said that I was trying to steer her away from that area, you know, now, not because I'm discriminating, I was trying to help her, you know, I was like, oh, that's a pretty rough area, but check out the words that came out of her mouth immediately right after that. And I was just kind of shocked. You know, she was like, this is what she said. She was like, nuh-uh. She's like, that area ain't bad. It's been at least a year since somebody got shot there.
That's the aim.
Clearly, we live on two different planets. If you consider a good area, if it's been at least a year since somebody got shot there, I'm like, somebody
The
ever
pinnacle.
got shot there? You know, it's like, whoa, what's going on here? You know, but that just shows you, you know, people get to choose where it is that they want to live. And if you're the one that's making the decision, you could be found guilty of discrimination. So try always to put that decision on them. They're the one that's got to live there, not me. So even though I'm trying to help her, if she didn't know that, and if she like had a chip on her shoulder because I'm a white guy, she could have been crying racism, you know. But you know, she didn't because she saw, you know, we got along good. But you never know what's going on in the other person's head. And like I said, it doesn't matter if I was white. I could have been black and she could have still accused me of discrimination and steering her away. Okay. So you got to be careful what you say to people because you never know what's in their hearts, you know?
Right.
And words, you know, things that you say, your actions that you take, you got to be very careful that they can be no way be deemed discriminatory in the event that somebody ever wanted to sue you or make charges against you. You got to be very careful, especially, you know, it's a business, it's an industry, you know. If people see they have an opportunity to make money, they may take that opportunity, you know. So you got to be very careful.
Right.
Now, so steering is limiting someone's options of where they can live, not by showing them all the properties in the area that meet their criteria. Like, remember I told you guys that it's a good idea when dealing with buyers to have them sign an exclusive buyer agency agreement so that you can't be accused of discrimination when you're searching for properties, but you're not showing them the ones that are not offering enough commission. Because if you were to put them all on a map and if it so happened to be that they were all from one area only, and now you were not showing them the properties from that one area, they could paint the picture. Hey, how come you're not showing me properties in that area? They meet my criteria.
Right.
But you're like, well, you're looking at the commission on it. You know, you're not looking at any of those other factors. And you're just like, oh, damn, they do all come from that area. Now, this person, if they wanted to, they could make an accusation that I'm steering them away from that area, and then I got no excuse for that, and I could be accused of discrimination, even though the only color I was seeing was green, right? So that's why you gotta. It's a good idea to have them buyers sign an exclusive buyer agency agreement, and if you explain to them that it's not offering enough commission, this is the minimum I'm willing to work for. Are you going to make up the difference? Or do you not want me to show you homes that are not offering that minimum commission? See, if you have that conversation with them in advance and you put it on paper, not to show those properties, now I couldn't be accused of discrimination because I didn't show them properties that all were from that one little pocketed area because
Right.
you know, trying to discriminate or something. So that's it's like things that we don't normally think of because we don't normally think that way. But you got to always, when you're in real estate, you got to always think that way. You know, it's a business, and you know, discrimination, and it's a big deal. You got to be careful. You know, that anything
Right.
that you do can in no way ever be deemed discriminatory by somebody. Even if it's the furthest thing from your heart, you still got to consider it all the time. Okay.
Yeah.
Here, I'm going to give you two more examples of, these are actual cases that I've had. Here's another one of when I started working in real estate, I started working in West Orange. Okay. And so the Oranges was the area where I was working at, Oranges, Livingston, all that whole area in Essex County. Now, I had this one girl that came to me that she lived in East Orange, and she has a young child that was going to be starting to go to elementary school. And she was a young single Black mom. And she came to me and she's like, I want to buy my first house. She's like, but I don't want something that needs a lot of work because I don't know how to do the work. I can't do it, you know, and this is my budget. And, you know, so she didn't have a whole lot to work with. But so I had a discussion with her. I was like, maybe the best option for you would be to buy a condo. If we could find you a condo in your price range, you know, because a single family house would probably be more expensive, and in this price range would probably require a lot of repairs and maintenance. You know, I said, so a condo would probably be your best option, seeing as you don't want to do a lot of work. You don't want something that needs work, you know. And so together we came to that conclusion, and she was in agreement with me. And so I started looking up properties, and I actually found a lot of good stuff for her in her price range, because she didn't want to move too far out of the area, but she was willing to move out of the area a little bit, move out of the geographic area. She's like, listen, I want to buy my first house. Here's the criteria for that. I don't want something with a lot of work. And she's like, I want a better school because my baby's going to start going to school. And right now he's got to go to school. And when he goes to school, he's got to walk by the wall where all the drug dealers and gang members hang out. And I don't want my baby involved in that. You know, I was like, okay, good, mom. I could see where she's coming from. I'll be glad to help her, you know?
Right.
You know, so I was like, okay. And so I started looking in areas that I thought was better, in areas that I thought that she would like. Okay. Basically, so I was trying to pull her out of the East Orange area, you know? And
Right.
she ended up making an offer in on a house with another real estate agent. And this other, the listing agent of this property called me because she remembered my client, because there was one listing that I showed her that required the agent to show up with the key to open the door for us. Okay, they didn't have the lockbox there. And so the agent remembered the client, you know, her as my client, and had I guess, kept track of things well enough. I don't know. I mean, I probably wouldn't remember that, but she remembered good enough, and she called me. And she's like, yeah, she's like, listen, I had a lady put an offer in on one of my listings, and I know that you showed her another one of my properties, and I just don't want to have any problems. I just want to know if you're aware that she's working with another agent now, because I don't want to have any issues with offers coming in with somebody who's you know, between agents arguing over this, you know. And I'm like, no, I wasn't aware, but thank you for bringing it up. I'll give her a call, find out what's going on. Thank you very much. So I gave her a call, and I was like, you've been cheating on me, you know.
Right.
And then she kind of blew up on me, and I was kind of shocked about it, because it seemed like I was showing her a lot of properties with her and her girlfriend. I was taking them around, showing them a lot of properties, and she seemed to be on the same page with me too. But I showed her a lot of stuff that met her criteria, price range, all that. And for some reason, she was not making an offer on any. So anyway, she made an offer in on another property that ended up being something opposite. It ended up being a one-family house. She didn't want a one-family house because it's going to need a lot of work. This house needed a lot of work. She told me she wanted specifically something that didn't need a lot of work. her kid was, it was in East Orange. Her kid was going to be going to the same school. She told me she wants a better school. Now,
Huh.
I was like, what the hell, you know? And the funny thing about it is trying to figure out what's going on in here in people's minds sometimes.
Mm-hmm.
It's a scary place. Don't go there. You know, this
Yeah, 'cause
lady,
they don't even know what they want.
oh my God. She was like, first of all, she couldn't explain why she went for the one family house that needed a lot of work. When she specifically told me that she did it, you know, instead she's blowing up on me. You're showing me stuff and areas I don't want and blah, 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 blah. I'm like, whoa, where did this come from? Every time I showed you a property, I asked for feedback from you. You're just like, oh, I just want to keep looking. Like, that's the attitude she had, you know? And now all of a sudden
Like you're
she's
supposed to be
blowing up on me.
psychic.
You know, and I'm like, look, you said you wanted better school district. Your kid's going to the same school. And she's like, yeah, but this house is on the other side of the school. He don't got to go by that wall. You told me you wanted a better
Okay.
school, you know, without the drug dealers and gang members, you know. And she's like, well, yeah, just because you have to walk by them. I'm like, oh my God, you know, what the hell are you thinking? Like, yeah, all right, whatever. You know, I wasn't going to argue commission on those or anything like that. I didn't show her that property anyway, so I wasn't entitled to a commission. But sometimes you just don't know what's going through people's mind. Okay, now let's go to the other spectrum. I had another guy. This one is rich, very affluent, looking for a property that has to have been, the guy worked in New York City, had to be near the train to New York City, had to have good schools with certain extracurricular activities that his son and daughter were into, had to have that a downtown homey feel in the town, but with modern stores and such. And I'm like, okay, so I get you. So let me do my research for you. So I started researching towns that met all those criteria. However, at the time, I was having a little bit of issue with the schools because this was shortly after President Obama got elected. And when he took office, he took down all the school report cards from the New Jersey Department of Education. He ordered that all states do, because until the Department of Education came up with a new standard of what kind of information about children that they wanted released in the public. Because once again, it had something to do with, we don't want to release certain information because it could be used for discriminatory reasons and all kinds of crap like that. Nonetheless, the bottom line was, me as a real estate agent, I had zero information about schools, finding a good school, okay? Because they took down all the old school report cards data that was available. So no state had it. So where do I get that information now for the good schools? So I start going to like websites like greatschools.com and websites like this. And in the meantime, they're using all old data. And a lot of it's very subjective. It's like schools get rankings based on a parent who liked the teacher because they baked cookies at the sale or some kind of bullshit like that, you know? And so that's not what this guy was looking for, you know? So I was like, all right. At the time, I used to be married, and I was married to somebody that was a public educator, public school educator. So I asked her, I'm like, how can I find out a list of the good schools that, you know, he took down all the information. And she was like, well, you could go to the Star Ledger website. They have something they put up, a school ranking system for, you can look up what they call blue ribbon schools. Yeah. I was like, okay, blue ribbon schools, they're good schools. Okay. So I cross-referenced now all the towns that met their criteria, the homes that they were looking for, with the towns that had blue ribbon schools in them. Yeah. And they're not blue ribbon school districts, they're blue ribbon schools. Okay. So I had to cross-reference the list. And so now I came up with this list. I put a lot of work into it. There's a lot of legwork that I put into that, a lot of research for this guy. I mean, I was eager because I knew he was going to buy something expensive. So I was like, I'm willing to do the work, right? And so I went out of my way to do all this work for the guy. And I give him this list now. No homes yet. This is just a list of the towns that meet his criteria for his approval before I start searching for homes, right? Yeah. And I give him this list, and he's looking at it like this. He's like, what's this? And I explained, this is the list with all the blue ribbon schools. It has all the towns that meet your criteria and everything. He's like, he threw the paper back at me. He's like, I don't want to see any of this blue ribbon school bullshit.
What? What?
That's exactly what he said to me. I don't want to, he was like, I don't want to see any of this blue ribbon school bullshit.
Classy.
Okay. Look, sometimes you have clients, they talk like this, you know, like you don't got to take BS from people, but sometimes you're going to want to bite your lip a little bit. Okay. Otherwise you're not going to get a lot of business done. Sometimes people can be sharp. Okay. So I was like, all right, why, what's the problem? And he's like, do you even know what a blue ribbon school is? I was like, good school. You know, and he's like, do you know how they determine if it's a blue ribbon school or not? I mean, we got any teachers in here at all that know what a blue ribbon school is? Well, if you go to the Star Ledger website where they had the list of the blue ribbon, I don't even know if that's still up there, but they had the list of the blue ribbon schools. Underneath the list, it shows there's a word there, data. And there's an asterisk that's a blue clickable link, the asterisk next to the word data. And if you click on that, it'll take you to a link that shows you how much weight they put into different criteria on what makes up a blue ribbon school.
Yeah.
What if you guys, I don't know if you guys got kids or not, but if you have kids, if you don't have kids, but if you did have kids, what would you guys want to be considered into the factors that you would want the most weight in to be considered a good school?
Success rate, like
Graduation.
Graduation rates?
And the colleges that look at these schools. My daughter actually attended a blue ribbon school. So you're actually teaching me something. She would come home with like hours and hours of homework. She had 2 book bags.
wow.
Well, what else do you think makes up a blue ribbon school? Or forget about blue ribbon. What do you guys think would make up the best school that you would want for your kids? So graduation rates. What else?
Good teachers that
Okay, good teachers, but I don't know how you'd really rank that, but okay.
like experienced teachers.
All right. How about this one? Teacher student pupil ratio.
Yeah.
Okay.
Class sizes.
Okay. What else?
Extracurricular activities.
Extracurricular activities. Okay, I'd put that a little bit lower on the list though. I mean, you want the kids to have extracurricular activities, but you know, I'd be looking more at test scores too, right? We got graduation rates. What about test scores? You know, the 3 R's, reading, writing, arithmetic.
Yeah.
I did go to Linden School.
I
That
guess.
was a joke, by the way.
Yeah. No, or like,
Yeah.
what about like college acceptance rate or something? Yeah.
Okay, but I don't know where you'd even get that information from. That would be on a case by case or class by class basis.
Yeah.
I know some graduating classes may give all the students from that particular class may say, oh, Jimmy is going to Harvard or whatever, right? But there's no database that would maintain that, like how many kids go to Ivy League colleges and such, right? So anyway, yeah, so a lot of those things are like test scores and all that. All right, test scores, graduation rates, extracurricular activities. Any other ideas? What's the most important for you guys, for your kids? Test scores, graduation rates, extracurricular activities. Let me tell you what put the most ranking, what was highest ranked on the list to determine whether it's a blue ribbon school or not. Now, keep in mind, all those things were on the list, but they were lower on the list. The 2 items that this guy pointed out to me that were highest on the list, that they put the most weight in to determine if it was a blue ribbon school district or not, are cultural diversity and subsidies. You know what subsidies are?
No.
Money.
Money.
How much money the school's getting from the state and federal government, and cultural diversity. Sure, listen, I want my kid to be culturally diverse, be aware of other students, and sensitive to other students, and learn all about different cultures. But when I'm thinking about education, money that the school's getting and cultural diversity, I would put them on I'd put them a little bit lower on the list along with the extracurricular activities. You know, they're good to have, but I'm thinking math, science, the reading, writing, arithmetic, the major things that'll get you somewhere in life, and all the others, while they're good, I wouldn't put the most ranking in them. And that's what this guy blew up on me. He was like, apparently he knew all the information already. He's like, if you go to this, he's the one who told me, if you go to the Star Ledger website, you click on data, there's a little asterisk next to it. You click on that asterisk next to the data. He's like, you could see how much you, I was like, then why the hell are you asking me? You should have told me a list of what schools and what towns you wanted to be in.
Exactly.
But in the meantime, I'm over here like spinning my wheels, trying to be so helpful for this guy. Remember, I told you no good deed goes unpunished, right? And there's a perfect example of it right there. Needless to say, this guy did not buy a house through me. He didn't use me, and I'm like, son of a, I did all this work for this guy, trying to find him good schools, trying to find him towns that met his criteria, and cross-referencing lists and extracurricular activities that he was looking for the kids for certain extracurricular activities. And then the guy ended up being a jerk off and not buying from me anyway. I'm like, So this is why I'm trying to get you guys to learn lessons through me. Don't put your neck on the chopping block with them. Don't go out of your way looking for information for people, because a lot of times they may already have that information. They just may be playing stupid with you. Try throwing the questions always back on them, because this guy already had an idea where he wanted to be, because he spoke to people at his job from this area that he was moving to, and they gave him ideas of towns that he wanted to be in already. So even though I was specifically asking him, he didn't give it to me, but I should have kept throwing it back on him. But, being nervous about getting this expensive purchase, I was like, yeah, I want this guy as a client, I'll make a lot of money off of it. Still got me nowhere, right? That's also the time where I gave up on dealing with the expensive homes, the mansions, and the rich people. I was like, you know what? Let me see where I'm getting most of my business from, and it's selling cheap condos. I actually ended up selling fixer-uppers, multifamily houses, and condos was my number one source of business. So I was like, you know what? Why don't I just start specializing in what I know best? Condos is a niche thing too. There's a lot of areas in real estate that you could specialize in. New construction, condos, fixer flippers, rehab properties, multifamily properties. We're dealing with investors. There's a wide range of areas that you could go into in working in real estate. And so, I just made the decision at that point, you know what? The expensive homes, the prestige, the beauty of the mansions, that's one thing. But one thing you got to keep in mind, the people you got to deal with that too. All right. Sometimes the attitude comes with it, and you got to learn to bite that lip. And, it's not in my style. I could bite my lip so hard, but once it starts to bleed, I'm going to start hitting back, I don't want to deal with that. So anyway, moving along, I just want to teach you some lessons that I went through that I don't want you to go through. So anytime that something is subjective and you got to ask a question, throw it back on them is my point. That's all I'm saying. All right. So here's the HUD Equal Housing Opportunity poster. We got to have that displayed. All right, now we're going to get into the LAD, the New Jersey Law Against Discrimination. Oh, wait, we were going to do some highlighting, right? So under blockbusting and steering, highlight the first sentence under blockbusting. Is also known as panic peddling, means inducing homeowners to sell by making representation regarding the entry or prospective entry of minority persons into the neighborhood. On the next paragraph, highlight the first sentence. Steering is the channeling of home seekers either to or away from a particular area on the basis of their protected class. So basically, any time that you're the one that has to make the decision of where somebody needs to be, throw it back on them. Don't make that decision, because you could be accused of steering. And then redlining, refusing to give mortgage loans or insurance as a means of discrimination. Turn the page. Turn the page. All right, the New Jersey poster. Now, failure to display the New Jersey poster, the LAD, New Jersey Law Against Discrimination. Let me just skip here for a second. Here's a picture of it on the slideshow. This is the New Jersey's poster against discrimination, the New Jersey Division of Civil Rights. However, just not displaying this poster does not automatically make you guilty of discrimination. It's just a $100 fine or more. Okay. Now, let me go back here. So under the LAD, the New Jersey Law Against Discrimination. This slide is pretty good because it goes over the federal laws as well as the state. All real property, it covers all real property. That's residential and commercial real estate. Complaints made to are made to the state attorney general's office. So it's basically enforced by the attorney general's office. And how long does somebody have to file a complaint for violations against the New Jersey law against discrimination? They have 6 months, which is 180 days to file a complaint. Anybody who interferes with that investigation is subject to a $500 fine and possible 1 year imprisonment. How do we inform people about the LAD, the Law Against Discrimination? Well, on page 7274, we have the Attorney General's Memorandum, which is the document that we need to give to homeowners at the time we list the property for sale. Sorry, I just want to pull up that Attorney General's Memorandum. Actually, you know what? Give me 2 seconds here. I'm going to go to their website because my understanding is from our meeting the other day that they just came out with a newer one. Let me check the date on this, see if I have the newest one. No, they have one that just came out. So let me take a look really quick and NJ Civil Rights, what is that? NJ Civil Rights dots, it's their website. njcivilrights.gov. Want to pull up the latest one. Ooh, what do you mean? NJ Civil. For real? Not a secure website, so I can't pull it up. What's going on here? Site permissions. Got to get the browser to be able to open up the site. Saying it's not a secure site, the New Jersey Civil Rights webpage. Awesome. Oh, here we go. I got it up. Ah, so, well, this brings up a different website, NewJerseyOAG.gov, Office of the Attorney General. Okay, so I'll get the civil rights website through that. Just give me 1 second here. I just want to pull up their COVID noted here. I'll share it with you as I'm going through it. Civil rights. Want to find their latest Attorney General's memorandum. Model policies, required posters. There we go. All the accommodations, employment, housing. There we go. That's what we want to find. Their latest housing poster. Maybe I do have it. That's their housing poster. Looking for the Attorney General's memorandum, though. All right, I'll look for that a little bit more. In the meantime, so what are the violations? Well, first of all, the Attorney General's memorandum is the documents that needs to be given to owners at the time that we take a listing. The federal laws must be given to the property owners for residential and commercial at the time of listing. Licensees must refuse listings when a property owner indicates that they intend to violate the LAD, the New Jersey Law Against Discrimination. So if you try to take a listing and somebody tells you that they have an intention to discriminate, you must turn down the listing. That's an exam question too, okay? And you need to know these fines for exams for the New Jersey, for violating the New Jersey Law Against Discrimination. It's up to, it's not 10,000, it's up to $10,000 for a first offense, up to $25,000 for a second offense, and up to $50,000 for further infractions. All right, so what do we need to know with the LAD? What kind of properties does it cover? All real property, not personal property, just all real property, residential and commercial. Who enforces it? The Attorney General's office. Who's the Attorney General? The highest law enforcement officer in the state. So the Attorney General's office. How long do you have to file a complaint under New Jersey law? 6 months. And what's the document you have to give to owners at the time you get a listing?
CIS.
Attorney General's memorandum, which informs them about the different laws against discrimination. And then what do you do if an owner tells you that they intend to discriminate?
Turn it down.
Refuse the listing. And what are the fines? 10, 25, 50,000. Okay. Got it all buttoned up right here for you to study from in just a couple of bullet points. You need to know that. You can see how quite a few questions can come from this too, right?
Right.
All right. So here is that latest anti-discriminatory poster from New Jersey. I do have that latest one here. Although the latest Attorney General's memorandum, I have to look up. It's to show me the same one from 2018. I was told that it was just updated, but let me check it's something else. Sorry, I'm just looking up really quick. I want to find the latest one, supply that for you. If I can get it. They told me that there's one that's available. How's everybody doing? Everybody here with me?
Yeah, I'm good.
Yeah.
Yep.
All right. Oh, here you go. New Jersey law against discrimination. All right, that's just a manual on the law. All right. Oh, come on, man. All right, I'll find the latest version anyway. So right now I do have it on the computer. The last one that I had available as the latest one. Contracts disclosure, Attorney General memorandum. Let me open it up and I'll show it to you. The changes were very mild anyway. I'm not even sure what they did. I think it was very mild change, if any, that they recently did. But here's the latest Attorney General's memorandum. Actually, they should have it here in this book too. Yeah, they do. They got the same version in this book too. But here I have it up on screen. For those who have version 13 book, you're not going to have that. All right, so we're going to actually go over this Attorney General's memorandum. This is the Attorney General's memorandum against the law against discrimination that we have to supply to all property owners at the time that we get a listing. Okay, you see there's no signature line anywhere here. There's no place to get them to sign it. So what I do is I just give them one copy, and I give them another copy, and I have them just initial or sign and date right in here, and I'll put that in the transaction folder, because I always like to have paper copies of everything to prove that I've given it to them. And then I'll put it in my listing folder. So I give one copy to the property owner, and I put one in the transaction folder where they signed and dated, like somewhere over here, because you can see there's no signature line anywhere there. And I don't want them to say that I never supplied it to them. All right. So let's highlight a couple of things, and then we're actually going to go over this Attorney General's memorandum. All right. So on page 70, we're going to, under enforcement, we're going to highlight complaints brought under New Jersey law against discrimination must be filed with the state attorney with the state attorney general's office within 180 days after the alleged offense. The attorney general's office will then investigate. And you can stop highlighting there. So they'll investigate promptly, and they have 45 days to attempt conciliation to get a resolution. After that time, the director of the Division of Civil Rights holds a hearing. The accused, if they're found guilty, will be ordered to comply with the law, to make restitution to those who were discriminated against, and take any other action that's ordered by the director. The orders can be enforced by the New Jersey Superior Court, or they could be appealed to that court. The director may award reimbursement for medical expenses, awards for pain and suffering or humiliation, highlight fines of up to $10,000 for a first offense, $25,000 for a second, and $50,000 for subsequent violations. And then skip the next paragraph. Following paragraph, we're going to highlight complaints brought under the New Jersey law against discrimination may be filed at any of the offices of the Attorney General. And then under notice at listing, we're going to highlight A copy of the Attorney General's memorandum on discrimination must be given to the homeowner at the time the property is listed. And in that same paragraph, highlight the last sentence that says, salespersons and brokers must refuse listings from owners who indicate that they have an intention to discriminate. So what do you do if a homeowner tells you that they plan to discriminate? Refuse the listing. Exam question. Boom. All right. Now, instead of reading over some of these other things, I like to, I skipped over some paragraphs and some pages here because I like to actually just read the document because it goes over the same stuff. Let's actually just go over it by reading the document that you're going to give to the owner and go over with the owner at the time you're getting the listing. Okay. So this is, you see the Great Seal of New Jersey up here. Comes from the Office of the Attorney General. That's the highest law enforcement officer in the state. The Division of Civil Rights, right? Department of Law and Public Safety, Division of Civil Rights. Here's the current Attorney General. This was created in August 2018. We're now in 2020. The New Jersey Real Estate Commission, let's read this. It says, New Jersey Real Estate Commission requires every licensed broker or salesperson with whom you list your property to give you a copy of this notice. The purpose is to help you comply with the New Jersey law against discrimination, which they refer to as simply the LAD. Now, you're not giving people the LAD. You're giving them the Attorney General's memorandum about the law against discrimination. You're not giving people the law, you're giving them the document about the law. So it also talks about some of the federal laws prohibiting discrimination in the sale or rent of property. Now, in New Jersey, it's illegal to discriminate against any of the prospective or current buyers or tenants because of, now they're going to give you the laundry list of protected classes that we have in New Jersey. And they are race, creed, color, national origin, sex, gender identity or expression, marital status, civil union status, affectional or sexual orientation, familial status, pregnancy or breastfeeding, actual or perceived physical or mental disability, ancestry and nationality, domestic partner status, civil source of lawful income used for mortgage or rental payments, or liability for service in the armed forces of the United States. See, remember I told you about that one? They added our military there now as a protected class. It's also illegal to place any advertisements or make any statements or utterances that express directly or indirectly any limitations to offer housing or real estate based on any of those characteristics. So basically they're telling you they don't even want you joking around about discriminatory issues, right? And they're telling you that if you think somebody has a disability, they just became a protected class. I had an issue with this one once before too, with familial status and pregnancy. I had a case one time. We'll get to it in a second. Okay, so state and federal law applies to a wide range of activities such as advertising, selling, renting, leasing, subletting, assigning, and showing property, including open land that's used for residential property. And here's some of the issues that come up frequently when enforcing the LAD. Now, discrimination based on the source of lawful income used for mortgage or rental payments means, for example, that a landlord cannot reject a prospective tenant because he or she intends to rely on Section 8 rental vouchers, FEMA vouchers issued to Superstorm Sandy victims, or any other type of rental subsidies. I usually have people write another one in the book over there. I have them write TRA, because this is one that's common in New Jersey. It comes from Catholic Charities in New Jersey. It's TRA is short for temporary rental assistance. But it's a common one and it's a big one. So I just have people add it there just for your own edification, not for exams. It basically says if the source of lawful income is lawful, you cannot deny people where they're getting their money from. You cannot deny renting to somebody because of where they're getting the money. So if they're on government assistance programs, for example, it's a lawful source of income. So you cannot deny them rental. You can't be like, oh, I don't want any of them Section 8 people because they're collecting Section 8 rental housing vouchers, subsidies, okay? Now, that payment is actually pretty reliable. If your rent is in the same price range that Section 8 is willing to pay, I don't know why you wouldn't want Section 8. It's a direct deposit into your bank account. They don't even give you a check.
I just said to myself, that's guaranteed money.
That is guaranteed money in the bank. Now, the thing is, this becomes an issue because a lot of people get put into the breadbasket, you know, or what do they say, throwing the baby out with the bathwater, you know. There's some horror stories with people who are collecting Section 8 benefits, and it's legitimate. But the majority of the people collecting Section 8 rental vouchers, they're good people, they work, and they just don't make a lot of money. So they need that extra subsidy to help them get by, to be able to afford a place to live. But the nightmare stories are so awful that it really puts a picture in landlords' minds that they really don't want to deal with Section 8 people. They're like, oh, all them Section 8 people, they're all drug dealers and prostitutes, you know, and it gives you that bad rap. You know, they don't care, they're going to destroy your property. Well, listen, when I opened up my own office in Middlesex County for the first time, I was dealing a lot with rentals, and I was one of the few brokerages that was welcoming to Section 8 tenants. So the Section 8 Housing Authority, the Middlesex County Housing Authority, sorry about all that noise, the Middlesex County Housing Authority was actually sending people over to me on a regular basis for rentals. But there's some rules you got to keep in mind. You know, that person has to have the money to pay you the commission, because Section 8 won't pay commission. So if they don't have the money to pay you commission, don't work with them. You're not denying them because of their Section 8 where they're getting their money. You're denying them as a real estate agent. I don't work for free, right? Also, you should be aware that some people that are collecting Section 8 benefits don't drive. Ask them, do you drive? Do you have transportation? Because I'm not going to be your chauffeur, okay? I could tell you a couple of bad stories I had with Section 8 tenants too, but there's for the most part, the majority of Section 8 tenants I dealt with were good tenants. You know, they just didn't make a lot of money. So it's guaranteed money coming from the county, okay? It's Section 8 benefits are based on the county. You get them from the county. So if you're moving from one county to another and you're collecting Section 8 rental vouchers, you need to get permission and approval. You need to get, first of all, permission from your housing officer, and then you need to get approval in that new county now. Otherwise, they may not be getting the Section 8 benefits in a different county. So that's something you need to be aware of as well. So Section 8 is meant to be a temporary housing assistance. Some people end up being a permanent thing because maybe they have like a permanent disability or something, and they need they can't work, so they get a Section 8 rental voucher to help them. The county pays their rent or part of the rent. I've seen some people that they're only getting maybe $60 towards their rent, or other people it pays the entire rent. Or other people, it pays the entire rent except for $20. The tenant has an obligation to pay $20 and they don't pay it sometimes. Well, you know what? You could evict those tenants because they did not pay their rent. Even though it's only $20, that's their portion of the rent. They need to pay it. If they're not paying it, they can get evicted for it. And you should contact their housing officer and let them know they're not paying their share, they're abusing the benefits, and the housing officer can then revoke their benefits. Okay, if somebody's getting just getting a subsidy and they're abusing those benefits, report them. Because I remember asking, because I had some really good landlords, and you can't turn down, you can't deny Section 8 tenants. So I had some really good landlords, and I had a legitimate concern because I did see my fair share of bad tenants, and I said, how can I protect the landlord This guy's a good guy. He's a good landlord. You know, he means well for any tenant. He don't care who he rents to, but I'm looking out for him because, I've seen a couple of harsh cases. And their housing officer told me, well, this is what you do. You treat them like any other tenant. The landlord has the right to interview a tenant and deny them if they don't like the person. They don't want that. They don't feel comfortable with the person, as long as it's not for discriminatory reasons. And as long as it's not because of the source of lawful income, a landlord still has the right to interview tenants and see if they're suitable, if they get along, if it's somebody they want to rent their place to, as long as they're not discriminating. They also have the right to inspect their apartment. They should put something in the lease that with like 24 or 48 hours notice, the landlord can come in and inspect it to make sure they're not damaging it. And if they are, start eviction and then reach out to me that they're abusing their benefits, and I'll revoke their benefits. They won't get them anymore. They'll have to get a job and try to make up the difference. This is a benefit they're getting. All right. So you try to quell landlords' concerns that way too, by letting them know that this is a possibility of what they could do in the event that the tenant turns out to be bad. Okay. I know they don't want to be in that place to begin with, but you cannot turn down the person's source of lawful income. Can't deny them because of that. All right. Now, a no pets rule. This is another conversation we were having the other day. A no pets rule cannot be enforced to prevent a person with a disability from using a service or guide dog. And a landlord may not charge a tenant with a disability an extra fee for keeping a service or guide dog. Now, in this meeting that we had the other day, nobody knew anything about this. People think they know, but they don't know. I got more information about this. I've been doing research about this to offer CE classes on this stuff. Basically, this is defined by federal law. And a lot of people are kind of sketchy on the details of it because it's so vague. And so therefore, it's not that sketchy. People try to overanalyze things sometimes. The law about service animals, the federal government did not want to put too many restrictions on the person with a disability who had the need for the service animal. So can you get your service animal registered through an online website?
Yes.
No, you can't. Those are all scams. Every single one of them. You have to meet with a doctor. You have to meet with your doctor, and you need a legitimate medical reason to have a service animal. And your doctor has to write you a prescription for it. And that prescription has to be renewed every 2 years. And landlords do have the right to request a letter from your medical doctor that you do have a need for a service animal. They don't need to know what the reason is behind it. They just need, from a medical professional, they need to have on the letterhead of the doctor that you have a need for a service animal, and then they can't deny it. But those websites, a lot of them are scams.
But I have a question. I have a service dog.
Okay.
And I have the registration and a certificate that he's a service animal. I use it for everything, like to fly with him. And it's legit. I do have also a psychiatrist, psychologist, a letter that I have to renew every year. It's not every 2 years. It's every 12 months. You have to renew that letter.
All right. So you went to a doctor or you got it through a website?
The certificate first, I got it through a website. Then I went to a psychologist to get a letter from him.
Okay. It's different if you go to an actual doctor, but anything you do online through a website, they're all bullshit. They're all scams. Because most of them have here, let me pull up a couple of them.
But I do use it to fly everywhere in the country.
Well, a lot of people use them, but they're not real. They're not. first of all, if you have one that says that you could go to a website that you could search the database to see, to search your animal's registration that certifies that they are a service animal, think about that for a second. We have HIPAA medical privacy laws. That would be a clear violation of those HIPAA laws. Right there, that should be your first indicator it's a scam. So a lot of people think they have service animals and they really don't. Because they paid a fee and the website told them they had their doctor certify them. It wasn't even a real doctor. You know, you have to actually meet with a doctor and get a prescription for that service animal. Do you have to have a card or that you carry around with you
Yes.
for a service animal?
Totally, yes.
No, you don't.
Well, I mean, they asked for it. They
Federal
said-
law says that it's too much of a burden on the person with the disability to have to carry around a certificate with them or a card that they have a need for a service animal. So under federal law, you're not required to carry any kind of evidence that it's a service animal.
Mhm.
Does a service animal have to have a harness that says that it's a service animal on it?
Not
No,
a-
they do not.
No.
Okay. But a lot of them get them anyway,
Yes.
but you're not required to have that.
Mhm.
Okay. When you go to businesses, they're limited in what they could ask you. The only thing they could ask you is that a service animal? And what function does the animal perform? I think that's all they're limited to ask that they could ask. All right. See, the problem with it is because the laws were so broadly written, there's a lot of confusion out there, even amongst the professionals. So what happens is you get a lot of these scam websites that come out there and people think that they're paying for and legitimately getting certified these animals, because a lot of these sites look real, they look legit, they even sound legit, they may even have like some governmental terms in their name. Let me try to pull one up over here and show you some of these examples, because I got a bunch of them.
But they also don't allow every breed to become a certified animal support.
Well, that's another thing. There's no restriction on breeds for service animals.
No.
None. Now, your municipality may not allow pit bulls because you have a municipal ordinance pertaining to that, for example, just giving you as an example.
Yeah.
But under federal law, there's no breed restrictions. There's not even animal restrictions. You see people with service peacocks. Remember a couple of years ago, a lady tried getting her service animal peacock on the plane in Newark Airport?
I saw a pony. In
It was in the news. Yep. That's why, I don't know if you guys ever listened to New Jersey radio station. I haven't listened to it in a while because I haven't been driving to work, but New Jersey 1015. They talk about all kinds of New Jersey issues and things that happen here. And a couple of years ago, they had all the airports in New Jersey, and the tri-state area pretty much, they updated their policies on service animals in the airports because it was getting ridiculous. And then you've seen all these activists that started screaming and yelling, and they didn't know what the hell they're talking about. They're all screaming and yelling, it's discriminatory against the people who have the need for the service animal, blah, blah, blah. So the two radio show hosts, they said, well, okay, let's look into this. Let's play devil's advocate. Let's look at both sides of the story. Let's listen to your argument. So they pulled up the new policy that was written down by the airports over here in New Jersey and the tri-state area. And they're like, let's take a look at these airlines, what their new policy is on service animals. And let's start off at the top here. Let's see what it says. And it says, no, it started off like this: no venomous animals. Venomous? What the hell are people taking on a plane? Pythons? You know, snakes that have poisonous snakes? You know, why not? They could be a service animal, right? Okay, so let's go on down the list. No hooved or horned animals. What, like a bull, a horse, a pony, a goat? People are trying to take them on the planes.
Yeah.
If you don't put restrictions in place, people will try to stretch it as far as they can. The one lady with a peacock, imagine sitting next to her in a plane. Peacock spreading its feathers all in your face. Yeah, you got to, I mean, you got to laugh because some of these laws are so ridiculous, you know, that people take advantage of them. And, you know, it's a shame though, you know, because you get the scammers out there that'll try to take advantage of the laws. You give them an inch, they're going to take 10 miles, you know. Let me pull up this service animal stuff here. Sorry. I'm going to pull up a legitimate resource that I have here from the Humane Society. Okay, here's one from Animal Legal Center. Okay, this gets too technical. I don't want to give you that. I have a resource on the HUD website. Okay, about fair housing and animals. Okay, FHEO. Okay, yeah, this is too technical too. I don't want to get into that one either. Here's the one from the Humane Society. Oh, jabuja, look at them faces. All right. So here's the law. Here's from the Humane Society. This is a nonprofit organization. This is a legitimate organization. And they kind of try to break down and simplify the laws on here for you. So the Fair Housing Act, they refer to it as FHA here, the Fair Housing Act, is a federal law that prevents discrimination against tenants in their homes. Under the Federal Fair Housing Act, a disability is defined as a physical or mental impairment which significantly limits a person's major life activities, even if a lease says no pets or restricts pets. Landlords are required to make what is called a reasonable accommodation to allow pets who serve as service animals, which includes animals who provide emotional support. Now, those are two different kinds of animals that provide a function, and emotional support animals. And I'm assuming you have an emotional support animal.
Yeah.
So assistance animals are different legal classification than pets who are not assistant animals, which is why pet restrictions and fees are waived for them. They're animals that work, assist, or perform tasks and services for the benefit of the person with a disability, or provides emotional support that improves their symptoms of a disability. There is no official certification or training, so you don't have to take them to a certified class, to a special class to get trained by a certified professional trainer, because federal law says that that's too restrictive on the person with the disability. How come that person with the disability can't train them themselves? Now, I'm sure most people can't train their animal not to crap on the floor, let alone how to perform some of these advanced functions, but federal law does not restrict them in that way. Because it's funny, because when I was listening to that radio show, people were calling in, oh yeah, I got a service animal and they need to get trained by certain places and they got long lists and it's expensive to train them. Well, in your experience, you had somebody trained and you got your service animal from a professionally trained place. Sure, it will be expensive, but guess what? They don't need to go through that. You could train them yourself if you knew how, right? They're animals that work and assist and perform tasks for the benefit of the person with a disability or emotional support. There's no official certified training for assistance animals, and they can assist in a wide range of ways. Breed and weight restrictions do not apply to service or assistance animals. That's what you're talking about before. Okay, so the difference between service animals and assistance animals. Service animals are categorized as animals trained to do a specific task for their owner. The most common is a service guide dog, you know, for blind persons. But service animals are also allowed in public accommodations because the owner's need for that service animal at all times. An assistance animal can be a cat, a dog, or other type of companion animal and does not need to be trained to perform a service. The emotional or physical benefits from the animal living in the home are what qualify it as a animal as an assistance animal. A letter from a medical doctor or therapist is all that's needed to classify the animal as an assistance animal. They don't need to be entered into a database. They don't need to have a permit. You need a letter from a doctor. Now, the fact that the term service animals often used by landlords and public housing authorities to refer to both service dogs and assistance animals is what creates the confusion. So some examples of assistance animals are a cat that can detect and alert their companion of oncoming seizures, a dog who alleviates a person's depression or anxiety, a cat who reduces a person's stress-induced pain, a bird who alerts their hard of hearing companion with their high-pitched whistling, right? When somebody comes to the door, yeah? So it doesn't have to just be a dog or an animal of a certain breed, you know, it could be different species too. This is why people start getting crazy with the snakes and the peacocks and the, you know, give them an inch, they take 10 miles, right? So demonstrating your pet is a service animal, you should provide your landlord with a letter from your doctor or therapist stating that you have a disability and explaining your pet is needed to help you cope with this disability. They refer to this as a reasonable accommodation, okay? So attach a brief personal statement explaining to your landlord that you're asking for a reasonable accommodation, and then under federal law, they can't deny you, and state law. If your landlord refuses to accommodate, landlords must agree to a reasonable accommodation request if the disability claim is true, and if the request does not create a hardship on the landlord or other tenants. If you're, so basically, if you got a dog that's constantly barking, you can't control it, the landlord can evict you even if you do have a legitimate service animal. So if your request for a reasonable accommodation is denied by the landlord, you have the right to request from a governmental agency to investigate your claim that the landlord's discriminating against you. You have several options for filing the complaint. You do it through the HUD's website, through local, etc., your state's agency. So housing that's covered by for the Federal Housing Act or the Fair Housing Act for the animals. All types of housing, including public housing, are covered except for rental dwellings of four or less units, where one unit is occupied by the owner. Single family homes sold or rented by the owner without the use of a broker. Housing owned by private clubs or religious organizations that restrict the occupancy of its units or lodgings to its members. Can a homeowner charge a fee for having a service animal? Well, service and assistant animals are technically not pets. So a no pets rule does not apply to them. Owners do not have to pay pet fees because it's not a pet. It's a service animal. So the landlord, however, can charge a security deposit and may seek money from the tenant if there is any damage caused by the animal to the home. Also, if there's a nuisance issue, the landlord does have the right to try to remove the assistant animal through legal proceedings to the court. It's the same thing in a business. Can a business deny you bringing your service animal into a business?
No.
They have to allow it in. However, if you cannot control that service animal, if that dog is barking and snapping at people or just lifting its leg and urinating or crapping anywhere, you don't have control of that animal. They could ask you to leave.
Mhm.
A lot of times people with service animals think that, you know, I can do whatever I want, you know, not so. So anyway, I just wanted to share that little resource that I had there with you.
Thank you.
Discrimination based on familial status prohibits discrimination against families with a child or children under 18 years of age, and that includes pregnant women. I actually had an issue with this one time in Roselle, I think it was Roselle Park. I had an issue with this. I had I had well, they were renters, actually. They were my clients were the renters. It was not my listing. But I set up for them to show a condo in Roselle Park. And there was a husband and wife, and they had 2 children, and she clearly had one on the way. So I'm showing this unit, and the landlord had to open the door for us to come in to show it. So as they're going through the condo and checking it out, the landlord pulls me to the side and says, "I'm not renting to them." I said, so I pulled him to the side. I'm like, "Shh, keep your voice down." I'm like, what's the problem? And he said, "I'm not renting to them. I'm not going to get in trouble to renting to too many people." I'm like, "What are you talking about?" He said, "Roselle Park has an ordinance, no more than 2 people per bedroom. And there's already 4 of them. And she's going to pop any day now." This is what the guy said to me. "She's going to pop any day now." That's how he spoke to me. I was just like, oh my God. I'm like, "Listen, I advise that you, first of all, keep your voice down, and you don't say anything to them like that unless you want to get slapped with a lawsuit so fast it's going to make your head spin." I highly suggest that you speak to an attorney before you deny them. They didn't even say if they're interested yet. Before you deny them a rental because she's pregnant, because he said, that there's 4 of them already. There's only 2 bedrooms, and the town only allows 2 occupants per bedroom. He said, "I don't want to get fined by the municipality because I'm renting to too many people." Well, first of all, that baby's not here yet, so you can't count the baby, right? Look, in the eyes of the law, isn't that the argument for people that are advocates of abortion, right? They say, well, it's not a child, it's not born yet, it's not here yet, it's nothing, right? So then you can't count it yet as an occupant either, right?
Yeah.
So it works both ways. So now I told that guy, and he ended up going and consulting an attorney, and the attorney told him that I was accurate in my statement. You actually cannot count, even when that child is born, you cannot count an infant as an occupant until they reach 24 months of age. So they're going to have 2 years that they could stay there after the baby's born, and you're still not going to be in violation with the city. But as long as that tenant goes in there knowing that once that child reaches 2 years of age, you got to go, because you're going to be in violation now for renting to too many people. All right. But that was fine because they were looking for a place to rent for maybe a year or 2 while they save up money to buy a house. So it ended up working out. They ended up renting it, and all was well. But this guy was freaking out because he didn't want to get fined by the municipality. But the way he expressed it, sometimes the way people express themselves is something, I ain't renting to them. She's going to pop any day now. Could you imagine somebody talking to you like that? Well, whatever. All right. Okay. So discrimination. Let's see. Landlords must permit a tenant with a disability at the tenant's own expense to make reasonable modifications to the premises if such modifications are needed to give the tenant full enjoyment of the premises. All right, so can the landlord prevent a tenant from making modifications to the rental unit? Well, not if they need it, but at whose expenses? Who's going to pay for those modifications?
You just said it.
I know. I want you to repeat it.
Oh, the tenant has to pay.
I don't give trick questions. I just want to make sure people are absorbing what I'm saying. You know what I'm saying?
Yeah,
All right.
I'm here.
And okay, so now if that tenant moves out, can the landlord require them to put the premises back to the way they were before?
Yes.
Well, only if they cause a problem for future tenants to fully enjoy the premises. For instance, if they have to put in a wider door in order to accommodate a wheelchair, is a wider door going to be a problem for future tenants? No, they're probably going to like it. It's easier to move the couches in and out, right?
Yeah.
So So they're not required to put a narrow door back in, you know. Now, things like ramps and stuff like that, that's a different story, you know. All right, but that stuff's expensive, so they'll probably be removing it anyway. All right. Penalties. We already went over this, but it's right here on the Attorney General's memorandum itself. If you commit a discriminatory housing practice, you violate the LAD, that's the New Jersey law against discrimination. That's not a federal law. So who enforces the LAD?
Attorney General.
Attorney General. What's the name of the form? Yeah, the Attorney General. All right, so the fines are $10,000, $25,000, and $50,000 for respectively. Okay. Now, victims of discrimination can also recover economic damages related to discrimination, like having to pay for a higher rent elsewhere if a landlord refuses to rent to them, as well as damages for emotional distress, pain, and humiliation. In more egregious cases, a victim may also recover punitive damages. Now, here's a note here about us to the homeowner. The broker or salesperson with whom you list your property must transmit to you every written offer they receive on your property. How soon?
Wait, yes,
Within 24 hours?
Within 24 hours, correct. And brokers and salespeople are licensed by the New Jersey Real Estate Commission, and their activities are subject to general real estate laws of the state. What are they also called? The laws of the state.
11.5.
4515.
Oh my
Title
God.
45, Chapter 15. Those are the New Jersey statutes or the laws. Now, 11.5 is the commission's own rules, which are also known as
Administrative code.
the administrative code. And the broker or salesperson must refuse your listing if you indicate an intent to discriminate based on any of the protected classes. Okay, so there are some exemptions to the LAD. The sale or rental of property, including open land, whether for business or residential purposes, is covered by the LAD. So in most cases, the following sales or rentals are exempt from the LAD. Renting one apartment in a two-family dwelling if the owner lives in the other apartment. Renting a room or rooms in a one-family dwelling, pretty much that's your roommate then, right? A religious organization can give preference to people of the same religion when selling or renting property. That's an organization, not an individual. You can't be like, I'm only gonna rent to Catholics or Jews or Muslims. You know, this is for organizations. That's a different story, not for individuals. Now, in certain types of housing designated for older persons, it's not unlawful to discriminate based on familial status. Okay, I got that exemption, and that is that for the Attorney General's memorandum, which is about the New Jersey law against discrimination. You got to remember, you don't give people the LAD, you give them the Attorney General's memorandum that talks about the LAD, right? Close that out. Oh, you know what? Well, I do a little research. I'm going to play something for you. If I can find it. That's it. There you go. There you go. So I'm going to play you a video about an example of discrimination and guilty knowledge and some of those other factors that play in there. All right. And one other thing, hold on a second. I want to bring something else up for you too. It's another topic somebody brought up. Here's one on New Jersey 101.5 site, but this is actually an issue that they actually brought up the other day too, as New Jersey, the state of New Jersey, I guess they're addressing it as a whole as well. As far as landlords go, this is not just about Section 8 tenants, but it's a matter of discrimination, where discrimination and intimidation really, here's a case where a landlord in New Jersey was demanding sex from women renters if they wanted to remain as renters there. That's this type of intimidation and harassment that won't stand as well. This was in Elizabeth. Interesting. Oh, wow. Oh, okay. Ooh, I was about to say, that looks like a building. I know somebody who lives in there. Okay, no, that's not. Okay, wrong building. All right, never mind. Okay, so let me bring up a video for you right now. I want to show you about an agent injecting themselves into discriminatory practices here. Here's a good way to lose your license. Once it starts playing, I'll transfer it to the screen.
High rise in Columbia. No African Americans living there. Is there a reason? Good evening and thanks for being with us.
All right.
High rise in Columbia. No African Americans living there. Is there a reason? Good evening and thanks for being with us. I'm J.R.
And I'm Darcy Strickland. The reason could lie with one real estate agent. A News 19 investigation uncovered what appears to be active discrimination inside a prominent Columbia high-rise.
News 19's Johnny Chappell has been working on this story for months now, and he joins us with the details.
A lot of us here put a lot of work into this story, and we hope that we can bring some possible good out of it, J.R. and Darcy. Who has the right to tell you where you can live? In January, I started looking to buy a new home. The very first place I visited, a realtor told me that for 25 years, the building had remained exclusively white. Her comment sparked our investigation, and our investigation has the federal government looking to take action. Looking up from anywhere between 5 Points and downtown, it's hard to miss. 1829 Senate Street, a 30-year-old high-rise, 19 stories of high-end housing. In all, 96 luxury condos. The Heritage, all white on the outside, and there's a woman who may be trying to keep it all white on the inside.
Wow. Wow, that's a powerful line. Imagine you're a real estate agent and you're in the news and they're talking about you like that. This building's all white on the outside, and we're going to introduce you to an agent that's trying to keep it that way on the inside too. You don't want to be in that news story.
Ann Bryant is a longtime Heritage resident. She's also a realtor, and she shows just about every property that comes up for sale in the building. After my experience, we sent a team to investigate.
I'm going to take you to see my son's unit.
A News 19 employee, her sister, told Bryant they wanted to see what was available. Bryant showed them 2 occupied condos before going inside a condo for sale on the 12th floor. At the time, the residence was not on the market. Bryant said she thought it would list for around $170,000.
When I have a listing anymore, I mean, I need to put it in the computer because if it's just, they go like that.
And she said that all prospective clients and their realtors go through her.
I meet people to show them the building. I mean, if it's another agent showing, I meet them.
Bryant went on to indicate that race determines whether she allows a person to see or inquire about purchasing property.
And I'm very careful when I make this statement. We do not have a mixed neighborhood. And I think that.
How careful is she? What the hell is she talking about? I'm very careful when I make this statement. We don't have a mixed race in here. What the hell?
Because we try to be careful and we try to not disrespect nobody. People just like them. I work with them all the time. It's just that they tend to talk too much.
Well, that part she got right.
She makes those differences appear black and white. Those statements marked the third time we had heard Bryant referring to possible discrimination. She said it to me during my visit and to another News 19 employee during a previous trip. We showed the tape to Dudley Gregory, who's with the U.S. Department of Housing and Urban Development.
That conversation is enough to give me pause and that I would want to look further.
Gregory said Bryant's behavior very likely violates a federal law. Under the Fair Housing Act, a realtor cannot discriminate in 7 protected areas, including race.
Okay, this is a little bit older, so when they start rattling off some of the protected classes, they may be missing some in there, but
The issue is, how many people have been to that place that are minorities that have been denied to even come through the door?
Local realtor Shelby King says those licensed in her field must complete class time every 2 years to keep up to date on the Fair Housing Act.
We are reminded about fair housing constantly.
King cites standard clauses in buyers and sellers agreements that deal with the law. She says there are certain things a realtor cannot discuss when showing a property, and that sometimes she's had to steer clear of a client's questions.
And they will usually preface the statement with, I'm not prejudiced, but what's the mix of the neighborhood? And I cannot address that.
So why would Ann Bryant, who's required...
you know what? Let me stop there for a second. I've had listings before where I had people call up and they start asking questions about the place and they say, well, who lives there? And I'm like, well, nobody. The place is vacant, or you'll get it, or it'll be delivered vacant. Or what other answer could you give when somebody says, well, who lives there? People, right? And they're like, well, no. I mean, who lives in the neighborhood? You know, are they, you know, are they mostly whites, blacks, Indians, Hispanics? Are they mostly singles or married couples? Now, we're not supposed to discuss any of that. We could talk about the real estate till our heart's content. All right. That's our job, to talk about the real estate, to sell the real estate, not who's living in the area. That's irrelevant to the purchase or sale of this house. You should always flip it back to, why are you interested in purchasing it? If you come on down, I'm sure you can walk the neighborhood and talk to the neighbors and see if it's a place you like to live. That's a good way to approach it. All right. Not to get into these conversations. First of all, you never know who you're talking to. So if you misspeak, you know, you can, there's something that we call testers. They're undercover mystery shoppers that are kind of acting like these undercover reporters here. They pretend to be buyers and renters. They have no intent to buy or rent. They're there. Yeah, I mean, if I ever dealt with a tester, I would consider them wasting my time, because I'm not discriminating against anybody. I'm looking to make money. This is my job. I'll rent it. I'll sell to whoever. But their job is they are volunteers. They're not hired by HUD. They're volunteers. We call them testers, that they act like they're buyers and renters to make sure you're not discriminating against anybody and you're treating everybody fairly and equally, and you're not engaging in any discriminatory practices. So you'll need to know that for exam. What do we call them? Testers. Now, why does it work? Because now you're on alert, because even if you are a racist or discriminating for whatever other reason, you're not going to do it, because you never know who you're dealing with. And that's why it works, which is how it should be anyway.
By her profession to adhere to a federal law, risked losing her license. She agreed to meet us at the Heritage for an interview. You said you showed most of the properties here. To the best of your knowledge, have you ever discriminated based on a person's race as to whether or not they can live here?
Anybody can live at the Heritage. We have no discrimination of any kind in the building.
She denied ever talking about race with potential buyers, even after I told her about our investigation. We've had several people come to us and say that you say that this is not a mixed community, that it's only white people are allowed to live here.
No, I've never made that statement to anyone. I would certainly lose my license if I did a thing like that. We do not have a mixed
Busted.
But I've never made a statement like that.
So here's what's happened as a result of our investigation. Today, Ann Bryant submitted this letter to her employer. She's retiring from real estate effective immediately. to remind her agents that they
Now you may be thinking, wait a minute, she's going to get off easy like that? She's just going to surrender her license right now? You mean it's not going to get taken away from her? Hold on.
her agents of the importance of this issue, her former employer is requiring each agent to sign a second ethics policy. Also, I've spoken with the president of the Heritage Homeowners Association. His comments: we don't discriminate in any way at all on the issue of why Bryant has been on hand almost every time a prospective buyer looks at a condo for sale in the building. The president said, quote, she is not authorized by the board to show property. After viewing our tape, HUD opened its own investigation. HUD officials have told us their attorneys will be able to make a decision based on the possible violation of federal law very soon. And of course, J.R. Narshi will keep you posted.
Well, Johnny, has this realtor had any past incidents?
We found out today, yes, she has. In 1997, a couple filed a claim against Bryant's former employer, naming her and her realtor as accusing her of steering. That's a practice referred to right here in the Fair Housing Act. Protected class, what type of housing or location would or not be appropriate for them, steering them in that direction. Her employer settled that claim, and Bryant had to pay a fine for that offense. So certainly a lot coming out of this story still to come, and we're going to continue to follow it in the next couple of days.
All right, Johnny, thank you.
Well, we also contacted the State Realtors Association after our investigation of the Heritage, and this is how they responded to what we uncovered. Realtors adhere to a high standard of integrity and a code of ethics that requires equal access to fair and affordable housing for all, regardless of race, color, religion, sex, handicap, or
Well, at least you're trained to. And, you know, what you do after you get out of this class, what you do after you take a code of ethics training class, you know, that's all on you. I mean, you can lead a horse to water. You can't make him drink, right? But this is interesting. Stay tuned. Continue paying attention to this.
national origin. Go on to say, as realtors, we deplore and will actively pursue action against any member whose actions run contrary to the federal or state fair housing laws or the Realtor Code of Ethics.
Well, we would like to get your feedback on our investigation of the Heritage. There are two ways you can voice your opinion. 299 voice the comments tomorrow.
So there's some follow-up here, which you usually don't get in news. This is why I like to show this news story. Now, this says, was it in 2005, HUD launched an investigation and reached out to a settlement with her broker. Bryant had to give up her real estate license, but she died last year. But that's not the end of it. The real estate agent who was doing the discriminatory stuff is dead. She's not even alive anymore. Her broker still got sued and got awarded a settlement of $90,000. Because it's a matter of guilty knowledge, right? Was the broker aware that that the discriminatory acts were occurring? And it's not an excuse to say, well, I didn't know, because should he have known, you know, especially with that particular agent who had a history apparently of discriminating, and why she was fired from her previous broker, which is interesting. So there it shows you a little bit about a lot of the stuff that we learned just in one video there, which was, I like to show those live examples. Sometimes they sink in a little bit better. Okay, so here are the protected classes in New Jersey. You know, they're on the Attorney General's memorandum. I kind of updated them here a little bit on this slide. Race, creed, that's doctrine of religion. That's what creed means. I had to look that up for some people. Color, national origin, sex, gender identity or expression, marital status, civil union status, affectional or sexual orientation, familial status, pregnancy or breastfeeding, actual or perceived mental or physical disability, including AIDS, HIV, and COVID-19, ancestry, nationality, domestic partner status. I'm not sure why you would have domestic partner status there anymore. Governor Christie signed into law gay marriage a couple of years ago. So I'm not sure what domestic partner status would entail now then. Source of lawful income used for mortgage or rental payments, liability for services in the armed forces of the United States, and it's illegal to make any statements or utterances directly or indirectly about any of those characteristics. Okay. Covered by the LAD is refusing to lease, rent as a means of discrimination to somebody, or refusing to offer the property or negotiate on transactions as a means of discrimination, or lying about the availability of the property, changing the terms. Okay, a lot of this is the stuff that I've already read, actually, so I'm going to kind of go through it a bit. All right, the next thing that we're going to learn about. You see zoning discrimination, Mount Laurel 1 and 2. You guys turn a page. Zoning discrimination, Mount Laurel 1 or 2. You guys see that heading, that section?
What page is that?
Page 75.
Let's see.
Yes.
It's after the LAD, or the Attorney General's memorandum, I'm sorry. All right, so let's highlight the title, the zoning discrimination, Mount Laurel 1 and 2. Okay. What to highlight in here? On the third line, just highlight the words exclusionary zoning. My slide is probably the best thing to study from. I explain it better here. What you need to know for exams. Exclusionary zoning is, well, first of all, you guys know what zoning is, what zoning laws are? Zoning
Like sectioning off the town.
Yeah, zoning laws are powers that are given to the local government that could be used, that could dictate the lot size, setbacks from the property line that any structure can be built, the types of construction materials that are used, or what can be built where. Actually, those are building codes, but what can be built where. Those would be covered under zoning laws. What kind of property can be built? Is this residential, commercial? Can a high rise be put here, or a certain kind of structure? Those are the kinds of things that are dictated, the kinds of powers that are given to municipalities with zoning ordinances. Exclusionary zoning is what this illegal practice, discriminatory practice, came to be known as. You need to know that term, exclusionary zoning. It's a discriminatory zoning practice that was outlawed by the Mount Laurel court decisions. There were 2 court decisions. And they said that municipalities cannot discriminate against low income or poor people. Now, so this is what you need to know for exams. An illegal zoning practice that discriminated against low income or poor persons through discriminatory zoning practices. Exclusionary zoning. What's the law that made it illegal, that outlawed exclusionary zoning? The Mount Laurel decisions. Boom. That's it. That's all you need to know for exams. Okay? Good?
Yeah.
Study that. You will get it on exams. Understanding that the way I just phrased it. Now, let me give you a little story about real life. Okay? Because the laws are written one way and it sounds great one way. Now you may be thinking, why would a municipality engage in a discriminatory zoning practice like this, and how would they implement such a discriminatory practice? How would a municipality use zoning laws to discriminate based on poor people, saying that they couldn't live in the municipality? Well, by saying that, it's kind of a dishonest statement on its surface. Let me explain to you what happened here in Mount Laurel. So Mount Laurel is a town in New Jersey. And in Mount Laurel, New Jersey, years ago. What happened was the town was not a wealthy town back then. The town wanted to improve their services to the community. They wanted to improve their policing and fire and have better roads and schools. And where does a municipality come up with the money to fund these things?
Taxes.
Taxes, property taxes, right? Now, what are property taxes based on? How do they base how much they charge you for property taxes?
The schooling, like how good the school is?
Well, no.
How good the school?
No.
Okay.
Lot size?
Not that.
And what determines how much money that you pay?
The lot size? The lot size and the zoning? I don't know.
Well, contributors to it, but it's ultimately the value of the property.
Okay.
Gotcha.
The general real estate tax that everybody pays is actually called, in Latin, it's called the ad valorem tax. And in Latin, ad valorem means according to value. Yes, we're going to be learning a little Latin in this class. Some of the legal terms are Latin. So ad valorem means according to value, and that's how that general real estate tax is based, on the value of the property. So if you've got a lot of cheap homes in an area, they're never going to be able to raise the values of it. Now, there's nothing that municipality can do over the homes that are already there. They're grandfathered. You know, if they change any laws, they can't force somebody to tear down a house and put up a bigger, nicer house that they could charge you higher taxes on, right? But they do have powers over anything. Like if they change any zoning laws, it would affect any new construction in a town. So the way that Mount Laurel decided, hey, for us to be able to get more tax money, we need to have more expensive properties here. Now, the way that it started at the beginning is Mount Laurel has a lot of history. During the days of slavery, there used to be something called the Underground Railroad, where blacks were escaping slavery in the South to the North. And a lot of families that escaped through the Underground Railroad settled in Mount Laurel, New Jersey. And when they settled in Mount Laurel, New Jersey, they built homes. There was no zoning laws. You could build shacks, you know, one-person homes to live in, you know. So people built a lot of small homes, like right on top of each other, right next to each other. There's this whole row of homes on this one street that I seen a picture of this, and I read this article in one of those newspapers down there, and it referred to them as altered or customized or oversized chicken coops. So it kind of shows you that it kind of builds that picture in your head that they're kind of shacks, right? So yes, you're not going to have a lot of value to them. You're not going to be able to collect a lot of taxes on them. And if they're built right on top of each other, you know, if the town keeps that kind of zoning that homes can be built that close together, they're never going to be able to build more expensive homes there. So the way for them to be able to raise the values is by requiring any new construction to have a larger lot size, right? Okay, that makes sense, right? Can we all agree on that that makes sense?
Yeah.
All right. So we don't want homes built right on top of each other. That's understandable. I mean, we see some towns, some older areas of some towns where homes are like you could open the window and touch the other building, right? I mean, they're that close. So this is that kind of a scenario. So I can understand that they'd want more distance between it, larger. You'll raise the revenue, the value of homes. I can understand that. However, Mount Laurel went a little bit overboard. I'm not sure what the minimum lot size is that they went to. So I'm just going to make up a number just so that we could discuss it in class here. Let's just say that they made a new requirement that you couldn't build a house unless you owned at least 1 acre of land. That's a lot of land to own, right? In order to build a house. Now, keep in mind, I'm making that number up. I'm not sure what the actual lot size is. I just know that it was a larger lot size that was ridiculously large. So I'm going to go with 1 acre. So now they didn't create a various zoning throughout the municipality. They just said, if you want to build a home anywhere in our town, you got to own at least an acre of land. So people started buying acres of land and building mansions on them. All right. If you're building mansions on them, that's going to increase the value tremendously. But what is it also going to do to the cost of the land to acquire the raw land? Goes up too, right? So it got to the point that a lawsuit was filed by the NAACP against Mount Laurel, New Jersey, saying that by creating this restrictive zoning law, you're effectively pricing poor people out who can't afford to buy that much land, especially as property values continue to rise. So this Mount Laurel, the end result of the Mount Laurel 1 decision ended up coming up with this at the end. So let's read this. It says, in 1971, the lawsuit came to be known as Mount Laurel 1, filed by the NAACP against the town of Mount Laurel, New Jersey, for illegal discrimination against low-income and moderate-income persons through the use of exclusionary zoning. And I just showed you how they excluded poor people by requiring larger lot sizes that were ridiculously large and effectively pricing them out of the town. So the court stated that all developing communities had to zone for their fair share of the regional need for low-income and moderate-income families. So in 1975, the court ruled that the poor may not be excluded from residential areas. Okay, fantastic. Sounds good. So they can't price people out of the town. So that means that they need to be able to provide that range of housing, especially for low-income and moderate-income families. Okay, this really isn't targeting moderate income though. Now in 1983, the town of Mount Laurel, New Jersey came out with a Mount Laurel 2, a second lawsuit by the NAACP. Okay, first of all, can we agree the Mount Laurel 1 decision was good? You know, you have to provide a range of housing. You can't price people out of the neighborhood by requiring these ridiculously large lot sizes. So the Mount Laurel 1 decision put an end to that. It said that you had to provide a range of housing for lot sizes so that people can afford to live here. Now, in 1983, the Mount Laurel 2, the second lawsuit filed by the NAACP against Mount Laurel, New Jersey, resulted in courts providing specific guidelines for developing communities. That is a lie, or it's not accurate. The courts required municipalities to come up with their own guidelines. The court did not provide specific guidelines. This second lawsuit said that municipalities have an obligation to provide their own written plan on how they're going to meet the requirements of allowing more people from different I guess affordability zones, for smaller lots, larger lots, etc. They had to have a written plan of how they were going to get more low income and affordable housing built. Now, because the courts did not set specific guidelines on how the towns were going to accomplish that or should accomplish that, some towns created the guidelines, some didn't, because they were so vague with that request. So this was accomplished by allowing for higher density developments. That means being allowed to build homes closer together than normal. And a 20% set aside. All right, now they're not clear about that, so I'm going to just assume that a 20% set aside means that for every 100 homes built, 20 of them need to be for low and affordable housing, right? Low income and affordable housing. Zoning for mobile homes has to be established, and a requirement that communities must cooperate with efforts to obtain subsidies. What are subsidies? It's a dirty word. It's money. All right. Why don't they just say that? A requirement that communities must cooperate with efforts to obtain subsidies. And a panel of judges appointed by the Chief Justice in New Jersey was set up to hear cases of hardship that people who have been disenfranchised by these laws or disaffected by these laws. All right, so Mount Laurel 1 decision said you can't zone people out of the town. Okay, good law. Mount Laurel 2 decision said now that not only can you not zone people out of town, the community has to make an active effort to try to provide a range of housing and to have a written plan on how they're going to accomplish that goal. But they didn't give any guidelines on how to accomplish that goal. So the majority of the municipalities in New Jersey, still to this day, have no written plan. However, they do get the money from the state and federal government to ensure that the housing gets built, and the municipalities have to keep tabs. They need to keep a written plan. For every 100 homes built, 20 need to be built for low income and affordable housing. When? It doesn't say. It just says you got to keep tabs on it. It needs to be built, but it doesn't say when or where.
But how does that happen? Like, how do you set a price on a home for low income if we have taxes and?
Well, it's not setting the price on the home. It's saying that you have to make sure that it gets built. First of all, municipalities are not landlords, right? They're not the ones that are building the low income housing and hosting it for low income people to live in. How would a municipality incentivize that getting built? Well, maybe they'd give tax breaks to a developer to come in and build affordable housing or low income housing, right? That's the way municipality does it, because municipality is not in the business of being a landlord. So they could use some of that subsidy money, I guess, to offset the tax dollars, and they could keep that, right? Or does it say where they need to be built or when? No. So a lot of municipalities are keeping tabs on the numbers, but they haven't built a lot of this low income or affordable housing. There's nothing in the law that says when it needs to be built. There's also nothing in the law that says where it needs to be built. So you're getting a lot of these communities now. This basically, I'm saying this law is full of loopholes. So,
right.
So you're getting these municipalities that are collecting this money, and then they're going to neighboring towns, say like Newark, and saying, hey, Newark, take our subsidy money. We'll give you our subsidy money if you take on the obligation to build that low and affordable housing in your community.
Now my question, because in Mount Laurel, like I get it here in, well, not here, but in Hudson County, they have, and Essex County.
Oh, there's a lot of it. There's a lot of it.
Right. In Passaic County, they have a lot of apartments that are rent controlled and subsidized. However, how do they incorporate that in houses?
Well, they can't.
Right. That's why I'm like.
Well, the thing is, there's no written plan on this, first of all, because the courts were so broad and they're just saying, hey, we want, this is our utopia. This is our dream. This is what we want you to accomplish, but we don't know how to do it. So we're not going to tell you how to do it. We just demand that you do it. Okay. And so therefore municipalities, most of the municipalities out there said, no. They didn't say they're against it. They just said, we're not going to put a written plan together that we're going to hold ourselves to, because how do we do that? All right. So the second law, well-meaning intentions, trying to get municipalities more involved in this now. However, it's sloppy written, right? Can we agree on that? Mount Laurel 1 decision, good idea. Mount Laurel 2 decision, good intention, poor execution.
Right. It's like they kind of gave up, like give them something or we'll take it, just we want this over.
Mm-hmm. Now, unfortunately, now's one of those times where we're going to start injecting a little bit of politics into this, because throughout this class, we have to, unfortunately, I don't care if you're left, right, in the middle, I don't care where your views are. My point is, you need to know that politics plays a role in real estate, and pretty much everything, the taxes, everything that we do in real estate, pretty much politics plays a role in it at some level. So I'm going to show you an example of what a dirty game politics is, and it has become. You know, I mean, it's always been a dirty game, but it's gotten worse over the years. I'm not a big fan of Governor Christie to begin with. Okay, I mean, his first term, he was all right. His second term, he fell apart. He was horrible. Now, during his second term, though, he still did some things that were good, actually, but for the most part, he was awful the second term. But if you guys remember, there was a national news story, and it came about, I think, because he was also throwing out there that he may run for president, right? So, you know, you get the left and you get the right, they're going to attack each other anytime that they get, right? Apparently, you can't be a Republican or a Democrat and not curse at each other. You know, you can't or work amicably together to achieve goals for the greater good of the public, which is your job to begin with as a politician. And a good example of this was there was one point where Governor Christie actually tried doing a good thing. He reached out to all the politicians because the governor does not make the laws. We have governing bodies of politicians that do the legislation, that they're the ones that create the laws and they pass them. And then once they pass them, they put them across the governor's desk to sign. So the governor, because they can't create the laws, Governor Christie went to the politicians, the left, the right, and he said, listen, guys, these Mount Laurel decisions, they're not doing what they were meant to do. This law is not creating the housing that it's supposed to be doing. It's failing. The money keeps going out the door, but the stuff's not getting built that's supposed to be. The rules, it's full of loopholes. There's kickbacks. There's all kinds of crap that's going on. We need to do away with the Mount Laurel decisions, he said, and we need to replace it with a new law that doesn't have the loopholes in it. We need you all to sit down and write a new law, hash out a new law to fix the problem. Now, so that's what he said. Now, what ended up happening in real life in the news? Governor Christie proposes racist legislation to do away with protections for low income and minority persons by doing away with laws that protect them. That's what we heard in the news. And we heard that for a couple of weeks until he's like, okay, I see this is going nowhere. And he threw his hands up in the air and said he dropped it. But he got attacked. He got attacked in the national media for the next 2 weeks over that statement that he made for politicians as a suggestion for them to sit down and write a new law because this law was broken. He got portrayed as being a racist, trying to do away with protections for low-income persons and minorities. And you wonder why nothing can get done in this state. You know,
Right.
So there's just a little dirty look into that. And I'm no fan of Christie, but you know what? I'm just showing you that this is it's a bad thing. This is why we're so full of corruption in this state. All right, anyway, so exclusionary zoning, because a lot of these municipalities did not have a written plan in place now on how they're going to build that additional housing. There's a lawsuit that came to be known as Builder's Remedy. Remember, they say in the second lawsuit, they put together a panel of 3 judges to listen to hardships for people that are disenfranchised by these rules. Well, the lawsuit is called Builder's Remedy. And you can do Google searches on Builder's Remedy, New Jersey, and find tons of cases. It's a lawsuit against a municipality by someone like a builder who's been disadvantaged by the local zoning laws. Now, what was the purpose of these Mount Laurel decisions again?
Fair housing.
For low-income persons, right?
Right.
Well, this lawsuit of Builder's Remedy allows a builder where a municipality, if the builder wants to build something in your municipality and the local zoning department says, no, you cannot build your project, whatever it is that you want to build, whether it's low income or not, whatever it is. A builder can check to see if that town has a written plan on how they're going to address the Mount Laurel decision in number 1. Remember, it said that they, I'm sorry, number 2, that they have an obligation to create these specific guidelines that most municipalities do not have. If a municipality does not have those written guidelines on how they're going to accomplish their goals, a builder who's been denied being able to build whatever it is that they want to in a town can sue the town for something that's called builder's remedy. And under the guise of the Mount Laurel decisions, they could use that as a way to circumvent the municipality's zoning laws, where the judges, if they agree to it, they could just say, builder, you could ignore the zoning laws and build what you want. Let me give you an example. Anybody familiar with the Cranford Trading Station? Cranford area?
Said the train station?
Yeah.
Yeah, you know where the train station is in Cranford?
Yeah.
Mhm.
You guys know what they built across the street just the past couple of years? They built the
There's like a Starbucks, burger,
they built all those storefronts with the luxury apartments or condos above it.
Yeah,
I
they're
never
building more
even
down the
noticed on
street
top
too.
of it.
Is that stuff low income?
No,
The area isn't low income.
like the #1 downtown in Jersey.
Yeah, but I'm telling you, that building right there is nothing low income about it. You know how they got the permit to build that? Because that was all zoned 1-family houses there. The town of Cranford would not give them permission to build any of that because it was all zoned for 1-family houses there. So how did they build these luxury condos or apartments above these storefronts, and everything there is expensive? There's no low income housing in there. The builder sued Cranford because the Cranford does not have a written plan of how they're going to address these Mount Laurel issue. So they sued them for builder's remedy, and they used this as the reason to get their project built. They ignored the zoning laws because Mount Laurel didn't have a written plan on how they're going to address the low income housing issue. And yet they used that as the excuse, but what they built was not low income housing. This perfectly describes what Governor Christie was explaining. It's full of loopholes. So this is what it is, okay? What do you need to know for exam? Exclusionary zoning, a form of discriminatory zoning practice that was outlawed by the Mount Laurel decisions that discriminated against low-income people. Boom, that's all you need to know for exam. But for real life, you guys are gonna be in the real estate business. Maybe you're going to want to do some development projects, or you're going to have a client that does. And if you get turned down from the local zoning board, what you could do is you can look into that town to see if they have a written plan of how they're going to address the Mount Laurel issue requirements. If they don't have that plan, sue the municipality for builder's remedy. And then you'll get the permission to build whatever the hell you want and ignore the town. Okay?
Wow.
I'm just teaching you the rules. You know what? I don't make the laws, but if you got some of these people that I'm sure are politicians and rich people that are taking advantage of it to begin with, why shouldn't you? Right? If you know the rules, that's you know the game, right? So take advantage of the game until they fix it. You take advantage of it as well. I just want to give you that little golden nugget as well. All right? You don't need to know that for exams, but it'll serve you well in life. If you're into building and construction at all, or you got clients that will be. All right, that'll make you a nice knowledgeable realtor there too, by the way.
An investor as well.
Don't know this. A lot of real estate agents, they take this class, they just know exclusionary zoning. It's illegal discriminatory zoning against poor people. Ask them, okay, how? I bet you they can't elaborate. They can't tell you that it's because they increased the zoning lot sizes, and then that went back to court and was a Mount Laurel 2 decision. I bet you none of them will explain that to you. I bet you a lot of instructors that teach this stuff don't even know. The only reason why I know, I never dealt with this personally. I did a lot of research on it because when I started teaching, I don't want to start teaching stuff that I was clueless about. Students asking me a million questions, and then I'm sitting there, like a bump on a log or trying to make stuff up. I do research. I find out. And you guys don't need to trust my word for it. Do Google searches, search online, search search for a New Jersey builder's remedy, and then read up on the cases that come up on the websites. Educate yourselves, right? I did some research. I'm just sharing it with you, but don't believe me. Check yourself, okay? Anyway, you're welcome for that. But this is on
Thank
exam, exclusionary zoning. Who did it discriminate? Who did it exclude? Poor people, okay? What law made it illegal? Mount Laurel decisions. Moving on. So this slide is good to study from. The book, not so much. You'd have to write a definition like I have here, because the book doesn't really give you a good enough definition for the understanding of it. Okay, and if you want to write that, builder's remedy, that's that lawsuit, which I got it written in my book too. I wrote down builder's remedy there. All right. Moving along. Code for Equal Opportunity, HUD and NAR have fair housing partnerships. They often come together to try to create community development programs to bring real estate agents together with local communities to try to create neighborhood beautification projects and try to educate the community about how to get involved in housing ownership. You know, that's basically what that cooperative is about. So nothing much there for exams or anything to talk about. All right, implications for brokers and salespeople. Brokers should always have an office policy, like we saw in that video I showed with that one lady discriminating. It's a good idea for brokers to have their own written office policy that even though you take this class and you know you got to follow the state and federal anti-discriminatory laws, it's a good idea for brokers to have policies as well that give guidance to their agents about what they won't tolerate, okay? They should have that the HUD Equal Opportunity Housing poster and the New Jersey one posted in their office space. They should have a prominent display of the sign stating that discrimination is against the company policy as well as state and federal laws. These are just suggestions for them. Make proper responses to your clients when they express discriminatory desires. And look, I touched on it before, but then I kind of changed the subject a little bit. I had this one, this happened many times, but I had one listing that I got tons of traffic on where people will always call up. They say, yeah, who lives there? I'm like, well, a lady's living there, but don't worry, it's going to get delivered vacant. And they're like, well, no, who lives in the area? You know, I know what they're getting at. So, you know, you could play with people a little bit. You could say people. Well, if you're interested, come on down. You can take a look at it, introduce yourself to the neighbors, talk, see what's going on in the neighborhood, see if it's a place you want to live. You know, I can't talk to you about the people that live in the area. I could lose my license for that. That could be discriminatory conversation. And the juice ain't worth the squeeze on that one, buddy. I am not going there with a 10-foot pole, right? So you guys have to try to answer these questions in a diplomatic way when people call you and ask you questions about who lives in the neighborhood, right? You simply say, oh, I can't discuss those things. You could come down, take a look if you're interested, meet the neighbors, and you know, that's probably the good way to say it. All right. Now I had this one other lady that called up and she said the same thing. She's like, yeah, who lives there? And she's like, no, in the area, you know, are they mostly these people or those people? Are they single? Are they couples? And I'm like, she sensed my irritation because this is like the 500th phone call I got in this listing. So I was like, ma'am, I can't enter into that conversation. I could lose my license for that. That could be discriminatory. If you're interested in a property, come on down. You can meet the neighbors. And she was like, no, you got me all wrong, in her New York accent. You got me all wrong. She's like, me and my husband, we're New Yorkers. We want a more diverse area. And so who lives there? Ma'am, it does not matter what your stated reason is for asking it. I cannot enter into that conversation. So she tried to, you know, to justify it. Oh, I'm not asking because I want to discriminate. I want a more inclusive neighborhood. Well, then come down and talk to the neighbors because I can't talk about who lives here. You guys got to remember that. Somebody, you could get a tester on the phone that's trying to test you to see if you're going to answer those questions. And they could get you like that too. Trying to act like their reason for for asking is totally harmless, or that I'm looking for an inclusive neighborhood that's a mixed neighborhood. All right. It doesn't matter what your reasoning is. We can't engage in that conversation. And you guys are going to have to find a way to talk about it, because the question will be asked and we're not allowed to talk about it. So you got to find a way to say it without being offensive to people or without accusing them of discriminating or anything like that. So you got to try to find a way to say it. And sometimes it's difficult for people to talk about race and religion and you know, all those other factors, you know, that come into play. You know, look at, if you can't discuss it, how are you gonna cure a problem if you can't even discuss it, right? So, but I just tell people, listen, I can't talk about those things. I can talk about the house. You can come down, you can meet the mayor, the mayor. You can come down, you can meet the neighbors, the residents, and see if it's a place you want to live. Boom, end of story. Okay, reverse discrimination is also a thing. Where's that? Okay, on page 76, implications for brokers and salespeople. In the first paragraph, last sentence, we're going to highlight, in order to be found guilty of discrimination, the complainant does not have to prove guilty knowledge or specific intent, only the fact that discrimination had occurred, which is something I told you guys about 10 times already. Somebody doesn't need to prove that it was your intent to discriminate. They just need to prove that a discriminatory action had occurred in order for you to be found guilty of discrimination. And if we go down to the fourth paragraph, it talks about how you should answer people if they ask you about who lives there. I just told you about 3 or 4 times. They give you a little bit more of a robotic answer. It says, if somebody asks you for a preference based on housing, based on the race of the people that are living in the area, they suggest that your response should be as follows. I cannot give you that kind of advice. I will show you several homes that meet your specifications. You will have to decide which ones you want. Okay. You got to make it flow a little bit better, but in essence, that's what you're saying to them, right? Did I put you guys to sleep?
No.
Okay.
That's right.
Okay. I know it's boring stuff. We're almost done with it. Last paragraph, highlight reverse discrimination. Regulations are intended to preserve racial balance in a given area. All right. But what was the very first paragraph I had you highlight there? The complainant does not have to prove guilty knowledge or specific intent, only that discrimination occurred. Yeah, reverse discrimination is it is still discrimination. It's got it even in the term. It's a form of discrimination that's meant to correct past wrongs. All right. Yeah, but in essence, now you're doing another wrong. 2 wrongs don't make it right. Okay, just from now on forward, do things right. Right. That's the way to do it. Otherwise, you're always going to have people arguing with each other, and it's never going to end. So I'm not going to. What's that?
What was the last thing you said to highlight?
Oh, reverse in the last paragraph there. Reverse discrimination regulations are intended to preserve racial balance in a given area. Now it goes on to say local laws sometimes run counter to federal and state laws, because what have I been teaching you this whole time about discrimination? It's inclusion. As long as you're not excluding anybody, you should be fine. But now over here with reverse discrimination, now you may be thinking, well, how's that going to be affecting me? Reverse discrimination. I'm not discriminating against anybody. Well, sometimes, once again, it'll be politicians that'll create problems for you. They try to correct past wrongs by trying to meet quotas, and that doesn't sound good either when you're using the word quota and talking about people's race in the same sentence. But they're trying to put a balance, I guess, to having more people from different backgrounds involved in housing. Listen, what I've been teaching you is people can choose where it is that they want to live. We should not be steering them in any direction because there's already enough of these people there. So we need to get some other people there. You know, just by describing it like that, that sounds racist, doesn't it?
Mm-hmm.
So if a politician's telling you to do this, I'm going to tell you, ignore it. Let everybody move where they want to live, and try to put your head down and see what happens. All right. Now, I know that, you know, you get some politicians, especially these days, people are becoming more and more activist like, and that's going to cause a problem for us if it actually seeps into the real estate business here, that there's regulations that are going to be put into place, because it's to be in violation of these federal anti-discriminatory laws that we already have in place. I know just a couple of years ago, the FHA was FHA, HUD cooperative, whatever, something was going on in the federal government that they actually spent millions of taxpayer dollars to create, for lack of a better term, race maps. Now, these race maps were meant, the meaning of them, why they're putting them together, was to try to create more integrated communities throughout the United States. All right, and they start with first mapping out who lives where by combining census data on maps and superimposing them. So, for example, white people would be a blue dot on a map. You know, Asian people of Asian descent, you put a red dot on the map. Black people, you'd put, I don't know, green dot on the map. You know, you get different colors, dots would represent the different people from different backgrounds. And actually, President Obama did a speech on this, and he said that his vision is to have nice mixed communities. Now, the way to do that is he wanted to put together these maps, and anybody who's trying to get housing using government funds, insured loans, guaranteed loans, funds that are kept in lending institutions that are insured or in any way related to the federal government, that, and real estate licensees. There was a warning he put out to real estate licensees that in the future, they're planning on trying to implement a standard that would require that if you have a client that wants to move to a certain area, but there are already too many people of that race living in that area, then you would have a requirement to look at this map first and zoom out on it. If it's not a nice blend of purple, which is a mix of all the colors, then there's too much of a concentration of people from a certain color, and you wouldn't be able to get them in there. You would have to steer them somewhere else. But we already know steering's illegal, so I don't know how they would accomplish that. All right, so that ended up going nowhere. That law ended up falling flat on its face. But there was still but still millions of dollars have been put towards this. And there are still some politicians that are pushing this kind of an agenda. You may be hearing something else about with real estate, and sometimes with the presidential election, you heard an argument about zoning and doing away with suburban communities. Now, that was kind of glanced on. President Trump never got into the details of what he meant by that. He's got a lot going on in his head when he says stuff, but people don't get it because he's not explaining it. There's a proposed legislation that they put away to do away with single family zoned neighborhoods, so that basically you could put multifamilies, apartment buildings, low income housing in one family neighborhoods, suburban communities. Well, let me ask you a question. If you do that, I live in a neighborhood where it's all one family homes here, suburban community. If you put up an apartment building next to me, what would that do to my home value?
Lower it.
I would think that
drive it down.
I would think that it does, wouldn't you?
Mm-hmm.
All right, so I mean, it's just common sense will tell you that. But the politicians want to keep telling you something otherwise. And there's people that are pushing an agenda to try to do away with single family neighborhoods, which they refer to as suburban communities. In reality, what a suburban, do you guys know what an urban, suburban, and rural areas are? I think I think I got a map actually written here somewhere. Is it in this chapter? Nope, it's in one of the other chapters. All right. An urban area is defined as a densely populated area. You have a lot of people living within a close proximity of each other. Suburban is people are spread out a little bit. They're a little bit farther away from each other. Instead of having hundreds of people in an apartment building, you have maybe homes that are a little bit further apart from each other. And then rural, you can't even see your neighbor, you know? People are much further apart from each other. So that's the way you would define urban, suburban, and rural. Urban is densely populated. Suburban is a little bit less densely populated, and rural, they live far away from each other, okay? So they're talking about doing away with the suburban area, and really there's no reasoning for this of why they would want to do this, because there's plenty of room to build our housing still. It's just a matter of, you know, New Jersey. Did you know that the majority of the state of New Jersey is undeveloped? We are the most densely populated state in the United States, the most densely populated state in the United States. And the majority of the land here is not developed, is undeveloped. And also the highest tax. Okay, so testing, we already went over that. They're undercover mystery shoppers to test to make sure you're treating everybody fairly. All right. They're not paid employees, because that would be entrapment if they were paid by HUD to go out and pretend and try to gotcha, you know. That would be entrapment. So instead they're volunteers. All right. Now let's go over the advertising rules and we're done with this chapter. First, on page 77 under testing, I want you to highlight testers or checkers are undercover volunteers who want to check whether customers and clients are being treated the same, because that's in effect what they're trying to do. Turn to page 78, and there's a chart here for advertising. I like to go based off the chart instead of reading all the paragraphs here. I like to just explain it on the chart. If you want to read the paragraphs, you could read them. They give you an idea of what you can and cannot say in advertisements. Now, listen, you guys can have conversations with people in real life like this, but in advertisements, whether it's on television, written ads, or newspapers ads, print ads, TV, radio, there's certain things that you cannot say in an advertisement because it could be misinterpreted as being discriminatory. And here's the basic way that it works. I got a slide up in front of you here. There's a category, a rule, what's permitted and what's not permitted. So basically the general rule is the same all the way down. You can't express a discriminatory preference or limitation. Now let's go with the first category, which covers race, color, and national origin, where people are from. No discriminatory preference or limitation can be expressed in your advertisements. You are allowed to use terms like master bedroom and good neighborhood. How racist do you got to be to consider the term master bedroom a racial term still? Does anybody know what a master bedroom is?
The main bedroom in the house? Is that what you mean, or why people get offended?
Well, a lot of people, I mean, you could gather why people get offended by it, because I mean,
yeah, how
racist you got to be to consider that a racial term. But actually, a lot of people, the reason why I'm asking it has nothing to do with the racism part. The reason why I'm asking, because a lot of people that are in real estate have no idea what a master bedroom is. Too much watching of HGTV. HGTV will tell you the master bedroom is the largest bedroom in a house. False.
I was gonna say that.
You know what a master bedroom is? Not every house has a master bedroom. A master bedroom generally is the largest bedroom in a house. However, it is a bedroom that has a full bath in it.
I was gonna say that as well.
If that bedroom does not, look, you could have houses that none of the bedrooms have a bathroom attached to it. Well, then you don't have a master bedroom. Not every Not every house has a master bedroom. So I'm teaching you some good basic real estate stuff here too. All right, what's not permitted? You're not allowed to say white neighborhood or no French, you know? Religion, pertaining to religion, no preference or limitation can be expressed. You are allowed to use terms like chapel on premises, kosher meals available, or Merry Christmas. All right, well, Merry Christmas is a greeting, so why shouldn't you be able to say that? Now, chapel on premises. I want you to be careful with this. Chapel on premises. Okay, if you're in a building or inside a complex that has a chapel there, well, you're just describing a feature that's on the premises of the property. That's why you're allowed to say it. You're not allowed to describe features that are in the community, in the area. That could be deemed discriminatory. Look, for example, if I say there's, let's look at what's not permitted. No Muslims, nice Christian family, walking distance to synagogue. All right, now here's the example. If I say the synagogue is nearby, what am I telling you?
That it's a
Islamic
neighborhood with-
area.
I'm telling you there may be a lot of Jews in the area. So that could be kind of like a dog whistle, right? Hey, watch out, there's Jews in the area. Or, hey, Jews, come on, you're welcome here. It could be interpreted either way, right? So chapel on premises is not saying, hey, like that's like saying, hey, there's a church down the street. What am I saying? Christians, right? Generally speaking. So chapel on premises, however, is saying this is actually on the property. It's a feature on the property. We're not allowed to say walking distance to synagogue, or the church is down the street, or the mosque is down the street, or what have you, because that could be interpreted as a dog whistle that these people of this religion are in the area. You're welcome, or look out for them, you know? So in your written advertisements or radio or TV ads, you know, you could say, like, for devout Jews, it may be important for them to be within walking distance to a synagogue. That may be important to them. You know, they can't drive on the holy days, they got to walk, right? So a lot of times when you're selling homes for Jewish people, they may say they want that put in the ad because it's a selling point. And I've had that before. When I started working up in West Orange, I worked in Livingston. Livingston's got a big Jewish population there. And you had I had this one lady one time, she said, you know, it's important you put that in the ad. She's like, because the house is within walking distance. That's a selling feature. I said, to who? And she's like, well, to Jewish people. I'm like, exactly. I'm like, I cannot target people of a certain religion. We can put in our advertisements general things. I could say within walking distance to houses of worship, but I can't, because that's more secular. It does not target a particular religion, right? And then if it's important to somebody, they're going to ask, well, is that a mosque? Is it a synagogue? Is it a church? And then I can answer their question. But in your advertisement, you can't address all those issues. So, and you don't want to seem like you're targeting either, because the law makes it illegal for you to do that. All right. And the MLSs will fine you if you put that in the MLS, walking distance to the synagogue. Even though it's an important feature, I would say walking distance to houses of worship. Okay. And then you could elaborate if that's important to somebody. All right. Now, sex, yes, please. No, it goes, no discrimination or no discrimination or discriminatory preference or limitation can be expressed. Okay. It's the same thing for all of them, the same rule. Permitted, what are you allowed to say? You are allowed to say in-law suite or mother-daughter or female roommate sought. All right, let's break this down. We're talking about features of a house again. Anybody know what an in-law or mother-daughter is? It's the same thing, and but sometimes it's called an in-law suite, or sometimes it's called a mother-daughter. It's a single family house. It's zoned one family house. So but it's set up like a 2-family house. But you can't rent out the other unit because it is only zoned a 1-family house. Now, why do we call these in-law suites or mother-daughters? Well, perhaps for an in-law suite, maybe, here, I'll give you an example of a client I had last year. I got a friend, they just got married, and the husband's father is kind of elderly, and they want, single, elderly, the mother died years ago. So he wants to keep a close eye on his dad, but he doesn't want them all up in their business. You know what I'm saying? He still can get around and do his own thing, and they want to keep him close by and let him have his independence, but not be intruding on their life either. So it's kind of having this like 2-family setup in a 1-family house. It's called a mother-daughter. It's a nice feature to have, okay? It could be like a studio apartment or whatever set up there, but it cannot be rented separately because it's zoned 1 family. Okay, now, so you are allowed to use that, and it's not considered discriminatory against people who don't have families or that are not married or don't have children, okay? It's describing the feature. Female roommate sought. How's that not discriminatory? You're targeting a gender, aren't you?
Mm-hmm.
Yes, however, it's allowed because you're targeting a gender that's going to be sharing the same apartment that you're living in. It's a roommate. You could have some young college age girl, she's renting an apartment and she's got another bedroom and she wants to get somebody to help pay the rent. So she wants to have another girl her age coming in there to share the apartment. She doesn't want the old guy creeper. Oh yeah, I'd like to live here with you. She wants to, she would feel uncomfortable like that, right? So she wants somebody of the same sex in there, and she'll feel more comfortable that way. That's okay. It's allowable. However, if it was an apartment that was vacant that you're looking for a renter for, you cannot target based on their gender. You see the distinction there?
Mm-hmm.
All right. Now, what's not allowed? You're not allowed to say great house for a man. Why not for a woman or the other 192 genders they came up with recently, right? What about a wife's dream kitchen? Why has it got to be a wife's dream kitchen? First of all, it's only good for married people? Wife's dream kitchen? What about gay people? They may have a problem with that. What about single people?
Why can't a man cook?
And why can't a man cook? My point exactly. Look, at least in my family, the guys are better cooks than the women anyway. So
yeah, right.
Man cave. Look, you could talk to people. You could be showing a house and say, wow, this would make a great man cave down here for you. That's how you sell it. You're puffing it, right? But don't do it in a written ad, okay? Man cave is targeting a gender, right? So you can't do that. Same thing with this one, she shed, right? The she shed. I got a link here to the YouTube video for that, but I actually got it on my, got that one on my computer here. I know that for a fact. He burned down my she shed. You guys know that one, right? No.
I do.
Yeah, those what's that Geico commercial? Those
State
Geico
Farm?
commercials.
Yeah.
I think it's State Farm.
State Farm.
Oh, is it State Farm?
Mhm.
He burned down my she shed. What the hell is that? I was just looking at it before.
So you're saying that it's okay to say certain things when we're showing the homes, but it's just we can't put it in an ad?
Yes.
Okay.
Yeah.
Because
it's that's not a discriminatory statement. Hey, this would make a great man cave down here for you. I'm just making conversation, I'm not discriminating against anybody. But if I put it in an ad, people get hypersensitive these days. They get they start thinking that you're discriminating against them because you're targeting a gender, because everybody's an activist these days, and I don't know what the hell's wrong with them. They lose their mental reasoning, everybody's not out to get you or attack somebody, I don't know.
Yeah.
That's basically what it boils down to.
Peyton.
Why the hell may I find this?
I have a question.
Yeah.
Do these same things apply to like, if you're the agent for a rental property?
Yeah, these are for all advertisements for any real estate agent. You
Right.
should avoid these terms.
Cause I know like usually on Airbnbs and whatnot, I know that's like different. That's like you're renting straight through the owner. But
Well, you know what?
it'll-
They're not excluded from the laws either.
on like almost all the postings, it'll be like, oh, 5 minutes away from.
Did you just hear me? They're not
Yeah.
excluded from, if you're a for sale by owner, you're an owner of the property and this is your house. You're not excluded from the law. You need to follow these laws. You can't be discriminatory. You cannot be advertising in a discriminatory way either. So
No, I'm talking more so in like where you have walking distance to synagogue.
yeah,
Like a lot of like Airbnb ads will usually say like walking distance to here or 5-minute drive from here. I don't know if that's like a little different or.
well, within close walk to shops, near the bus stop, those things are fine. Jogging path, things like that, nearby, you're describing the features. That's not a problem. But some things like when you're talking about religion, like the churches, the houses of worship, stuff like that, that could be deemed discriminatory because it could be like, oh, you just don't like Jews, so you're talking about synagogues, you're making a dog whistle. Or you could be like, oh, you are a Jew, so you only want other Jews, you're targeting them for a certain area, right? So, I mean, people could twist things to sound however perverted they want it to, they could pervert the real meaning of the intention of the ad. And they often, unfortunately, do. So that's why we're not allowed to put those kinds of terminology, those kinds of terms that could be misconstrued by the uber hypersensitive types.
Understood. Thank you.
You're welcome. No problemo. All right. Oh, it's right in front of me. I keep passing by it. I'll show you that little video.
Well, it finally happens, actually. Somebody burned down my she shed. Nobody burned down your she shed, Cheryl. Well, my she shed's on. There was struck by lightning.
That's funny.
Exactly. It's my she shed covered by State Farm. Your she shed's covered, Cheryl.
Yeah.
That's it.
That's really funny. My she shade.
Well, they got that idea from, they don't make up a lot of these ideas. A lot of these things that these State Farm and Geico commercials and such, where they actually rip them off. They get them from these HGTV type channels and these home improvement channels where, you know what a she shed is? They're basically taking, they're taking a shed and maybe putting electric in it, heat, perhaps even water or a bathroom, and they make it like the getaway place for the woman, the wife, and then the husband has the man cave down in the basement where he has his bar and poker table or pool table or whatever down there, right, where he could do his manly things, or a movie theater, right? So these are just ways, it doesn't matter who uses what space. It's just the kind of terminology way we set it up, because that's what guys usually do, right? They make their escape to the basement, because ladies usually don't want to hang out in the basement, but the guys do. But until they fix it up and they make it all nice now all of a sudden everybody wants to be in the basement, right? Well, they came up with this saying, well, why should the woman be excluded? So they came up with the she shed concept over here and a lot of these HGTV programs. But either way, she shed, man cave, now we're assigning gender roles to areas of the house. It's discriminatory. We can't do it in advertisements, but you could have a conversation with somebody, and if, they get all butthurt about it, that's their problem, right?
Mm-hmm.
Yeah. Okay, so there's your commercial on the she shed. He burned down my she shed. All right. I love that. Yeah, I got some videos. I got some neat videos to show you guys as we get through this thing, as we get through this class for different topics. Little shorts like that. And every now and then I'll even throw in there a little bit of humor. Here, you want a little bit of humor? Just a short one. All right, it's from a comedy channel that I pulled up. By the way,
how much?
What?
How much is it? How much you want for it?
There we, let me rewind this one.
How much is it? How much you want for it?
You see her frustration there? You see what's going on?
I thought it was so, I thought it was somebody on the line.
She's
One of
yelling
us.
at the phone. How much is
Me
it?
too.
How much you want to it? Look at the
I
sign
thought it
in
was
the
one
back.
of our classmates too.
Hearing aid center. She's yelling over the phone to somebody
Oh,
who's
that's
deaf.
funny.
She's getting frustrated over
How
that.
much is it? How much you want for it?
That's really funny.
By the way, I got tons of videos like this on our Facebook page. If you go and you like facebook.com/Career Path Academy. I post news up there periodically too when I'm not in Facebook jail. So there you go. Let's see. I got,
Why are you in Facebook jail?
'cause somebody always gets frustrated
right.
about something that I say.
That's
right.
so funny.
Let me see. I got a great video there on our Facebook page, and I got one that I could play for you, but it's probably a little bit long. I don't know. Yeah, it's 4 minutes. I don't want to waste that time. Maybe a little bit after class, I could play it at the end of class for anybody who wants to stick around and watch it. I got one called The Realtor, or when we get to one that talks about open houses and stuff. Actually, I'll play it then during class. That one, The Realtor. That one's interesting. On Facebook, there's a nice one there that teaches you how to negotiate. Look at the one on Facebook that I have. I have a video there about teaching you how to negotiate. It's actually British humor, but it's funny as hell. The guy starts negotiating with a dentist about getting a tooth pulled, and he starts negotiating on the price. And I'll let you go and watch it yourself because it's funny as hell. Just go to the media section that I have and you'll see the video there. It's funny as hell on facebook.com/Career Path Academy. All right. And if you don't like politically correct, if you don't like politically incorrect stuff that may be slightly offensive, then don't follow me. All right. So let's see. When it comes to disabilities, no discriminatory preference or limitation. Oh, you guys aren't seeing the slide, are you? Okay. When it comes to disability, once again, no discriminatory preference or limitation can be expressed. You are permitted to say wheelchair ramp, walk to shops, walk-in closet, jogging path, or walking distance to something. And it's not considered discriminatory against people who cannot walk. See, that's starting to get into the realms of idiocy when you're, come on, walk-in closet, you're describing a feature, walk to shops, you're saying that it's with close distance, okay? Jogging path, well, that's what you do on those paths, jogging or walking path. It's not discriminating against people who cannot walk, okay? You're not allowed to put things in ads, and I don't know why you would. Here's your general rule of thumb. Keep ads positive, right? You're not going to sell anything being a negative person. Try not using negative connotations or any kind of negative wording either, like no wheelchairs or able-bodied tenants only. What are you doing? You know, you may have good intentions by saying, well, yeah, but there's no elevator there. There's no ramping available. It's all a lot of stairs. Well, then call it a walk-up. I've done that before. I've had in Edison, there's a place called the Waterford. There's no elevator. It's too steep. It's a stairwell that goes around. It's a 3-story condo unit. I was selling a 3rd-story condo unit. So I worded it in the magazine ad. I put in there 3-story walk or 3rd-story walk up. And I actually had a guy that called me and he's like, is there ability to put a ramp in there or an elevator in the building? He said, because I'm mostly in a wheelchair. He said, I could walk, but I can't walk too good. So I can't walk upstairs too much. You know, 1 or 2 is fine, but I can't walk up a lot of stairs. And I said, no, unfortunately, it'd be too steep to put up a ramp, and it's a winding staircase to get up there. I said, no, but however, I could take a look and see if there's any 1st floor units available for you there, or look in another complex in the area for you. You see, he would have never called, and I would have never been able to try to get him as a client still if I just put a negative thing in that ad, said able-bodied tenants only, or no wheelchairs, That's why you try to keep your ads positive. If you put negative things in that ad, just trying to be helpful, though, it's you're chasing away business. It's kind of like me and the sold sign riders. I don't believe in putting under contract or sold sign riders on a property, because you're chasing away potential clients. Look, until you're going to have limited time for that sign to be up there, up until it closes, and then the new owner is going to want it gone, right? So why not, even if it's under contract, just leave the for sale sign up there. People will call you up. You could get their information. What is it they're looking for? Have they been pre-qualified yet? And then get into the conversation with them. Oh, that property that they called about is already under contract. It's no longer available. However, I have a couple of other homes in the area that I think I could show you that are similar, that you may be of interest to you. And now you could start working with those people to turn them into a client. So I don't like chasing people away by putting negative wording in an ad. And then when it comes to familial status, once again, no preference or limitation. You're allowed to say 2-bedroom, family room, or quiet neighborhood, which I have no idea what that has to do with families, because most families ain't quiet, right? At least mine ain't. And what's not permitted, you're not allowed to say married couples only, or no more than 2 children, retirees dream house, no young children, or I'm not going to rent to her because she's going to pop any day now, right? But this is what you're putting in advertisements, written advertisements. You're not allowed to put that. And you can see why. It's kind of self-evident. And we're done. We're done with this chapter. So let's do the key terms to review now for chapter 4. Right? Federal law setting many protected classes with some exceptions.
Attorney General's memorandum.
No.
Oh, wait.
Federal law setting many protected classes with some exceptions.
Oh, Federal Fair Housing Act of
1968, because that's the one that has exceptions to it, right? 5 is
right.
A federal law protected classes are race and color without any exceptions.
Civil Rights Act 1866.
3 is B, Civil Rights Act of 1866. Inducing panic selling based on prejudice.
Blockbusting.
2 is C, blockbusting. I like to add little skits to things. I keep trying to create this. So I'm going to be adding these videos and stuff in the future to our shows here. I got to get one from All in the Family. You guys remember that with Archie Bunker?
Yeah.
I got to get some of those skits, because I remember with him and George Jefferson, there was some good skits with him pertaining to real estate that I could have stuck in here. So let's see. New Jersey. Oh, wait. Inducing panic selling based on prejudice. Oh, you already said that. 2 is C. New Jersey law governing discrimination in real estate transactions.
Law against discrimination.
That's the law against discrimination, the LAD. 6 is D. A refusal to lend in certain areas, usually inner city.
Redlining.
Redlining. 9 is E. Section. There's a keyword there. Section of the Federal Civil Rights Act that covers housing.
Title 8.
Title 8. 13 is F. Specific group that may not be discriminated against.
Huh?
Protected class.
A protected class. 8 is G. Court cases covering, look over here, they're not mentioning low income anymore. They just say moderate.
Oh, hi. I'm in class, honey.
Court cases
come on in if you want. Yeah, come back later. Thank you.
Let me just mute you there for a second. Okay, court cases covering low income housing.
Mount Laurel 1 and 2.
Correct. 7 is H. Channeling home seekers to or away from certain areas.
Sorry about that. Which one did I just miss? I'm sorry. Someone was
7 was H.
What about right before that was steering?
Oh, 13 was F. Wait, no, that was Title 8. That's the one you answered.
Oh, G.
And then, 8 is G. Yeah, okay.
8 is G. Great, thank you.
Channeling home seekers to or away from certain areas.
Steering.
Steering, 11 is I. Undercover checker who monitors fair housing compliance.
Tester.
12 is J. Now, next to K, next to the letter K, I want you to cross out the word benign. Benign means nothing's wrong with it, but all discrimination's wrong. So discrimination intended to correct past wrongs.
Reverse discrimination.
And is K, reverse discrimination. Federal agency enforcing civil rights compliance.
Federal Fair Housing Act.
Department of Urban Development.
Agency, yes, the Department of Housing and Urban Development, 4 is L. Statement about discrimination everyone listing property has to receive.
Attorney
General's memorandum.
1 is M. All right. That would conclude chapter 4. So now we go to chapter 5. Chapter 5.
Federal law stating. Oh.
I'm going to open chapter 5 and I'm going to open chapter 20 at the same time because we're kind of going to get sidetracked early on. We're going to start with chapter 5 and then we're going to get sidetracked to chapter 20 in this one, episode here.
5 and 20.
Or chapter 5 though. Okay. Ooh. All right, so chapter 5, everybody ready? All right, what is real estate? See, this chapter, we're finally starting to get into real estate. I know we've been learning the rules and regulations and discrimination stuff up until now. However, we've been digressing a little bit because I went off on little tangents when they started talking about words that are in later chapters. So I did teach you a little bit about real estate already. Thank goodness, otherwise it would have been really boring just going over the rules and regulations. So hopefully I've been making it entertaining. You haven't been falling asleep in class yet because this is dry material. I understand that. I try not to sound monotone for you guys and I try to keep the energy level up. I hope that I am doing that for you. So
yep, it's been fun.
Started. Awesome. I'm glad. I want you guys to have a good time here and enjoy yourself. It's not easy with this material. All right. So at the end of this chapter, you're going to be able to identify the characteristics of real estate and distinguish the difference between personal property and fixtures. Fixtures are actually part of the real estate. There are items that are considered personal property at one point, but they've been attached to the real estate that they've been made part of it. All right. The bundle of rights we're going to start with, and you can see that here on page 83 at the bottom. When you buy real estate, when you own real estate, what actually are you purchasing? You're purchasing the land and everything that's on it, and all the rights, interest, and benefits that go with that property. We call that the bundle of rights. So real property ownership is often described as the bundle of rights. I just want you to highlight that term, bundle of rights.
Hey, Victor.
Yeah.
Does that include like the airspace over it or something like that? I wasn't sure. I think I've heard that.
Yes, airspace, airspace, the subsurface rights, and we're going to be getting into all that stuff in this chapter. Okay. Yep, and we're going to be getting into all that good stuff in this chapter. I don't know if we're going to have time to get to it today, but we're going to try to. So the right of possession or season, these are all the things that are included in the bundle of rights. You do not need to memorize them all, by the way. You just need to understand this term, the bundle of rights. You need to understand what's going with the real estate when somebody's buying it. The right of possession or season is the exclusive right to possess and own the property. the right to use the property in any legal manner, the right of quiet enjoyment to keep others from disturbing you on your property, the right of exclusion to prevent others from entering or occupying your property, the right of disposition or alienation. All right. This term alienation, you should add that to your definition list. I'm going to give you a simple dumbed down definition for it, and I do have it right here. Alienation is a transfer of property. Let's just cut it right there. No further explanation, because we're going to see that term alienation. There's an alienation clause in mortgages. Alienation, that term is going to come up a couple times. So let's keep it simple. And then you could figure out what they're talking about. If we understand alienation is a transfer of property, think of it when you alienate yourself, what are you doing? You ever hear that term?
You're removing yourself from something.
Yeah, you're removing yourself. You're separating yourself from others. Why is little Jimmy alienating himself from the rest of the kids in class, right? He's separating himself from the rest of the kids, right? So it's basically what a transfer of property is. You're separating yourself from the property, right? Now, so alienation or disposition is to be able to sell or give away or lease the property or transfer it or any of the rights to another person. So there are two forms. Alienation can happen while you're alive or after you die. It could be voluntary or involuntary. What does the word voluntary mean? It means it's something that you wanted. Involuntary is something you did not want. So voluntary alienation is when you sell the property, give it away, leave it to somebody by will. We call that devise. You lease the property to somebody else. That's where an owner, what is a lease? A lease is a document that is considered personal property. It's an intangible asset. It's because it's considered personal property where an owner of real estate intentionally, you got a little noise going on there. Let me just silence you there. Where an owner of real estate intentionally conveys their rights to the real estate that they own to a tenant to occupy and possess those premises for a limited time as defined in that document that we call the lease. So the person who's leasing a property does not have real estate. They have the rights to somebody else's real estate for a limited period of time. But that could be transferred through voluntary alienation as well. A lease is a form of voluntary alienation. License is giving somebody permission to enter or occupy and use somebody else's property for a specific purpose. We'll go over that shortly. So involuntary, some examples of involuntary alienation. Once again, alienation is a transfer of property. Involuntary is when you don't want it. Foreclosure, isn't that a form of involuntary alienation? Someone's taking your property away from you. Escheat, that's the government's right to take away your property with the just compensation. They have to pay you for it. But nonetheless, you didn't want to give them your property. They're taking it from you. You don't have a choice. Partition is a court proceeding where if you have two owners that own a property together and one wants to sell the property and the other does not, can you sell your interest in the property without the other? Sure can. It's just not easy to do. How are you going to find somebody who's going to want to buy your shares of interest in owning a property with some other person, right? So that's not always the easiest thing to do, and usually they fail to do that. So are you stuck owning a property with someone else who does not want to own it? No, you do have an option. You could partition the property. Partition is a court proceeding where one co-owner takes another to court and asking a judge to see if the property can be physically divided in two, physically partitioned. And if that's not possible, then the judge will order the property sold and each of the co-owners will get their proportionate ownership shares paid out to them. So that's a form of involuntary alienation when a judge is forcing you to sell the property. Your other option would be to buy out your partner if you could. All right. And then suit for adverse possession. That's going to be an interesting one. This is a form of involuntary alienation where somebody is, it's basically like squatters' rights, right? Somebody's squatting on your property without your permission for a long enough period of time. They could take you to court and claim ownership of it. We call that an easement by adverse, suit for adverse possession, or an easement by prescription. And we'll be getting into those in chapter 6 or 7. All right. So for other additional rights that you have are the right to improve or devise. Devise means to leave by will. That's a word you need to add to your definition lists. Do not confuse it with the word demise, which I'll have a slide up just for words that are commonly mixed up by people. So I'll have a definition list for you. You don't have to write anything right just yet. So in the book here on page 84, underneath those olive branches, those sticks that are bundled together, that's your bundle of rights. Those are olive branches. And under there, in that first line, you're going to have the word devise, leave by will. I want you to write page 276 above that. Devise, leave by will. I want you to write page 276, 276. That's in chapter, what chapter? 20. Yeah, that's in chapter 20. 276 or chapter 20. We're going to be going over that in just a moment. Mortgage, encumber, cultivate, explore, mine, build, lease, license, dedicate, give away, abandon, share, trade, or exchange the property. These are all terms that we're going to learn. Okay. So, death terms, chapter 20. So we're gonna learn them here, and then we're gonna go to chapter 20 for a moment. Devise is a word I told you. It's a transfer of property by will, your last will and testaments. Does anybody here have a will?
Yes.
Okay. One person has a will? How many people have children?
I do.
One person has kids? Wow.
I have.
All right.
I have.
Okay. So you should have a will more than anybody. You don't have to have a lot of possessions to need a will. Okay. But you got kids, right? You may want to dictate who's gonna care for them when you're gone.
She's grown.
I know you're young and you're healthy, but you know what happens if you get hit by a bus tomorrow? You know, stuff happens, right? And we're all mortal, and you never know. Stuff happens. So everybody should have a will. Even if you don't have a whole lot of belongings, you need a will even more. Because if you don't have a will, then the court's going to have to appoint somebody to decide how your assets are going to get distributed amongst your heirs, and they're going to have to determine who those heirs are. So an attorney's going to have to get involved, and then it's going to become a long, legal, expensive process. And in the end, you'd be lucky if your heirs get anything. If you have a written will, a handwritten will, we call that a holographic will. It doesn't require any witnesses, and it is considered legal in New Jersey. Video wills are not legal in New Jersey. Okay, a handwritten will, it's called a holographic will, doesn't require any witnesses because it's easy enough to prove that you wrote the whole document. It's hard to forge an entire document that's handwritten, but just a signature is a different story. That's why if you have a will like Quicken Will Maker or something like that, you do the will on the software, they require 2 witnesses, and those witnesses' signatures should be notarized as well. All right, we're going to get into that in chapter 20. I'm going to show you in a little while. But demise is a word that's often confused with devise. They sound so similar, and they even look kind of similar when you see them next to each other, right? Devise and demise. Demise is the transfer of property by lease, not by death. It's the one that sounds like it's by death You finally met your demise, right? But it don't mean death. It's a transfer of property by lease. Every lease has a demising clause in it that says the landlord is to let the premises and the tenant is to take possession of the premises. Devise is the one that means death. Devise. I don't know how to try to put that picture in your head. Just think it's the opposite of what you think it is. The one that sounds like death isn't. All right. Testate is, the word testate simply means that you made a will. You prepared or made a will. Intestate means, well, you died without having a will. Testator is the person who made a will if they're a male. Testatrix is a female who made the will. This ought to get interesting when people start talking about 52 genders now, right? These are legal terminologies, okay? They've been used forever. All right. Probate is a court proceeding that determines who the heirs of an estate are after all the debts have been paid. And then your heirs can inherit whatever's left over. So look at that. What debts are they talking about? Well, they're mainly looking for taxes. That's all the court cares about. Did you pay all your taxes before you died? If you didn't, guess what? You got to pay your taxes even after you're dead. They'll take it out of the stuff you left behind before your heirs get theirs. Isn't that double taxing? No matter. Okay, so
Depends on what vehicle you left that in. It depends. Because okay.
I don't know. I bought stuff when I was alive. I paid tax for it. How come I got to leave it to you and now you got to pay taxes for it again? No. Probate court though is looking for, if you have people that you didn't pay back money that you owed to, or maybe you had income tax that you had to pay first that you did not pay. And instead of just leaving your money to your heirs, you got to pay the government still their fair share, right?
Well, if you leave it in an insurance policy, they can't tap that. They can't take money in that, can they?
Well, insurance is something different, but yeah, they still can touch that. That's an inheritance tax. That's a little bit different, but yeah. Yep. That'll be interesting. That'll be interesting to see what happens with these taxes now. There's certain people that are looking to raise these taxes right now, okay? We were looking to eliminate them last year. This year, we may be looking to increase it now. Your death taxes. Okay, now escheats is when you die intestate. What does intestate mean?
Without a will.
Without a will. And no heirs can be located. The property would revert to the state.
Wait, I'm sorry, Victor. Are you reading from the book? Or just
Right now, I'm just reading from this slide. This is stuff
Okay.
that's actually in chapter 20.
Okay.
We're going to go to chapter 20 actually right now because it uses that word devise there, and that devise is a death term, and I like to go off on my tangents. So actually what we're going to do is mark your page with something here. We're on page, what, 85 or 84? And go to page, what's on page 276? Let's go there first. That was for devise. Where's the word devise on page 276?
Wait.
That may be a page number that got screwed up there. Where did I get page 276 from? It was on a slide, right?
The olive
Oh,
branches.
down the bottom.
Mhm.
Yeah. Devise.
Page 342.
Yeah, it's not written anywhere on page 276. Yeah, that's probably all that stuff on page, what page was it? 340 what?
342.
Or 341, 342. Right. I don't know why I got 176, 276 written there.
I think
That's probably in the chapter in 13 book, the version 13 book.
Mm-hmm.
So we actually should be on page 341. Okay. Things got shifted a bit. So sorry, underneath those olive branches, then change that from page 276. I could have sworn there was something there. Page 341. Yep. Yeah, that 276 don't need to be there no more. So let me just go there and turn that to page 341. So I just want to adjust the slide here. 1 second. All right. So on page 340, 341 is where we're going to be going over and highlighting all this stuff. So right now, I'm first just going to be going over it on the slideshow with you. We'll be going over it through the slideshow. Actually, let me just open up the other slideshow too. Transfer you to the chapter 20 slideshow. So right now we're doing chapter 20, actually. We started 5 and 20 kind of simultaneously here because they discuss some of the issues in this chapter. All right. And some of these things we kind of already went over, like the word title. Title, the real estate is ownership of the land. Alienations, a transfer of title or transfer of real estate, right? And that can be done during your life voluntarily or involuntary, or after death voluntarily through a will, or involuntarily if no will is left through a escheat. What is a escheat? That's the last thing we were just going over, right?
Yeah.
So alienation of title. It could be voluntary by gift, sale. You could sell the property, lease it, give it away. You use some sort of deed of conveyance when you're transferring the ownership. If you give property to the government, if you're giving land to the government for a public use, like streets, schools, and parks, that's called dedication. And if the government gives you land, that's called public grant. Anytime there's a transfer of, when one person's giving land to another, it's by grant. Public grant is when the government gives it to you, okay? Dedication is when you're giving it to the government. If you're selling your property to me, you're granting the ownership to me. All right. The only time we call it something different is when we're giving it to the government. We're dedicating the land. Involuntary alienation is a transfer without the owner's consent through escheat, eminent domain, foreclosure because you didn't pay your debts, a court action such as a partition proceeding, or a suit to quiet title. Remember what that is?
Yeah.
If you can't link one owner to the next, perhaps we want to have a court make a decision of who the owner is. So we do this lawsuit called a suit to quiet title. Adverse possession is something we're going to be learning about in chapter 7, I believe, the types of easements, where you could take the owners, it's kind of the squatter's rights. You could take the ownership of a property if you've been using it against the owner's permission out in the open and exclusively against hostile and adverse to their title for a period of time as defined by law in the state. But that's not easy to do. Okay. Here's some of those rules for an easement by prescription. I have that in this chapter slideshow. We're going to have this and we're going to go over this in chapter 7. So I don't know about digressing on this right now too much, but this is going over those details. When you use someone else's property for a period of time as defined by law, we call that the prescribed period of time. That's the amount of time that the law says that you have to have used somebody's property before you could claim ownership of it. Now, currently, there's 3 prescriptive periods on the books in New Jersey. So there's actually 3 laws that are contradicting each other. Our politicians are doing such a good job here. They created 3 laws that contradict each other on the same topic. And they've been trying to clear this law up to settle on 1 prescriptive period for over 10 years now.
Wow.
You know, if they want to create a new gas tax, how long does it take them to do that? Trying to clear up this rule that they're all in agreement on how they want to do it, and it still takes them forever. All right. The use had to have been continuous, hostile, adverse to the owner's title, exclusive, and without the owner's approval. Because if a property owner gives you permission to use their property, you can't take the ownership from them. It's only when you've been using it against their permission for a long period of time that you could claim the ownership of it.
Which is kind of crazy.
It kind of is. And we're going to go over that in detail. And I'm actually going to show you a video of a lawyer explaining it to you because she'll do a better job than I can, at least on the legality points about that. And when we are in chapter 7. And it's this requires, it's not automatic. If you use that person's property for a period of time as defined by law, you don't automatically become the owner. You still have to sue the one owner of the property to take the ownership from them.
So crazy.
Yeah, yeah. And look, you had to have used that property for a period of time, but check it out. There's something called tacking. So if you weren't the only person that was using that property, somebody else was using it before you, you could tack on one person's time to that of the other to come up with that prescriptive period and to claim the ownership. But you had to have been successors in interest, like a tenant and a landlord, or, well, there's a lot of different forms of successors in interest. We'll go over them. You don't need to study them, but an heir, you know, a seller and a buyer. So to perfect this easement, the lawsuit's called a suit for adverse possession. Now, how can an owner prevent somebody from claiming this easement against them? Well, they could give them permission to use their property, and then you can't take it. They could cut off their access to the property, and then your use wasn't continuous. Or they could give you permission, and that resets the time clock. Or they could take legal action against the adverse possessor to get them removed from their property, which you should do, right? Somebody's occupying your property, get them the hell off it.
Yeah.
Otherwise, you deserve to lose it.
Right.
Okay, transfer of deceased person's property, intestates. Okay, let's start doing a little highlighting here. On page 340, well, you just got the word voluntary alienation, nothing really to highlight there, and then involuntary alienation. The last line under involuntary alienation on page 40, we're going to highlight when a person dies intestate and leaves no heirs, the title to their real estate passes to the state through the process of escheat. The state escheats you out of your property. Now, nobody's cheating you out of your property, but I kind of like to describe it that way because ultimately the state's getting your property. So they escheated you out of your property. It's my bad Spanglish, right? Escheat. Now, land may be transferred without the owner's consent to satisfy any debts that you had. In cases of foreclosed property, they're just showing you different ways that somebody can take your property through involuntary alienation, which I had that list up there before, so I don't need to read this again. But if you go to the end of the line of the next paragraph, it says partition proceeding. Highlight that. That's a term you should know. A partition proceeding one co-owner seeks to force another to divide or sell the property.
Sorry, where we at? What am I highlighting?
Second paragraph, page 341, second paragraph, end of the line on the first line. Partition proceeding, one co-owner seeks to force another to divide or sell the property. Plus, we will also be going over that in chapter 6 or 7 too. Again, 7, I think. All right. All right, next to adverse possession. Next to adverse possession, this was for stuff that was on this last slide here. Next to adverse possession on page 341, what I did, I dropped my pen. I did this. I put a little bracket around the, right, where is it? Where is it? I gotta get it on screen. If you can see it. Bracket over here. No. See, I put a bracket around this paragraph.
Is it all three?
So yeah, it's for all three. Under adverse possession, I just put a bracket around all three paragraphs. And I wrote 20-year, and then I wrote in the margin over there on the left side of it, there's a 20-year common law, page 100. 20-year common law, page 100. Year common law, page 100. All right. Now, in the second paragraph, we're going to highlight, or the first paragraph, second sentence, we're going to highlight that. In New Jersey, a person may acquire title by adverse possession through continuous, open, notorious, hostile, and exclusive occupation of another person's property for 30 years, 60 years if it's vacant woodland. And I had you write in the margin, 20-year common law, page 100. Just shows you, and another part of the book, they discuss it and they tell you there's 20-year.
In California, it was like 7 years.
You know what? New Jersey created this 30-year and 60-year period. A common law, if you, what common law is laws that are common through most states that don't have their own separate laws.
Yeah.
That's common law. So we have a common law in New Jersey, but we also have a 30-year period and a 60-year period. So if anybody tries suing you, they'll never win because you have 3 laws for different periods of time that are all conflicting with each other.
Yeah.
So New Jersey is going to look to get rid of the 30-year and 60-year period and make it a 20-year common law period to take the property. And they're going to add another law that says any land that used to be underwater, like if the sea levels dropped and you have more dry land, that if that land is dry for 40 years, then you can claim ownership of it.
Oh.
All right. Yes, sea levels do drop. They do not just rise, they also drop. Okay, next paragraph, we're going to highlight on the third line at the end of the line. The process is not automatic. Legal action is necessary to perfect the claim. And then we're going to write underneath that paragraph, suit for adverse possession, like I have written here. Suit for.
May you please repeat that?
Yes, under adverse possession on the second paragraph, third line, we're going to highlight the process is not automatic. Legal action is necessary to perform the claim. And underneath it, we're going to write suit for adverse possession. That's what we call the legal action.
Suit to perfection?
Suit for adverse possession, like I have written here.
Oh.
See, I keep calling it the board, the slideshow. Suit for adverse possession. All right. All right, then go down to transfer of a deceased person's property. And that's where we're going to highlight intestates on the second line without having left a will, because that's what intestate means. You died and you never made a will. Go down to the next line, and at the end of the line, we're going to highlight testate. Means that you had prepared a will. So testate, you have a will. Intestate, you don't. Then we're going to highlight the first sentence under probate. Probate, although my definition here on this slide is a lot better. Probate is a court proceeding that determines who the heirs are and what the assets of an estate are after all debts have been paid, and distributes what's left over to their heirs or those named in a will. Okay. So you got that one, but you know, I have that one slide that I created myself. This one has those definitions a little bit better. Probate is a court proceeding that determines who the heirs of an estate are and what the assets are after all debts have been paid, no matter if you had a will or not. Boom. That definition is better than these other slides. This is my custom one. Should probably delete some of these crappy slides. Intestate and probate. Intestate, probate. And you know what? Delete. Can't delete it that easy. Delete. Delete. Transferred part of by descent. Rise. We'll leave that up there. Alienation title. All right. So let me read a little bit about this though. So probate is the court proceeding that whether you had a will or not, your estate needs to be probated to determine who the heirs are and what your assets are after all your debts have been paid, including your taxes or any debts that you may owe to somebody. Either an executor or an executrix, that's the female who made a will, that's named in a will, or an administrator named by a court. If no executor was named and there is no valid will, would oversee administration of that, the distribution of your assets. Now, if we turn the page, transfer of title by a will. A last will and testament. No, I don't have that on this slide, but there we go. Page 242. Yeah, I'll split some of these definitions up among two slides. But a last will and testament, what is that? That's a document that you create to determine or to state all your final wishes, you know. Who's going to take, who you want to take care of your children when you die, if your spouse is not still alive, or if they're not alive, or they're not your spouse no more, or, you know, it goes over all the different scenarios, the will, what your assets are, who you want to get them, These are all things that you would state in a will. You could also have a living will section that's added to it. In the event that you get into an accident and you're brain dead, who are you going to give control over whether they're going to pull the plug or not? You know, these are all things that you would put into a will. Where do you want to be buried? Do you want to get cremated or not? You know, these are all things to discuss in a will. So highlight, a last will and testament is an instrument made by an owner to voluntarily convey title to the owner's property after their death. How do you transfer ownership while you're alive? What's the document that's used?
A deed?
A deed. But when you die, the deed is no longer valid. You transfer ownership after you're dead by your will. But the will, even though I could name in the will that you're going to inherit my property, if I'm still alive, I could still sell that property and transfer it by deed, right? Then so this is why you should update your will every now and then. Because if you have something stated in a will that I was leaving you the house, but I sold the house already, you inherit nothing, right? So a party who makes a will is known as a testator, or if you're a female, you're called a testatrix. The gift of real or personal property by will is known as devise, and a person who receives real property by will is known as a devisee. A gift of money or other personal property is a legacy or bequests. You may have heard these terms in movies before, where somebody's reading a will and they're like, I bequeath to thee the vast fortune in my bank account of $4, right? So a legacy is the things that you leave behind when you die. A bequest is your wishes. Who do you want to get them? Right? And the person receiving the personal property is a legatee. You don't need to know that one. Okay, so highlight, I put a highlighted box around that whole paragraph, but don't worry about the legatee one. You know, testator, testatrix, devise. All right. Here's an interesting thing. Now we're going to get into the interesting stuff. Ready? In New Jersey, children can be disinherited. Ooh, you want to find out who inherits your stuff if you don't have a will? It works like this. In New Jersey, children can be disinherited, so be good to your parents. But a surviving spouse is entitled to at least 1/3 of the estate. What? You know you can't write your spouse out of the will? If you're married, you cannot write your spouse out of the will. If you don't leave them anything, or if you leave them less than 1/3 of the estate, they have something called the right of election. This is a right reserved only for a spouse that they could exercise and say, nah, you know what? Instead of that lesser amount that you left me, I'm going to take a higher amount that the law required that you leave me, 1/3. That's called the right of election. All right. So that right is only reserved for surviving spouse. You don't need to know that for exams. It's just I'm reading it to you now because it's interesting. Now, a will differs from a deed. Why? Because a deed is how you transfer property while you're alive. A will is how you transfer it after you're dead. So when does the transfer of ownership take place when you're alive?
In a will?
No, when you're alive. You have a deed. You transfer a property by deed, right?
Yeah.
At what point does that transfer of ownership take place? Remember, deeds don't need to be dated. So when does the transfer of ownership take place with deeds?
Filed.
Upon delivery and acceptance of the deed itself. That's why the deeds don't need to be dated, and they're not required to be recorded either. It's in your best interest to, but you're not required to. Remember we had that conversation? At what point does the transfer of ownership take place? Upon delivery and acceptance of the deed itself. And the deed needs to be signed by the seller, not by the buyer, and it's still valid. All right. So to be valid, we're going to highlight, to be valid, a deed must be delivered during the lifetime of the grantor. Oh, check this out. You're buying my property. I named you in my deed to be the buyer. I'm the seller. I signed the deed. However, I never got a chance to give it to you because on my way to give it to you, I dropped dead. Had an accident, whatever. I'm dead. But I signed the deed and I named you in it. Are you the owner?
No,
Why?
because you never got a chance to deliver it.
So delivery and acceptance never took place, right?
Right.
So just on the surface, based on what I told you, then you're right. However, let's just say that we had a conversation with our attorney. I had a conversation with you on the phone and we had our attorneys on the phone. And I said that, okay, I signed it. I'm going to be delivering it over there to you in a jiffy. Guess what? You are the owner then. Because now we could prove that there was an implied delivery and acceptance. I signed the deed, but I never physically delivered it, but there's something that could also be referred to as implied delivery and acceptance, because it was my implication through our conversation over the phone with our attorneys that I was going to be running it over to you. Okay, so that starts getting to be a little sticky situation right there. But that actually happened. There was a famous, I forget who it was. I'm not sure. It was one of some famous Motown singer. I forget her name. She got into a situation like that. She was selling the property to somebody and she died before she got to deliver the deed. And her kids claimed all the money that was in the bank account. Her kids were the heirs to the house. However, they said, hey, the deed was never delivered, so we're still the owners, we're the heirs, we get it. Okay, so that was a big argument in court. But the kids were kind of a little bit ignorant on the situation because they tried to play, you know, that they knew the law so that they could keep the house. Well, the guy was like, okay, well, then you don't get to keep all the money in the bank account because some of that was the money I transferred to purchase the house. It's interesting when you see some of these things in live situations, how they play out. All right, now, the parties named in a will have no rights or interests as long as the party who made the will is still alive, because I can make a will leaving you something, but if I'm still alive, you don't get it until after I die, right? That's basically what they're saying. So what are the legal requirements for making a will? I already explained to you that you can have like a software do it, Quicken Will Maker. If you type it up and then I sign it, it requires 2 witnesses. One of the heirs can serve as a witness though, but those signatures should be notarized in a timely manner. And if I completely handwrite the will, it's known as a holographic will and requires no witnesses. Let's go down to transfer of title by descent. You guys want to know who gets your stuff if you die without a will?
The state.
The state.
Well, the state has an obligation. It says, look, escheat. How does escheat work? When you die intestate and no heirs can be located. Let's say that we can locate heirs. Well, first of all, who are your heirs? And then if we locate heirs, who gets your stuff? This is how it works. We're not reading this because it's on exam. We're reading this because it's freaking interesting. Okay. And sometimes people have questions in class about this. So let's do this now. Transfer of title by descent. They call it the laws of descent and distribution. And once again, this only takes place when you die without having a will. Who gets your stuff? Well, I'll start reading at the title to real estate and personal property of a person who dies intestate passes to their heirs. Under the descent statutes, the primary heirs of the deceased are their spouse or civil partner or domestic partner and close blood relatives. Close blood relatives. So when children have been legally adopted, Most states consider them to be heirs of the adopting parents, but not heirs of the ancestors of the adopted parents. So if you're an adopted child, you would inherit from your parents, your adopted parents, but you wouldn't inherit from their relatives, not unless they specifically named you in a will to leave you something. You're not considered to be a blood relative, so you cannot inherit from them unless they specifically wrote you in a will. So in most states, illegitimate children, all right, let's stop there. I got to give you a definition. What is an illegitimate child? It's if your parents were not married when you were born. Let me put it in modern terminology. You guys all watched Game of Thrones, right?
Yeah.
Yeah.
It's the bastard child.
Oh, wow.
All right. So an illegitimate child is a bastard child. Basically, your parents were not married when you were born. All right. It is kind of medieval terminology that they use in legal world, isn't it?
Yeah.
So in most states, illegitimate children inherit from the mother, but they do not inherit from the father, unless he has admitted parentage in writing, or parentage has been established legally in some other manner. They take a blood test or what have you, DNA test. If he legally adopts such a child, that child then would inherit like an adopted child would. That's kind of messed up. Did you follow what I just read there? If your parents were not married when you were born, your blood father, your real legitimate blood father, can adopt you. However, you would inherit from your father, who's your real legitimate blood father, but you would not inherit from your father's side of the family. You would inherit like an adopted child would. That's kind of screwed up, isn't it?
Mm-hmm.
All right.
Weird.
Because you're actually blood relatives, and you still don't inherit like a blood relative because your parents weren't married at the time you were born.
Weird.
Interesting, isn't it? So let's see how it works now. Who gets your stuff? Now, once again, this only works like this when you die without having prepared a will. So on page 343, we're going to read this. The laws of descent come into effect only when the descendant leaves no will. A surviving spouse or partner becomes the sole heir if the descendant leaves no parents or children. If there's a child or children who are also the children of the surviving spouse, the spouse or partner receives the first $50,000 plus 1/2 of the remaining estate. The rest goes to the child or children. If the descendant leaves no parents, or the descendant leaves parents and a spouse, but no children, the spouse or partner receives the first $50,000 plus 1/2 of the remaining estate. The rest goes to the parent or parents. If there's no children, or if there are children who are not the children of the surviving spouse, the spouse or partner receives half the estate, the child or children the other half. Because, we get people, you could be married to somebody, but they already had a kid perhaps from a previous marriage or what have you, right? Or partnership. Now, when no spouse or partner survives, children become sole natural heirs. Where there's neither surviving spouse nor children or their own heirs, the estate first goes to parents, and failing that, to brothers and sisters or their heirs. In default of any other natural heir, grandparents, aunts, uncles, and first cousins can be considered heirs in New Jersey. But beyond that point, the entire estate goes to the state of New Jersey through the process of escheat. So the state treasurer, just highlight the word escheat there. So how does this work? The state treasurer sells the property at a public sale, an auction, giving notice of the publication of that forthcoming sale in the newspaper in Trenton and the county in which the property is located. The proceeds from the sale are held in a fund for 1 year. 1 year. And if no claims are made within that year from any heirs who step forward to claim it, the state keeps it. So I got 2 website links here for you guys down at the bottom of this slide over here. Missingmoney.com. This is a website that's run by the federal government. New Jersey, our governor pulled out of it a couple months ago. For some reason, New Jersey stuff is no longer in there. But you should still search it because you could have stuff that's from national, from the federal government that's in there. Instead, for New Jersey, here's the website you should use to search and see if you may have some money coming due to you through unclaimedproperty.nj.gov. And not just when somebody dies. I want everybody in this class, after class today, to go to these website links. I want you to write it down. And I want you to search your name. Search your relatives' names. I guarantee you at least one person in this class is going to find money. Well, I don't want to guarantee, but usually in every class, we have at least one person that finds money due them. I did this search once before when my dad was still alive, and I found $5 grand for him. He bought a savings CD and he forgot about it. It's a CD that had to mature over a couple of years, out of sight, out of mind. He forgot about it. The bank turned those funds over to the state and it went into missingmoney.com. I searched missingmoney.com and that's where I found it. But New Jersey doesn't use missingmoney.com. We pulled out of it for some reason recently. So you would go to unclaimedproperty.nj.gov to locate it. And so for different things, like for a savings CD, banking stuff will be in there from anywhere from 6 to 10 years. If it's due to somebody dying and leaving the real estate to their heirs or what have you, they have no heirs, it'll stay in a fund for 1 year only. So I had a girl from one of my classes. She found money. She used to work at Hot Topic in the mall, in Woodbridge Mall, I think it was. She used to work at Hot Topic, and her boss never paid her last check. Instead, he turned it over to the state. She found it in Missing Money and she claimed it. Pretty cool. It may be a little bit, but hey, it's missing money. It's found money, right? Money you forgot or didn't know even existed. It may pay for this class and then some. And listen, there's only a 10% finder's fee that I'm charging. I'm kidding. There's no finder's fee. I'd be most grateful though. All right. So write down those 2 links, guys, missingmoney.com and unclaimedproperty.nj.gov. And then let's do the key terms to review after you've done that.
I'm in class right now. Oh, sorry.
Okay. So just write down missingmoney.com if you get a chance there and search it, as well as unclaimedproperty.nj.gov. These are government-run websites. They should not ask you for credit card information. If you're getting asked for credit card information, you are on the wrong website. I had a girl once do that. She typed in missingmoney.com in Google instead of putting it in the search, instead of putting it in the address bar in the browser, she searched it. And when you do a search like that, you come back with those paid ads underneath, and it said missingmoney.com on it, but it took her to some other website and asked her for credit card information and all that. You're on the wrong website. This is a government-run website. It's not going to ask you for any of that. All right. Now, sometimes they'll tell you what it's for or how much money. Sometimes they'll just say on file, and you need to fill out an application, submit your social security number and all that stuff for them to confirm that it's you. And then you could claim the money or asset or whatever is in there. All
How
right?
long is the turnaround?
It's fairly quick. It depends what it's for though. It depends what it's for, but once it's in the state's hands, it's fairly quick. And look, money goes into here for a lot of different reasons. I gave you an example. One girl, she had a job. The boss didn't pay her the last thing. He turned it over to the state. If if you're leasing somewhere, you know, the landlord's supposed to give you your money back, you know, for your security deposits. If they can't, if you didn't leave a forwarding address and the landlord can't keep that money, they would have to turn it over to the state. Some do, some don't. There's for so many things, for bankings, for so many issues that money can go in here. So I suggest that you guys search your name, search your parents' names, search your relatives' names. Somebody's going to find something. I can almost guarantee it. Okay. All right, let's go over the key terms to review. Page 344 or chapter 20, key terms to review. Transfer of title with the grantor's consent.
Voluntary.
Yes, voluntary alienation. 13 is A. Acquiring of property by natural heirs.
What page are we on, by the way? For the
344. It's the key terms to review for chapter 20.
thank you, 344. Let me see.
Acquiring of property by natural heirs.
Descent.
Descent. 3 is B. Court proceeding to establish the validity of a will.
Probate.
Probate. 10 is C. Document disposing of property after one's death.
Testate. The last will and testament.
Last will and testament. 9 is D. Having made a will, having prepared a will.
Testate.
Testate. 11 is E. What do you call the person who makes a will? Testator. 12 is F. Really, if it's a female, it's testatrix, right? One who can inherit.
An heir.
6 is G, an heir. One who receives property through a will.
An heir. Wait, an intestate. No.
Visee.
Devisee. 4 is H. Look, devise is leaving property by will. I'm going to give you a little tip on legal terminology that we're going to go over in chapter 6 too. There's a chart there in chapter 6 that'll tell you this. If you take the root word devise, and we know that devise means to leave property by will. If you put an OR at the end of it, any legal word that ends in the word in the letters OR means that that's the person that's giving whatever the root word is. If it ends in EE, it's the person who's receiving it. Look at the word lease. A lease is the document where an owner intentionally transfers their rights to a tenant for a limited period of time, right? So who is the lessor? The person who gives the lease. That's the landlord. The lessee is the tenant. That's an easy way to remember it. Words end in EE is the person that's receiving the root word. Words that end in OR is the person that's giving the root word. Right? One who receives real property through a will. Is that? Oh, we just did that. Devisee, 4 is H. A person named in a will to administer a descendant's estate.
Administrator.
No.
Executor.
A person who's named in a will to administer the estate is an executor. It's an executor. 5 is I. If a court names somebody to do it, that would be an administrator. Okay.
Administrator.
So title acquired by usage.
Title.
Adverse possession.
2 is J, adverse possession. Transfer of title without the grantor's consent.
Intestate.
Voluntary alienation.
Involuntary alienation. Alienation is a transfer of property. Involuntary is without your permission. You don't want it. 8 is K. Without having prepared a will.
Intestate.
7 is L. And person
I'm sorry,
A,
what was 8? What's the
8 was K. 8 was K.
And
And 7 was L.
Thank
Per-
you.
Person named by the state to administer a descendant's will if they didn't name somebody in the will to be an executor.
Administrator.
An
Administrator.
administrator. One is M. All right. So look at that. We did chapter 20 today too. Boom, 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 boom. Go back to chapter 5. Let me know if anybody found any money or finds any money on those missingmoney.com sites.
I was just on the site too.
Yeah, she already did it.
I'm already on it.
Did you find something?
No, I haven't checked yet. I just pulled it up.
I sent that to my family chat.
Yeah, I mean, I like to hear about if somebody finds stuff, you know. Good for you, you know.
Interestingly enough, my husband came home and told me about a website last night. He found money, but it wasn't, I don't think it was this one. So I don't know. So I don't know.
Well, these
if they
two
have-
are missingmoney.com is run by the federal government and states can opt into it. New Jersey used to be, but our lovely governor pulled out of it a couple months ago. Instead, New Jersey stuff is only on the unclaimedproperty.nj.gov now.
Okay.
Okay. So it'll be one of these two. If you just go to nj.gov, they'll have this link somewhere on that website too, where you could find it. Ooh. All right, let me close out that chapter 20. Buck to there. All right, you see, so that slide, I got this slide in 2 chapters, in chapter 5 and chapter 20. I have this slide in here with all these death terms and stuff. So good slide to study from. You know what, there's something in here that we didn't go over, with dower and courtesy, but that's okay. I think it'll be in chapter 5? No, chapter 6. But either way, here's something. You guys ever hear of a dowry?
Yes.
You know what a dowry is?
Yes.
What's a dowry?
It's what you pay. It's the money you pay a family for marrying their child or something like that.
Isn't that prostitution?
No, because there's a reasoning behind it.
Yeah, sure there is, you know. Yeah, you know, the reasoning is, you know who pays it? Now, this is common in some cultures, actually. What happens is the wife's, the young lady's father or side of the family will pay over to the young man's side of the family. They call it a wedding gift, right? When they get married, okay? Well, why is the wife's side paying the husband's side a gift?
For raising a great woman.
No,
for giving them a good wife.
If that was the case, then the man's side would be paying the wife's side, right?
No.
Instead, what's going on is some young lady's father is paying some young man to please take her away.
Oh, Lord.
But that has nothing to do with dower and courtesy. Dower and courtesy are ancient rights in New Jersey. All right. The dower is the wife's right to half of all of her husband's property that he owned during his lifetime. Courtesy is a similar right that the husband has in the wife's property that she owned during her lifetime. So when your spouse dies, your spouse has rights of interest in all the property that you own, not just the primary marital residence. Now, I said it is an old law. New Jersey abolished the creation of any new dower or courtesy rights on May 28, 1980. So that means if you were married after May 28, 1980, you do not have dower and courtesy rights. However, if you were married before May 28, 1980, your spouse has a right to half of all the property that you own. See, instead now in New Jersey, your spouse only has the rights in the primary marital residence. You can own real estate that your spouse has no interest in, just like you can own a car that your spouse has no interest in. It's your car, not your spouse's, right? You could own an investment property your spouse has no interest in. Now, we got a lot of ladies in this class. When we got a lot of guys in the class, sometimes we come across people who are divorced and it was kind of bitter and they start yelling, "That's bullshit. She got half of everything." I'm like, yeah, you know why? She had a good lawyer. And that's a real answer. That's a legitimate answer. She had a good lawyer. You know why? Because your spouse does not have rights to half of all your property that you own, unless they follow the money. If they could link that you used 1 penny, $1 from that joint marital assets, then your spouse has rights to that property. So if you ever used money from a joint bank account to do repairs or pay a mortgage payment or pay insurance on that property or anything like that, guess what? Your spouse has interest in that property now. That's the way it works, right?
Just a heads up, I found money for my mom.
Awesome.
I found money for my dad.
Awesome. Do you know how much or no?
No, they didn't say.
Yeah, sometimes it discloses, sometimes it don't. Yeah. Yeah, sometimes it'll tell you what it's for and sometimes it doesn't too. But look at that. Boom. What do we have? 2 people, 3 people that found something? Awesome. Let's have a party. All right. So anyway, that's the dower and courtesy rights. We're going to get them in chapter 6, I think, again, but this is just a preview. This slide is great. It's got all these death terms and commonly confused terms that I put together for you. But that one for dower and courtesy, you will see on exams. Dower is the wife's right. Courtesy is the husband's right. When did New Jersey abolish the creation of any new dower courtesy rights? You need to know that date too. New Jersey abolished that creation on May 28, 1980, right? So how do you remember which one is the wife's right and which one is the husband's right? I'm going to tell you an easy way to remember it. Are you ready? Are you ready? Are you ready? You want to hear it?
Yeah.
Ready.
Okay. All right. I just want to make sure you got it. Otherwise, you can study on your own. You know? Okay. So here's the way that I remember, that helps me remember. Look at the word dower. Dower begins with a doe. You know what a doe is?
No.
It's a female deer.
I was gonna say that.
Remember that song? Doe, a deer, a female deer. So that's how I try to remember it, you know? Dower, it begins with doe, and doe is a deer, a female deer. So that's the wife's right. And courtesy, because men are courteous to women, is the husband's right. So that's the way I remember it. Doe, because dower, because it begins with a doe, and a doe is a deer, a female deer. So that's the wife's right. Courtesy, because men are courteous to women, is the husband's right. And then, well, you just need to memorize this date. May 28th, 1980 is, you do need to know that date too. That's the date that New Jersey abolished the creation of any new dower courtesy rights, but any existing ones already in place are still in effect. Okay. Goody. Hopefully that works for you. Land.
Yeah, thank you.
You're welcome. Land. What is land? Ooh. Some people refer to real estate as land, some real estate. They use the 2 terms to describe the same thing, but there is a distinction between the 2. Land is the surface of the earth and includes anything that's on it by permanently on it, attached to it by nature, like water, trees, bushes, all that stuff is considered land. So land refers to the surface of the earth including the water or rights to use the water, and anything permanently attached to it by nature that doesn't have to be planted every year, like trees, bushes, grass, flowers, or crops that are required to be planted every year. Those could be considered personal property, and an owner can take it with them when they move. Anyway, so land is the surface of the earth and everything attached to it by nature, and everything below the surface to the center of the earth, and everything above the surface to infinity and beyond. All right. So this also includes the subsurface rights, the air rights, and the water rights. Okay, so what's the difference between land and real estate? Well, real estate is the same definition of land, plus all man-made improvements. Well, what's an improvement? It could be a structure like a building, but it doesn't have to be. It could be a paved road or sewer pipes running under the property. Those are all man-made. And if they're on the property, guess what? It's no longer land, it's real estate. So basically, real estate is land plus man-made improvements and all the rights, interest, and benefits that go with it. That includes the subsurface rights, air rights, and water rights. So I got this little drawing I made. Obviously, a kindergartner can draw better than I can. All right. So this is supposed to be the surface of the earth. That's not a hand sticking out of the ground. That is a tree. Okay. And that's a bush, and that's grass. Okay. See, I had to write that there. Trees, bushes, and grass. That's the surface of the earth, and all things permanently attached to it by nature, like trees and bushes and grass. Everything beneath the surface to the center of the earth, and everything above it to infinity. All right. Now, because you own everything above the surface of the earth, does that mean that you could prevent planes from flying over your property? No. Unfortunately, you cannot. The Federal Aviation Administration, the FAA, has primary jurisdiction of everything above, I think it's 500 feet above the highest point above the land. 500 feet? Yeah, 500 feet. All right. So here's two ways to describe the definition of real estate. Real estate can be described as land plus man-made improvements plus all the rights, interest, and benefits that go with it. Or another way for saying the same exact thing is land plus man-made improvements and the bundle of rights. Remember the first term that we learned in this chapter, the bundle of rights? Those are all the rights that you get with the ownership. Okay, so this is actually a pretty good slide to study from. I got the definition of land and real estate here together. And guess what? You need to study it, because on both exams, they're going to give you questions where you're going to need to know the difference between land and real estate. Land plus man-made improvements and all the rights, interest, and benefits that go with it. The bundle of rights. Boom. Now we're going to learn about the different types of rights. Well, let's first do some highlighting here. Let's highlight under land. Land can be defined on the second paragraph. Land may be defined as the earth extending downward from the surface to the center of the earth and upward to infinity, including all things permanently attached to it by nature. Underneath it, they have a definition for the word parcel. I don't think you need to know that for exam purposes. So I'm not going to have you highlight it, but it is good to know what the definition of a parcel is, because you hear people sometimes say a parcel of land. Well, what is a parcel of land? It's an area of land that has legally defined boundaries. So a specific tract of land is commonly referred to as a parcel, which can be of any size, but has legally defined boundaries. All right, so there you go. You don't need to study it for exams, but It's good to understand terms.
Can I say something else? This is too much. Hello?
Yeah.
So this is really off topic, but a little bit on topic. My
Mhm.
husband, when he's a New Year's baby,
Mhm.
and he's a twin, and he was the first baby born on New Year's, a few years ago. Well, back when he was born. So he had gotten all like this gift from the state, and he had gotten money, him and his sister. But in whatever happened in their house, they lost all the certificates, the paperwork, the bonds that they gave them. So he just really never got interested in claiming it. I just found it on the side after like 30 years. So
Wow.
After 30 years and you could still claim it. That's interesting.
well, he had that money because I see the name of I
Well,
see his dad's link to it because
Yeah.
that's something that he got from his dad's job too.
Yeah, I mean, it's
So-
possible. There's like I said, in those databases, there's a lot of different things that you could find.
I mean, he's 30, he's gonna be 33, but they gave it to him when he was born. So that's what I'm
Yeah,
saying.
but
And it
still, that's-
matured at a certain time that he was able to
Oh.
take it out.
It
but he
probably
wasn't-
matured, yeah, and then
Yeah.
you're within so many years of that date, so that's probably what's going on. Yeah.
Yeah.
And I was about to say 30 years. That's a long time for something.
No,
You
no,
never know. You never
he
know.
was only able to take it out when he turned a certain age, and then something happened with him and his sister's house, and they lost all the paperwork, and he just didn't want to go through all
You
the
guys got to
trouble.
take me out for a drink. That's all I.
He didn't want to go through all the trouble of finding that paperwork, and now here it is. So,
Boom. There you go. Look at that.
thank you for that.
This class is paying for itself already, huh? I hope so anyway. I don't know how much money it is. I hope it is. All right. So that's not off topic. It's still kind of on topic. We were talking about claiming money there from missing money and such. And I'm
Yeah.
glad that you guys are finding money. Good for you. I'm not a bitter person. I like when people find stuff there.
Well,
Okay.
thank you. Yeah.
You're welcome. So property rights. Oh wait, we have to highlight the real estate definition here still too. So in the second paragraph, we're under real estate. We're going to highlight real estate is defined as the surface of the earth. Highlight that whole sentence. I read it a bunch of times already. Just highlight that sentence. And then underneath where it says all the rights, benefits, and interest in it, also write bundle of rights. Because I'm not sure how it's going to be worded to you on exam. It could be worded both ways. They could say plus all the rights, interest, and benefits, or they could say plus the bundle of rights. You guys ever hear the term tangible before?
Yeah.
Yeah.
And tangible and intangible assets. You know what something is if it's tangible?
Something
You know
you
what that
can in your hand, like something you can physically.
Yeah, it's something you could touch, right? Something you could touch or feel. This is tangible because I could touch it. It's a tangible asset, right? Tangible is anything you could touch. You can also have an intangible asset, which is something you cannot touch, like views or rights. Is there value to having a beautiful ocean view or mountain view or view of the lake, right? Yeah. So, but that's an intangible asset. It's not something you can touch, but it does have value to it. Also, your rights. Do you value your rights? Right? I mean, you can't touch a right, but you have value to them, right? How about this? When you are leasing, when you do not own property, but you lease real estate, what is a lease?
An intangible, right? Yeah, an intangible.
It is an intangible personal property, right? It's an intangible asset that's considered personal property. It is your rights to occupy someone else's property for a limited period of time as defined in the lease. And that's personal to you. So it's personal property. And it's intangible because you can't, it's not, even though you could touch the paper, you could touch the lease. It's what it symbolizes, your rights, and you can't touch your rights. So that's why it's intangible. So now that we know the words tangible and intangible, there's another word for tangible and intangible: corporeal and incorporeal. A corporeal asset is a tangible asset. So we're going to highlight them because I don't know, sometimes they may mix these words up on exam for you if they give them to you. So let's just highlight corporeal tangible asset. And then let's highlight intangible incorporeal assets like views or rights. Like views or rights. All right. All right, so subsurface rights. Well, what surface are they talking about?
The Earth's surface.
The Earth's surface, correct. So subsurface is anything below the surface of the Earth.
Like oil, gas.
Well, it could just be the space below the surface, but it could also include any minerals that are in the ground or below the surface, right? Like oil, gas, diamonds, gold, silver, coal, or anything else, other minerals, right? Beneath the surface. Now, if you have rights to real estate, check this out. Did you know that you can sell the real estate that you own, but keep the rights to what's in the ground or below the Earth's surface or above it? You could keep rights to the land, but you don't own it anymore.
Do you just specify it in the deed or?
Here, yep, it has to be specified in the deed somehow. Look, I had a girl in one of my classes one time. She moved here from Texas. This is a common thing that they do there. She sold the property that she owned and she retained the mineral rights to the oil in the ground.
Money.
So she doesn't own real estate in Texas anymore. She lives in New Jersey, but she has the rights to the oil under that parcel of ground, if there's any.
Wow.
Now, it's one thing to have rights to something that's in the ground. It's another thing to be able to explore and extract it from the ground, right? So those contracts have to have something written in them that would give her the right to be able to dig or drill in order to get the oil out of the ground on someone else's property, right? Now, the guy who bought the property had to agree to those terms when they bought it, and she had to make that known that at the time they made the agreement, not last minute, but the time that they went into the contract, that she was going to keep those mineral rights. Now, she could also, so what she ended up doing is she sold the property, she retained the mineral rights to the oil with a further agreement that she's allowed to explore on the property to extract the minerals from the ground. So she hired an oil exploration company that they searched the ground, they found oil, they drilled, they found oil. Now, she said they didn't hit the mother lode, but she's getting a check from them every month that's enough to make the mortgage payment on her and her mother's house. Wow. Not a bad deal for a property you don't own anymore, huh? Right. I'm just trying to paint a picture now to expand your minds a little bit, because a lot of times people think when you own real estate, you either own it or you don't.
Yeah.
But you do have rights. Now, rights are not real estate. You do not own real estate. You only have rights to use it or to extract something from it. How about this? If I own land, I could keep all the mineral rights to it. The gas, the oil, the diamonds, the silver, whatever. I could give one person the oil, another person the diamonds. I could lease out those rights or sell them individually to people as well. And that also goes for air rights. Everything above so many feet above the ground, I could keep the air rights to. So if I were to do that and you wanted to put an addition on the house, but I own something, everything above a certain height, you wouldn't be able to do it unless you bought my air rights or leased them from me.
Right.
Let's talk about this one a little bit. The rights to use the air above the land and may also be sold, leased independently of the land beneath it, such as the air rights over railroads to construct office buildings like Grand Central Station in New York City, or Yeah, what is that? The MetLife building is above that? Grand Central Station, is that Grand Central? Yeah, Grand Central Station has the MetLife building above it. So that's not a good picture of it, but here's a good idea. Actually, that land, you know what? Let me go to the whiteboard for a second. I'm better off drawing you a picture of it.
That makes sense.
It's an interesting concept, especially in New York. It varies from city to city, the air rights, because your municipality determines the rights of the property and the building and zoning and all that stuff. That's all determined by your municipality. Oh, let me close this and try to open this again. So you could keep the air rights independent of the land itself. So you could sell the property. You could have one person of the owner of the land, another person who owns the subsurface rights for what's beneath the surface of the land, and another person who has the air rights above it. On Grand Central Station, this image that I was showing you in that slide, while this thing tries to open still, you see this slide here? Let's see, this is the land, okay? This is the surface of the earth right here. This line right here is the surface of the earth. In yellow, this is everything below the surface, the subsurface. That's where the railroad station is, Grand Central Station. There's a building that's hovering above it, but buildings don't hover above the ground. They have to be supported somehow. So this one has these foundational supports that are in the ground. They don't just sit on top of the ground. They actually get sunk in below the surface of the earth. So the person who owns the air rights here was able to construct a huge office building with only owning small pieces of land, which they would construct their foundational supports. And then they have this building above someone else's building.
Oh, wow.
This in blue here is the one person owns this land and they have buildings on the land. The person has the air rights, owns small pieces of land that have these foundational supports. And this huge high-rise building is sitting on that.
Wow.
So this is what happens when you're in an urban area where space is at a premium, right? You can't build out, you got to build up, right? So that's what they did here. This is how you fully utilize it. And look, we got 3 different owners here. One owner of the subway, another owner of the land, another owner of the air rights. Interesting concept, right? Kind of opens your mind up to the idea of this a little bit. Did the whiteboard open? Okay, there we go. Whiteboard's open. Now let me clear it off. Want to show you a couple more ideas. Clear the canvas. We're actually kind of done here with the time, but let me just draw this picture for you really quick. Just show you. So in New York City, we got all these high-rise buildings in New York City, right? They're all over the place. High-rise buildings, right? Now that's a common tower with that weird roof. We know which one that is, right? So we got all these buildings throughout New York City. And if you own the air rights, I'm going to show you how they could be very valuable. All right, so you got a bunch of owners of these different properties in New York City. New York City is a unique animal. It doesn't work that way. It works on a city by city basis. It doesn't work this way throughout the whole state of New York. All right, this is just to give you an example of air rights. I just gave you one example with the train station and the air rights and somebody owning the land separately. Here's another example. Years ago, there was an actual developer in New York, and he built a lot of properties. And what he started doing is this was the first property that he built on his own. And he managed to go to all the building owners around them and ask them if they would sell him the air rights to the land, to the air above their buildings.
Who was that?
That sounds like an odd thing to do, doesn't it? I'll tell you in a sec. It's an odd thing to do. And people started looking at this and saying, wait a minute, this actually became a national story. This was in newspapers and magazines. They're like, this guy has got to be so rich. He don't know what the hell to do with his money. He wants to buy the air above our building. We're not going to allow you to build on top of our building. He's like, no, I don't want to. I just want to buy the air rights above it. But you can't use them. He's like, let me worry about that. I know I'm not going to build anything on top of your building. If you have no plans to build your building higher, can I buy your air rights? So this became a national story. He started going around to all these building owners and buying their air rights up. Some people were speculating in the media that this guy is just so full of himself. He doesn't want this building that he got. He don't want it obstructing his penthouse views. So he wants to buy the air rights from all the buildings around it. All right. He was like, whatever, believe what you want, say what you want. Now, this guy was a developer. He was planning on building more buildings in the area. And the way that it works in New York is that if the city limits that you can only build so high, and you own the air rights from one building over here, you could actually transfer these air rights to this building so that you could build it that much higher.
Really? That's weird. Because wouldn't they have those laws like for safety reasons?
That's the way it works in New York. I told you, it's a strange animal. There are so few real estate agents that actually know the laws because it's quite complicated stuff. I seen a documentary on this. I could try to post it on our Facebook page when I get out of Facebook jail. I could post, there's a documentary on this, this fact of, there's this one guy who's a real estate expert. This is what he specializes in now. But back then, this was unheard of. Nobody ever heard of such a thing, but yet it was a thing. And this developer ended up getting very rich off of doing this stuff.
It's crazy.
And that's who it was.
I knew it was Trump.
He got, I mean, it sounds like crazy. I mean, there's been so many stories written over this guy. He's done some wacky crap over the years, but I tell you what, some of this stuff is genius. You know, people were mocking him over this. This was like in the late 70s, early 80s. They were mocking him over this stuff.
Yeah, there was a movie, I forget the name of the movie, but it was a showgirl. It had Cher in it.
Uh-huh.
And they wanted to buy Cher's building, and she couldn't afford to keep the building because the guy was overbidding her. So what one of her girls that was working for her, what she did was she bought the air rights because the guy wanted to build a high-rise apartment. Yep. So because she bought the air rights, he couldn't build. Even if he bought the building, it would still have to remain the same size because she bought the air rights above it.
Or she could have just sold the building. If she already owned the building, she could have sold the building and kept the air rights.
And that's what happened. I think that's what happened. He was buying the building from her. Well, she was losing it.
Yep.
And they wanted to buy the building. And she was like, she wanted to keep it or at least rent because of the, you know, the girls, that's where they worked. And, you know, they were going to lose their jobs. So one of the workers, the dancers, she bought the air rights over the building. So the guy couldn't even build higher. So he just left the building alone.
Uh-huh. And the best part about it is, do you own real estate when you have rights?
Yeah. Wait.
I think so because
you only have rights. So to the air rights or subsurface, you have rights, but you do not have an ownership in the real estate. But you can limit people who have the real estate because they can't build any higher because you own the air rights, right? So the great part about it is you don't pay taxes for air.
Oh, see, that's how he got over. That's how Trump is getting over.
Okay. Well, when you well, the thing is, he's a developer, so he builds the property. And the thing is, if the city limits how high he could build, because you're limited on space, you got to build higher. If he already owns air rights that he bought out from people, he could transfer it over, build that building that much higher, like in this example over here, and boom, money, 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 right?
And
'Cause
now
you-
these
if
people
you-
that built higher have to pay him for
No,
his
they
air-
cannot build higher unless they buy the air rights back from him or lease them from him.
Now can he charge them taxes?
Well,
Even
no,
though
no,
he
the city charges him taxes, but he owns the rights. He could say that, no, you can't build up any higher because now you're in my airspace. You would
yeah,
have
and
to,
he's
you would have to
selfish like that. So
you know?
he probably, I want to be the tallest building right here.
There's a lot of people that want to do this. They just don't know how to. I think there's one real estate agent in New York City right now that's the go-to guy that specializes in air rights. You know, I don't think Trump is doing any consultation to teach people this, but there's one real estate guy out there who does this, and he makes a lot of money because air rights can be valuable. And is it a tangible asset or an intangible asset?
A tangible asset.
Intangible. You can't touch the air.
Oh, wow.
But you know what, guys? We're actually done for the day, so we'll actually leave off right here. I don't want to get into water rights. I'm going to launch the afternoon poll here. We actually went like 15 minutes over today, so I'll bid you adieu right here.